Right. My lord, court is muted, my lord. Sorry.
Page 23.
Referred for mediation before the trial court. All possibility of settlement.
Respondent is
When it can be taken up?
On 31,
On 31st, it is posted. Let's this matter on 23rd of October.
23rd.
Yes.
Page number 5, serial number 24 to 31.
Serial number 29, my lord. Matter is settled and it can be referred for tomorrow. I'll keep the parties present. We have filed the mutual divorce also.
Tomorrow. At the request of
Petitioner.
Page number 6, serial number 32 to 32, 33. List number 2. Page number 2, serial number 4, 5. Page number 3, serial number 5 to 9.
Serial number 9. Because today I am paying a DD of 45,000 as maintenance. We will file calculation number. Serial number
MFA,
9.
What is the DD?
DD of rupees 45,000 rupees as ordered by this case.
MFA.
No, RPFC.
RPFC is in list number 3, sir.
List number 3.
This is list number 2.
2.
Yes.
Sorry.
Yes.
Page number 4, page number 5, serial number 10.
Serial
12,
my lord, serial number 10, my lord. Serial number 10, my lord.
Yes.
My lord, I inform the other side also. I seek a short accommodation, my lord. Personal inconvenient.
This is the matter on somewhere in the month of November.
Serial number 12, my lord.
Page number,
Serial number 13.
Insurance company disputed the age of the deceased, my lord. Records is required. Age of the deceased is disputed by the insurance company. Records is required.
If records are required, it's coming up for admission. We'll admit and call for the TCR.
12.
It's coming up for admission.
Yes.
Admit and call for the TCR.
Please,
The
please.
matter be called.
Serial number 13.
page number 5, serial number 13 to 17.
My lord,
Another
13.
connected
Serial
appeal
number
is there,
13.
What is the connected appeal?
Photo 86 of 22.
Give that.
Serial number 13, my lord. Connected appeal is before division bench, my lord. Death case, my lord. It is here injured case is
So
posted,
let
my
this
lord.
also go before the division bench. It is submitted that there is a
MF
connected matter. MFA number so and so.
MFA 4286 of
Write on a
2022.
paper and give on so and so, which is pending before the division bench. Registry is directed to place this matter also before the division bench along with so and so. Yes, next.
My lord, serial number 15, my lord, 15.
Yes.
Kindly call next week, my lord. We have disputed the very involvement of the vehicle. It's a case of self-fall.
Where is, have you informed Mr. Maheshwarappa?
MV
I'll inform, my lord. I'll inform, my lord.
Not will inform. Well, please wait till the matter is called.
Page number
Yes.
My lord,
7.
right now I'll inform, my lord.
Not right now. We will not adjourn and then not inform. You have to inform first. Yes.
Page number 7, serial number 18 to 22. Page number 8, serial number 23. List number 3. Page number 2, serial number 3 to 7.
Serial number 5, my lord, sir. Next week, my lord. Serial number 5. I will appear for the petition in this case.
2019 matter we will not at all adjourn.
Because suddenly
Yes.
comes.
Page
Yes.
number 3, serial number 8 to 11. List number 4.
Serial number 3, that is RPFC.
Yes, sir.
Yes,
it is.
RPFC.
RPFC
No,
245.
all these paying the amount and everything, it can't be done at the time of mentioning.
No, I have mentioned, I already submitted the copies also for calculation.
I have to
I will
record.
file it in the office.
The file has to come. I have to record. It can't be done during the mentioning time. Yes, next.
Please.
List number 4 for referring to Lok Adalat matters. 1 and 2 are in dismissal caption.
Anyhow, let it be. First refer to the Lok Adalat. Next, what about 4?
4, furnishing of PF fund. Memo called
HDFC, Ergo General Insurance.
HDFC.
B. Pradeep.
Who appear? Pradeep appear. 4, Mr. B. Pradeep is directed to take notice.
per order.
Memo, next memo is filed seeking dispensation of notice to R2, dispensed with. Then refer to the Lok Adalat.
Yes, ma'am.
Then any other, all other matters are referred to.
Serial
Lok
number 5,
Adalat.
my
Well, serial number 12, my lord. Serial number 12.
Yes,
My lord,
Yes.
serial number 12, my lord. My lord, I produce these income tax returns. They are not ready to accept. Several times it is discussed, so it may be referred back.
delete from the list and post in the usual course.
My lord, serial number 10, for the respondent, respondent is disputing the ownership of the vehicle, my lord. So it will be contested. There is no option of.
Delete.
serial number 5, liability is on question, my lord. Liability is on question, my lord. Serial number 5.
Number 5.
Please.
This also delete. Post in the usual course. Yes.
Remaining matter referred to Lok Adalat. List number 1,
Lord,
part
I
matter,
mentioned,
serial
my
number.
lords, interim order is there, my lords, in that matter.
Wherever interim order is there, they will extend. Yes, call the list.
List number 1, part matter, serial number 1, Zamir Pasha for petitioner.
Please, my lord.
Dilraj Joint.
That's WP 19496, my lord.
19557.
But this is arising out of the impugn order wherein Lord interim maintenance was granted by the family court. Lords, please see the affidavit of the.
What is the amount? What is impugned order? How much is granted?
My income in my affidavit.
Switch on the mic. Yes.
Lord, in my affidavit, my income is declared
As to how much is granted?
60,000 is granted.
60,000 is granted.
My
What is the next writ petition? WP 7808.
that is, Lord, from the G&W proceedings.
What is that?
Lord, that is with regard to Lord the enhancement of the visiting rights. Lord, unfortunately, since the day of this order, Lord, she is not allowing me to meet my children. It's been nearly 2 years since I have met them.
Sir,
Is it so that the father is not meeting the mother is not permitting the father to meet the child?
Lord, I must mention one more thing.
Yes.
Few months back, my lord, the father of the petitioner herein was ill, my lord. He requested the children to visit him. My lord, children were not ready. Then, my lord, the respondent's father persuaded them, convinced them, my lord, and sent them. They were there for 2 days. Thereafter, my lord, they came to Bangalore. They visited. My lord, whereas this petitioner, my lord, from the date of this order, never made a single call, never attempted to meet the children. My lord, all these things have happened. My lord, the submission what has been made from the other side, my lord, is wrong.
Come to the order. First writ petition.
Please. Lord, order impugn is in page
Come
12.
to the, come to the reasoning part.
Reasoning is in Lord page 22. Para 16, Lord. I read, Lord.
Read.
Here in the present case, respondent himself had stated that he is a director of so-and-so. On the other hand, the petitioner had also produced some photographs to make out the standard of living of the respondent where he was with the petitioners. Further, he had also produced photographs with regard to the company of the respondent and their companies all over India and their sufficient companies. And even there are so-and-so buses. Hence, taking into consideration the source of income of the respondent as petitioner number 1 now stays separately with her children, she has to bear the
Did
expenses.
you file your statement of assets and liabilities?
Yes, I have filed. Lord.
As per that, what is your income?
My income, Lord, I have declared it 61,000. Lord, your lordship will.
All the documents that are required as per the judgment are filed or not?
Lord, I have submitted.
What
Please see the affidavit, Lord, for a moment. Please see the affidavit of the petitioner, respondent, in page 58.
Yes.
I'm sorry, not 50, 45, Lord. Page 45, I'm sorry.
Yes.
Lord, this is the affidavit of assets and liabilities of the respondent.
45 is the affidavit.
45 is the affidavit of the respondent. Lord, please see this.
Which one?
This affidavit, Lord, first it is.
Paragraph.
Lord, entire affidavit, not in the format, Lord, enunciated in Rajneesh versus Neha. 1. Number 2, no documents are enclosed to substantiate or even to show, Lord, any information furnished in this affidavit is forthcoming or supported by any of the document. See the exaggerated figures. Turn to page 48, please. Lord, she says in page 48, Lord, point number 25. Point 25, loan obtained as follows. The petitioner has borrowed huge sum of money from friends and relatives for her day-to-day life, and she requires to repay 50 lakhs. Lord, anyone borrows 50 lakhs?
What is the age of the child?
Lord, the children now at present, son is 15 and daughter is 13. But this is the exaggerated affidavit. Nonetheless, Lord, no document is submitted.
What document?
Lord, nothing to substantiate
Let's not
this.
take that 50 lakhs into
Yes,
consideration.
hypothetically.
Let's not take
Oh,
it.
Lord, please turn to my affidavit.
No, you have two children,
Yes.
school-going children, who are 15 and 13 years old.
Yes.
What would be then the school expense?
Now, Lord, school is owned by the petitioner's father. I mean, respondent's father. It is their own school.
So, you will not pay, you will not take care of the maintenance.
I'm not saying that. I'm only
It doesn't
putting it
matter.
like,
Whatever is the fees of that school, your contribution, half of it you should make.
Lord, there is no fees paid with them. It is their own school.
Let
This is
it
what
be,
is
let
my
it be.
submission.
That's your responsibility to take care.
And Lord, they're staying in their own house. It is very affluent family. Lord, it is also the not disputed by the respondent wife. Lord, own school, own house, lavish lifestyle, everything at her disposal.
So
She is,
that's
Lord, my
any
respect.
judgment say that wife's father is
And
wife's
Lord-
father is having sufficient amount, then
But-
the father has no, husband has no responsibility to maintain
No, I
the
would
wife
not, I
and
would
the
not,
children.
Lord, I would not place my submission on that. Lord, but please appreciate this. Lord, the marriage is of 2008. We have two children. Lord, this problem emerged because of the infidelity of the respondent. Lord, in the guise of attending some coaching classes, she used to take money and leave the matrimonial house. The matrimonial domicile was in Sivakasi. She used to say, Lord, she has some classes to attend in Bangalore. Leave the children with the petitioner husband.
So that all that we can't.
And
do
Lord,
right now.
Lord, please see, this is very serious because this problem entirely has come out from this because of the infidelity.
As you understand, what is the scope of this writ petition about the character and
Lord,
other
therefore,
things?
Lord, your lordship recollect, I had filed one more writ petition which is pending, Lord, arising out of the MC proceeding. Lord, that was filed after we came to know about her infidelity. And Lord, she was asked about it. She admitted, and then she left the matrimonial house. It was not that we sent her out. And then, Lord,
Not be decided in this application. Please only address your arguments as far as the quantum of maintenance is concerned.
quantum, Lord, my affidavit, Lord, I have declared honestly
Where are
that
your bank statements for the last 3 years as per the judgment?
that is submitted in family court.
What is the, what is
This is the
balance
income as per the affidavit. I have not suppressed
in the bank accounts?
that. Not precise figure at present. Right now, I do not have.
To have the documents?
My lord, no documents, my lord.
Now, the court has assumed something basing on some assertions, some photographs. That's not the way we calculate
Yes,
the
madam.
maintenance. So, as per the judgment of Rajesh versus Neha, whether he has filed all the documents or not. If he has filed, as per those documents, what is the income of the husband? That's the only thing we can look into.
My lord,
Nothing else.
as per the assets and liabilities, it has been mentioned, my lord, 61,000. My lord, blindfolding the pigeon, my lord, doesn't mean that, my lord, cat disappeared. But he is owning 27 firecracker companies, factories. Apart from that, charcoal factory, school.
Have you filed the bank statement of the company where you are a partner?
I have submitted, Lord. My instructions have
File all that. We'll see, and basing on that, not on the photographs, we will not grant maintenance.
And moreover, the 60,000, my lord, what has been awarded at page number 23,
We will see.
order,
Less is
petitioners number 1 to 3.
Less is
For 3,
smarter.
it is 60,000, 20,000 each.
Smarter on
Lord, in the
that.
meantime, may I make one request? Lord, let them allow to meet my children at least.
We are, I have
Now,
not
the
restricted.
most
I have not
unfortunate,
restricted.
You're
the
not
most,
coming.
Lord, the most unfortunate thing is 1.5 years back, I met them last. And Lord, at that time,
Come. This weekend, the father is permitted to meet the children on, what is today's date? 9, on 14th September, between 10 to 2.
One submission, my lord. Children are not ready to meet him because during the subsistence of marriage, he has married one more girl and fathered a child.
it's a new
Then
thing.
why-
They are not small children. They are not small children, 15 and 13 years.
Let them also not have the maintenance from the father, if that's the case.
No, that is different issue, my lord.
Maintenance, but you don't
That
want
is
to see
different.
the father.
Children are not willing because of this, the
That
character.
also will be, that also will
No,
be
let
considered.
him come. I have not restricted my children. Children are not going there and
So
meet him.
that's how it will not, on that they shall meet. Let's this matter on 20, what is the date I've given? Not 15, 23rd,
23rd, Lord.
yes.
Please.
Serial number 2, K.R. Lingaraj for petitioner. Somshekhar
Petitioner, my
K.M.
lord.
Why is it adjourned?
My lord, other side not appear, my lord. Sorry.
have not appeared.
It's a case where, my lord, the wife filed petition for conjugal rights, my lord, wherein application has been made for maintenance. The family court dismissed the application without granting any maintenance.
Hmm.
Lord,
On the
only
ground?
on the main ground is, my lord,
Please
for
come to
not
that order.
producing the bank details, my lord. On earlier occasion, my lord has directed me to produce the bank statements. I produce along with memo before this court, my lord. The statements are
Though the petitioner claims that she is getting salary of rupees 16,000, she did not opt to produce any document to substantiate her contention, including her salary particulars and bank statement.
I produced the bank statement before this court,
As
my
per
lord.
that, what is the amount?
Lord, there is no money in the bank statement, my lord. There is no bank balance, my lord. The only transaction,
Be an entry, you are getting 15,000 per month.
my lord, I am getting, earlier I am getting 16,000.
Where is
Now,
that? At least
now,
show that entry.
now I am not working, my lord. Now I left the job, my lord.
Why?
Presently I am not.
Why
I'm
you
not,
left the job?
I am not health issues, my lord. I am not, health is not permitting to do the work, my lord. That is the reason.
What is the, where are the medical records to show that your health is not permitting and that's why you have stopped the job?
She's suffering, my lord, back pain, my lord. She take treatment from doctor, my lord.
I asked you from these statements, please show where is that 15,000 that is credited to your account.
Page number is 17. My lord, page number 152 of the memo, my lord. Page 152, bank statement on
Yes. I'm looking at it.
please, my lord. I'm drawing 15,000. That is the, my lord, page 55, my lord, on the bank statement. Up.
No, you have given some running page numbers to the bank account, 152.
155, my lord. HDFC Bank, page number 7.
155. Where is the entry for that 15,000?
15,000, my lord. That is in first row, my lord. 15.
There would be a date for it.
31/7/25, my lord.
31?
7/25. 31.
That's the only entry. That's the only entry.
$15,000. Okay.
That's the only entry.
ಬೇರೆ entry ಎಲ್ಲಿದೆ?
So that means this is not your bank account. There is some other bank account is there.
No, my lord, I produce both the bank accounts, my lord.
Then where are the entries for your income?
ಯಾವ bank account ಹೋಗ್ತಾರೆ?
So as far as this HDFC Bank is concerned,
Please, my lord.
until 139, no entries of your salary, except that 15,000 once you have shown one entry.
There on 7/4, my lord, 25,000 is there, my lord. In 7/4, in page number 1,
Is 15,000 by
141.
25,000.
15,000, no.
That is from whom? Because 25,000 entry is there, we can't take it as a
That is
salary.
incentive, 25,000 incentive. My lord, undoubtedly, my lord, I submit that I am getting 16,000 salary. That is 16,000 rupees salary.
But where
My
is
lord,
the entry? There should be some more from where you are getting the salary. That's why court has rightly dismissed your application. Why should we consider now?
my lord, by assuming that, my lord, I am getting,
Assume anything.
my lord, I am getting 16,000 salary.
We will not assume
My
anything.
lord, for a
We
moment,
have to be,
for a moment, my lord, I am lost my father at the young age. My father and my mother and me survive on the 11,000 pension by my father's pension, my lord.
cannot,
My lord,
we
see,
can
my
only
lord,
look at the problem.
my lord, I am become failed student. I am become failed student, my lord. After drawn out from the matrimonial house, my lord, I separately taken the house. Now I separately leaving the house. I am paying 9,000 rent to that.
You understand the orders from the court. Court will not pass orders from the emotions.
But
There are
my lord, I am not getting under motion, my lord. But earlier I am getting 15,000, my lord. Now,
Where
now
is that? That I want to see. Let her show that. That's precisely the reason why the court had dismissed her. By the time this application is filed, she should have filed. I'll set aside this order. Whatever you want to place before the
my lord,
court, let the place consider.
re-agitate, my lord.
Yes.
I will produce it in class. And also, my lord, direction, my
I'll make it very clear that if she doesn't come out with all the relevant
Please,
documents
my lord, please,
as
my
per
lord.
the judgment of Rajesh versus
Please,
Neha,
my lord, please.
court shall not consider.
Please, my
That
lord.
also I'll make sure.
Please, please.
Because this is not the way how you want a relief from the court, but you want to suppress everything. Please come. Agreed with the orders passed in. I number 2 in MC number 476 of 2023, dated 6 November 2024, whereby the court had dismissed an application that's filed by the wife seeking maintenance. The wife is before this court. The wife had filed the IA seeking maintenance of 35,000 for her maintenance during the pendency of the proceedings. The court has dismissed the same, observing that the facts declared by the wife in her affidavit of assets and liabilities shows that she is employed. She is working in the account section of Mrs. Aya Sri Brand Private Limited. Though she claims that she is getting salary of 16,000, she did not opt to produce any document to substantiate her contention, including her salary particulars and bank statement.
At present, she is not working.
The petitioner is a BCom graduate. We are not about the present. We are about on the day when you have filed the petition. The petitioner is a BCom graduate, and the records placed before the court shows that she is employed and she is having independent source of income. Non-production of her up-to-date bank statement, affidavits of assets and liabilities shows that she is having her own income and she is capable of maintaining herself. The wife withholding her bank statement, her salary particulars, failed to establish that she is depending upon the respondent and she is not in a position to maintain herself, and accordingly dismiss the petition. When counsel for the petitioner submits that now she lost her job, it is submitted that on health grounds. Nothing has been on health grounds. It is submitted that now she is depending upon her she and her mother, depending upon the pension she is receiving, that is in an amount of rupees 7,000. And the husband has an obligation to maintain the wife. It is submitted that the bank statements are placed before the court. Next, as such, the court may grant the interim maintenance to the wife. Next para, when counsel appearing for the respondent submits that withholding the crucial documents and not filing the documents as per the judgment of Honorable Apex Court and versus Rajesh versus Neha, court had rightly taken an adverse inference and rightly dismissed the IA, and there are no grounds to interfere. Next para, having heard the learned counsel on either side peruse the material on record. When the wife has filed an application seeking interim maintenance, in the light of the settled law as laid down by the Honorable Apex Court in Rajneesh versus Neha, there is a protocol of all what has to be filed, how the application, what all the details an application should contain, and what are the supporting documents. In each and every case, though the parties as they're represented by the advocates are aware of the judgment of the Apex Court, in spite of the same, for the good reasons known to them, they're withholding some of the documents. The judgment makes it clear that clear that if any of the documents as stipulated in the said judgment are not filed, an adverse inference has to be drawn, and rightly the court had drawn the adverse inference. When the bank statement is filed before the court, when the wife is saying that she is having 16,000 income, in none of the entries 16,000 is mentioned, drawing the attention of the court to some entry of 25,000 and another entry of 15,000. It is mentioned that it is incentive at a salary, which is not acceptable, and this court cannot consider. On the face of it, it appears that there is an intention on the part of the wife to withhold these documents. Learned counsel submits that she has financial difficulties and she requires maintenance. Considering all these aspects and also balancing the interest of parties, this court deems it appropriate to set aside this order and remand the matter to the trial court, to the family court for fresh consideration. Accordingly, this court is passing the following order. The order dated so and so is set aside and the matter is remanded back. Within 10 days from the date of receipt of the copy of the order, the wife and husband shall file their respective statement of assets and liabilities as per the judgment of the Apex Court in Rajneesh versus Neha. Next point. If the wife fails to file any document as per the judgment, the court shall not consider her application, and on the mere checklist that if she has not filed, the application shall be dismissed on that ground. Next, the court shall dispose of the matter within 1 month from the date of filing of the statement of assets and liabilities. Yes, next. Huh? Yes.
Cell number 3 for dismissal.
There is a chances of settlement. Settlement talking is going on.
ಸೆಟಲ್ಮೆಂಟ್ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮೀಡಿಯೇಷನ್ ರೆಫರ್ ಆಗಿದೆ.
It's a writ petition. Why should whatever settlement that goes on, let it go on before the trial court. Your MC is pending.
Once MC is settled, we will going to withdraw this. There is a chance of settlement. Kindly have it on 16th. Once MC is closed, we will going to withdraw this matter.
This is matter on 16th. It is submitted that the likelihood of settlement, whether the matter is settled or not. If the matter is not settled, that day the parties shall go ahead with the arguments. Yes, next. Delete. Yes, 4.
Cell number 4 for
That's
orders.
serial number 4. I appear for Union of India. It's a
Writ petition.
the issue is that respondents 1 and 2, husband and wife, they filed a divorce petition. They sought some documents summoned from the ROC. ROC filed a memo stating that there is a procedure for issuing certificate copies. You have to make an application. You have to pay the prescribed fee. Then learned, the family court judge wrote a letter, ministerial letter, saying that you furnish the documents and claim the amount. Accordingly, he furnished available documents and claimed 64,000 rupees. Thereafter, again issued the summons. Then I filed an application to recall that summons. Thereafterwards, my lords, what the learned judge did, that is, he refers to the RTA information, RTA Act, and he says per page you have to pay only 2 rupees, not the 10 rupees or 24 rupees, what has been prescribed under the Companies Act. That's how he has reduced 64,000.
Come to the order. Come to the prayer portion. What is that you have sought for?
Yes, ma'am. At page number
Yes.
19, 22.
Yes.
Yes. Pending on the file of so-and-so, other thing.
Setting aside the order.
Order
dated
date 23/7/21.
in MC number.
MC, that's what in MC number it has been filed on the IA.
You didn't mention about the IA.
No, they,
The order in MC has to be set aside.
no. It is actually, well, let's kindly see. Issue a writ of certiorari setting aside the order date 21, annexure T, passed in MC so pending on the file of so-and-so, filed by the petitioners. Second, and direct the respondent to pay jointly and severally. This 21 order is on the summons issued.
Okay, what is 21 order?
21. Kindly see annexure T manners. Page number 163. Let's see. 163.
Looking at the prayer, I thought, how can an order in a MC be set aside by this court?
Maybe I can, that portion maybe I can correct it. On the year, there is no IA. 163 manners.
And you file a writ petition in the year 2022.
Yes.
Till now, you are not taking steps to issue notice.
What transfer matters after filing this, the matter has been settled, it appears. They are not appearing. We don't have any personal knowledge except only one.
Then in that case, either of the parties must have filed an MFA.
No, manners. They have settled the matter. That's what we have been told.
It's an order, it appears. Order dated 23rd July 2021. It is passed on the merits of it.
No, it is based on the memo what I have filed and IA filed. Kindly see the page number 163, Lord. 163, annexure T. 160. May I read, manners? Order on memo dated 13/1/21 filed by Register of Companies Karnataka. Order on memo dated 13/1/21 filed by KG Joseph Jackson so Register of Companies Tamil Nadu.
They have furnished an order.
Yes.
Furnished a
Copies.
address.
Yes.
Address in the cost title. What happened to the earlier notice? And
I think that is the endorsement has to be seen manners that I have been told to furnish a fresh to take fresh steps.
that's what for you have to pay the.
I will pay. That problem over here was, my lads, Register of Companies is a government. You have to search for the. They have changed the address and may need some more time. I got only one address recently of the husband. Wife we don't know because she is not nowhere found in any records. I will get it. Some time may be granted.
You will only send the notices as per the address in the cost title.
No, that has been sent. I have taken steps. Kindly see the earlier steps taken. At the endorsement of.
No, because we can't keep the matter.
That's where, that at least if it is.
There is some procedure or the other, you have to get it served.
Settlement. As far as husband is concerned, I could get the address recently. As a wife is concerned, I am unable to get right now. I have requested the officers to in the Telangana to find out since she is from Hyderabad. It may take some time. If the lordship could.
No, it should have been done long back.
That matter was not listed only last. It came up.
You should know what is
Yes,
happening to your.
I will take necessary steps as far as she is concerned. That may be.
Appearances as before answered was returned with postal shara as respondent 1 and 2 has no such address.
That is the address which has been mentioned in the cost title of the MC and what has been taken. This is the only issue. That's under section 7, Millers, I cannot file the appeal also under section 19 because there is not a jurisdiction of the Learned Family Court to decide this issue. It's very peculiar circumstance under which I have been put in. Some 2 weeks time will be granted. I will take authorized paper public.
2 weeks time is granted, and even the counsel of the petition shall correct the self.
There, what happened? There are 3 more memos and other things. I will correct it according to that. Whatever the.
This is matter after 2 weeks. By the time steps shall be taken.
Serial number 5, Akshita Shetty. For petitioner, Vivek N.
For the petitioner.
Appear for the respondent in this matter.
Not
What is this order?
The cost has been imposed on them for not complying the order
Order,
and addressing the argument.
to
that
file
they
the
have not
affidavit,
filed.
my lords, for assets and liabilities. Even in the trial court, my lords, the assets and liabilities affidavit was not filed at that point of time.
So where is this order for costs?
Please, my lords, on 29,
They have sought an adjournment.
29/10/2024, my lords.
29?
10/2024. What happened, my lords? This honorable court insisted to file the assets and liabilities. In this case, my lords, peculiar case, there was.
Paid?
I'll have to seek instructions, my lords.
What instruction?
I tried to contact the council in Mangalore, whether she has paid the cost to the respondent or not. But apparently, there's a death in their family council. I could not talk to her. So if a week's time is granted, my lord, however, the
29/10/2024 is the order.
please.
This matter has come up on 2011, 9/1, 31, 23/7.
In the due
And you
co-
still would say that I have not, I have to
Yesterday-
find out it is something which is, which the court can't accept.
I understand. Yesterday I contacted, but however, the affidavit has been filed.
As per the order dated
That was to
9/10/2024.
that was to
If the
pay to the
cost-
council, my lord, council of the petitioner order.
That is not what the court said. Then counsel for the respondent seeks time. This is matter on 2011/24, subject to payment of payable by the respondent to the petitioner on the next date of hearing, not the counsel.
The party is Mangalore.
If the order dated 29/10/2024 is not complied with, this court shall not consider any of the contentions of the respondent, and on that ground, the writ petition will be allowed.
Please,
This is matter on 25th of September.
please, ma'am.
Bill number 6,
Yes,
Gautam Raghunath for petitioner. No board only.
memo of retirement filed by advocate Mohan Nadekar is, the same is considered and is permitted to, as already the other advocate has filed his NOC, he is permitted to retire from the case. Yes, district is directed to delete the name. Yes,
My lords, on the last date, on 28/2025, my lords continued the same order which was earlier passed. First 2 weeks was fine. Third week, my lords, as per the direction of the court, we had to make the children to talk to the mother every evening. So from Monday to Thursday, her phone was switched off. Phone was switched off, and her phone is switched off because every day we make the children talk to her. We give a call to her and they speak for 15-20 minutes. So Monday to Thursday, phone was switched off. And Friday, she messaged us saying that I was out of station and now I'm back. We have messaged her asking that we are not being able to reach you. Could you tell us whether Saturday we can send or not? Phone records and messages are there. So for that, she said I was out of station and you can send on Saturday, Sunday. Then we send the children on. We are making a lot of effort, my lords. Both the children are staying with the mother for Saturday evening to Sunday morning. Both the children, we are convincing them. So Saturday, we send the children, and the child fell down previous day while playing, and he got hurt little bit here in the nose. So she told the children that child that you have to, your father has hit you, and then punched you on your face, and then said your grandfather will get an heart attack soon. And the child was definitely disturbed and came back. And Saturday again, there is a fight with the maid servant, who's the caretaker who goes with them. Because the caretaker is there, they are in a comfortable situation whereby they know that somebody is there who will bring him back to the house. So that is what has happened, my lords. Previous two days, we have managed to send both the children. Not only one, both have stayed there as per the court direction. In the third also, they both stayed. But this is what has happened.
They create a situation, they manipulate and they play a victim card. I really don't understand because the elder son has been coming without any problem.
First of all, when she is not there in town from Monday to Thursday, is it not her duty to inform?
Please, definitely. In fact, I checked.
When did she inform?
You are not informed, but my phone was on for normal calls. My WhatsApp
So, like that irresponsibility which was there, which made the court to pass this order by the trial court is still continuing. That's what it reflects.
Please, madam.
She has no responsibility. Monday to Thursday. No, if once children get used to her, they want to speak to her. Her whereabouts are not known. She don't even have the responsibility to tell what is happening. So then why should the court do all this exercise? What for?
My lords, in fact, when my learned friend made this submission, I immediately checked with her because
She
when I
says
was
so.
not aware.
She
Please.
says so. She takes it for granted. So like, why should there be an indulgence? They're comfortable there, let her live there.
Your Honor, whenever I
Please talk to your advocate. I'm not asking you.
My lords,
Whatever
may I
you
have
want to
this-
tell your advocate.
May-
Pass over.
My lords, my request.
I will pass a final order. Please find
My
out
lords,
from
tomorrow,
your
my
client.
lords, my request. I have
Yes, tomorrow.
Great.
This can't go on like that.
Please.
Cell number 7, hearing on interlocutory applications. 7, Arun Govind Raj for petitioner. Sumanna B.
My lord, kindly pass over. Senior held up in another bench.
Yes. Next.
May I request tomorrow, madam? I have some difficulty.
Yes.
Tomorrow.
Cell number 8. Cell number 8, Ramesh KH. Timaya.
I prefer the respondent, my lord.
Yes. Yes. Where is the impugned order?
Yesterday I filed a memo with the update, Your Honor.
Huh?
Yesterday I filed, my lord, yesterday filed a memo with update.
What memo?
With the party petitioner filed update. He has not served the copy. He has not served the copy on the
I
respondent.
read update.
What update? I'm not able to understand what you're submitting.
Yesterday I filed memo.
What memo? For what? Who asked you?
Photos, submit the
Please
photos.
come to the impugned order. That's what I want. We will look at the impugned order first.
The page, Lord, impugned order para 16, my lord. Para 16. Para 16 and my lord 17 of the concern para. And pursuit of the affidavit, the additional affidavit, your lordship got it. Continuous page, therefore then the continuous page issue.
Where is the impugned order? It starts from page
Para
number
9, para 9,
41.
sorry.
That's what
page-
I'm asking.
Page 9, para 16, my lord. Reasoning. Your lordship got it. And pursuit of the affidavit and additional affidavit. The assets and liabilities filed by the petition number 1 is, it reveals her qualification as 10th standard pass. She is residing with her parents and date of separation is from June 2019. She has also pleaded details what are all the requirements. She has also stated that she is not employed. She left her job in the government in the year 2020. As per the petition number 1, the respondent one is SSLC passed. The petition number 1 has filed additional affidavit as assets and liabilities in which she has shown her earning as respondent 40,000 per month out of his avocation, cab driving, and is the owner of the vehicle. The respondent is shown as having immovable property in his native place. And recently in the year 2021, he has also purchased a site at Kanakpura. He had also purchased the site on 9/4/2021 in the name of his girlfriend, Lakshmi. Para 17, the respondent in his affidavit of assets and liabilities has admitted that the petitioner is wife, petition number 1 is the wife and petition number 2 and 3 are his sons. His income is shown as 6,000 per month as cooling. His parents are his dependents and he needs 10,000 for their maintenance. He has also admitted that petition number 2 and 3 are under the care and custody of the petition number 1. He owns a site at his native place. He has taken a hand loan of rupees 2 lakh from his relative. He has also stated that the petitioner number is
So determining the income of the petitioner, how can the court say 10,000?
petitioner is not working. Petitioner is working. He is working as a cab.
What's income?
Not according to he says that 6,000 is now he has left the cab job and he is doing coolie and he has not placed any material to show that not he is working as a coolie. He wants, in fact, you admit.
Even if we take, there is no contra material. He's saying that he's working as a coolie. Even daily wages and all will come to around 15,000 per month. How can the court grant 10,000? There should be some material on the.
But you also kindly appreciate, no? The petition number 2 and 3 are the minor children. They are not their age about 9 and 7 years respectively, and they are school going children. It
This
is
is the MC that is pending.
MC, there is no MC pending.
MC is not pending.
It's not pending.
Just the wife is staying separately.
And my lord, she has to take care of the, my lord, in fact, the education of the children as well as medical expenses. Apart from that, my lord, she's residing in the.
All is,
No, what has been awarded is
taking care of the needs of the child. It is not the same amount for everybody. A person might be earning 10,000. For them, what would be the way how they live their life? What would be the amount is different. A person whose salary is 2 lakhs per month, what would be the amount is different. For example, a person who is earning 15,000, can he pay 10,000?
No, he has not paid any matter before the trial court to show that he is working only 6,000 rupees. He is earning 6,000 rupees per month. Not in fact, he was working as, he owns a cab, his own cab, and he says that in the 2019 he left the driving and he is working in a private firm. He is working as a coolie. No document has been paid before the trial court.
What document he will place that he is working as coolie?
Not at least you will also kindly appreciate now.
No. Tell the court what is the document. That every day wherever he is going for a coolie, they will not give him a receipt.
He is not doing any coolie work. In fact, even today he is driving the cab. He is before the court, and in fact he could able to purchase the property in the name of his girlfriend. And he also
can't establish that.
I have got the material. In fact, I would make my submission that he has also contracted second marriage, and in fact his the mother-in-law of the petitioner would depose before he would file the affidavit before this honorable court. He could able to contract second marriage and he could buy the property in the name of his second wife. Now, why can't he maintain his wife and the children? That I'm not.
Those are all assertions.
Sorry.
Those are all your assertions.
It is not assertion. Well, I would file my affidavit in so far that is concerned.
It is not sufficient.
Now,
you should file the material.
Now I will place. I will place it on record.
You will file the material saying that there is a property in the lane of so and so lady. Would this court decide whether it is purchased by him, whether money is given by him?
You lost me kind of. It's a matter of evidence that could be decided at the time of the disposing of the 120. Now, all that the trial court has held that the minimum requirement of the petitioners is 10,000 rupees and 5,000 rupees as expenses for legal. Yes, and that is the only. You also kindly appreciate now. Even for the rented house, it would take not less than 10,000 rupees per month. And how could I pay the rent as well as to maintain the children?
That's not the concern of the court. Court can only consider.
Kindly look at now. You are like para 17.
Whether the order that is passed by the court is based on.
My lord.
Para 18, relying on the judgment of the Supreme Court.
My lord, I will file the page number 36, 38, 39. Aged father and mother come before the court, Your Honor. Photos is there 36, 36, 38, 39 and medical.
We take it for granted that you have everybody will have their own parents.
Aged father and mother will take a coolie work. Petitioner is a coolie.
Who will take care of the children?
My lord.
Who will take care of the children? Why did you marry?
No married, Your Honor.
Take your father.
No married, Your Honor. The father and mother and.
They might be there. They might be there. Your responsibility towards the kids also there.
Yes.
Who will take care?
Yes, but in the situation, father and petitioner father and mother is ailing. On that time, you go outside and you settle the respondent mother house, Bangalore. After marriage, some auto driver, to married recently, and photos also I will.
You married recently?
Oh yes.
Where are the photos?
Photos I will producing.
You didn't give him a copy of it.
Okay.
He has not given the copy.
I will give it.
He has not given He has not served the copy on those documents.
No, without serving a copy on the other side, what do you expect by filing?
Yesterday I will.
But this was filed long ago. Also, it is there.
Yes.
You should serve him a copy.
Yes. I'll give it.
Please come.
In fact, my instructions are not in fact.
Humble submission, Your Honor. Please, humble submission. I will humble submission, Your Honor.
And he has filed
to inquiry the respondent.
The court and counsel for the respondent, the respondent wife shall file an affidavit before this court whether she is married or not. whether is she the person that's appearing in these photographs or not. Basing on that, further orders will be passed.
Inquiry.
Yes. Next, this is a matter on 19th of September. Yes, next.
Cell number 9. Poonam S. Patil for petitioner. Veerbhadraya.
No representation.
So I appeal for petition.
Yes.
It's last occasion, Lordships had passed an order for this petition is for enhancement of maintenance. Lords, because the impugned order was not compliant to the extent it was ordered, 5,000 per month. Lordships on 7/8/2025 directed the respondent husband to deposit all the arrears. Lords, out of 1,20,000, he's deposited 15,000 on 3rd of this month. Balance 1,05,000 of the impugned order is still yet to be paid. Lords. Lordship's orders are last hearing date, 7/8/2025.
So all the expenses are paid.
No, he's not paid. So he has paid only 15,000. Balance of 1,05,000 as per the impugned order is pending.
Calculation has not given the calculation, and
No, no.
even
What is your
please,
calculation
my
you
lord,
give?
please, my lord, even though they are not filed the application, I am in the trial court. Voluntarily, the respondent has agreed to pay the 5,000. Please, my lord,
Say
3,000.
that you are ready to pay. I have recorded your submission.
I have paid all.
He is ready to pay
Out of
entire
that,
maintenance amount and also ready to bear the entire educational
15,000
expenses.
rupees has given out of the total maintenance. I have given 15,000 rupees. He is only getting a 34,000 salary.
Then what is his statement?
Please,
That I am ready to pay entire
I
education.
paid, my lord. I have given the statement of NFT. Through NFT has given the 15,000 rupees to the account of the petitioner account, my lord.
I think I'm not
Paid
clear.
partial maintenance.
I'm not clear in my question. What is that I'm asking? What I said is, you made a submission before the court. You are ready to take care of the entire educational expenses.
Yes, please.
First of all, you should know what are the educational expenses. Then only you will pay, whether you are paid or not.
Definitely, you will agree to pay, my lord. Partial amount already 15,000 rupees out of that.
The court had not compelled you to
Lord,
say. You
my lord.
only said voluntarily on the last.
Yes, my lord. Yes, my lord. I am agreed. But he is obtaining the 34,000 rupees salary. Part by part, they are agreed to pay the total maintenance.
School will not agree for educational expenses to be paid part by part.
Meanwhile, he has sent the letter to the school. If any due the amount of the salary, what is that in exchange?
Let's not go into all that. I'll pass orders on the merits of it. Please argue.
Please. Let's.
Subsequently, I have filed 26.
Let's.
No, I'll not go into any of what you paid, what you have not paid. I'll pass orders on the merits of it. Whatever is paid, before the court, you file your memo and get the.
Before I start placing my record notes, the petitioner had filed an RTA application with the income tax department because the salary particulars furnished by him before the court below was to the extent that he is earning 34,000. Now, the ITR reply under RTA application notes reflects 3 years income tax returns. If I may proceed, if I may be permitted to place. Court.
Give him a copy also. Was it not filed before the court?
By mistake, we thought the hearing date is tomorrow. We were to file today in the count after serving him. So inadvertently, it was not filed.
I said,
yes.
Is it not filed by him before the
No,
court?
ITR records are not filed in the court below.
Also part of it which needs to be filed as per the statement of assets and liabilities.
No, Lords. In fact, assets and liabilities, income tax returns is not entitled to be
3
filed.
years have to be filed.
Yes, both the parties have not filed, and if I
Not filed, but they
subject
have
to
be
yes,
filed.
yes,
Yes, let's see. Where is that?
yes, Lords. At annexure C, page 41.
This statement already filed before the trial court. Again,
Let's see what is that she's trying to make a point.
Statement of objection in the
Page 41 minutes. Lordship, see, this is the response to my RTI query.
order, my lord. Impugned order as filed.
Last written filed by where is so and so. No,
Page
where
41
is
only.
what is the amount?
Yes, Lords, if your Lordship says page 42, for the year assessment year 2021-22, at the second column, total income is 13,11,710. For the next year, 22-23, it is 12,02,580. The subsequent year of 2023-24, it is 13,20,760. Now, my lord, says a finding of the court below that he has no other source of income. I can, the impugned order is at page 20. Let's here the notes at paragraph 11. Part of that it says there is no document to make out that apart from the salary income of the respondent, he is having any other income. Lords, the impugned order was passed based on the salary details furnished by the respondent, where it was stated that he earns 34,000 per month. Now, in view of this ITR thing, Lords, in fact, we had taken a categorical stand that he earns 1 lakh plus month, which now Lords, stands supported with the ITR reply. It's what we had sought before the court below was 25,000 rupees for the child and for the mother. Mother, of course, is also working. That is not denied. Notes. Her salary notes as per the records born are 44,000 rupees per month.
How many of the children? One or two?
One child, 8-year-old child currently. And the records of the...
What are his expenses?
Notes, yearly fees about now, in fact, current I just inquired.
As far as the fees is concerned, we'll say both the wife and husband has to share.
Yes, that we are okay.
If he's earning more, then you will pay.
Yes,
He'll pay 60%.
proportionately. Proportionately, yes.
There be a, then what about monthly maintenance?
No, it's monthly maintenance. What I've stated is about 15,000 rupees. But the child is going to speech therapy. It needs speech therapy. I just ascertained now, it's about 5,000 per month. Apart from that, there are certain other expenses, like transport expenses for the school. On an average, for the
Form part of the school expenses.
no, the bus is extra. The school fees about is about 84,000 odd, and transportation is about extras.
Along with that, it will be proportionately paid by both of them.
Yes, but what?
If this document is not filed,
yes,
then what do you say? If this document is not filed before the court, let the perjury proceedings be initiated against your client. If this document is not filed, let perjury proceedings be initiated.
Single document has not produced the trial court. It is clearly mentioned in the trial court or impugned order, my lord, that petitioner counsel or petitioner has not produced the document, my lord. Even though in page number, page number.
Before the court, what did you say is your income? You said even before this court also, just now you said your income is 30,000.
Yes, ma'am.
30,000 into 12, how much it would be? 3,60,000. What there is lot of a difference between 3,60,000 and 13,11,710. I will allow this application, and if you leave it open to for her to initiate appropriate proceedings for making a wrong statement before the court.
No, my lord, it is clearly I have submitted.
What does it say? Why income tax? These are not your income tax statements.
No, my lord, I will pursue the matter, my lord. Otherwise, now the respondent counsel has served the copy.
According to the husband, before the trial court as well as this court, his income is 34,000. Land counsel for the petitioner has placed before this court the income tax returns for the assessment year 2021-2022, where the income is shown as 13,11,710, and for the assessment year 2022-2023, 12,02,580, and for the assessment year 23-24, the income is shown as 13,20,760. The land counsel for the respondent husband submits that he will ascertain from his client with regard to this. By the next date of hearing, land counsel by the next date of hearing, the respondent husband shall file an affidavit
My
with
lord,
regard to this.
please to direct him to the file income of the petitioner also.
That we will see.
Please,
that
my
we
lord.
will see. The counsel for the respondent husband
The petitioner
shall file
also
his
getting
affidavit.
the
Please wait. Please
1,50,000 rupees.
wait. Shall file his affidavit. File an affidavit say whether what are these income tax returns, whether he has stated before the court that his income is 34,000, he has no other source of income. If these income tax returns belong to the respondent, why did he state before this? Why did he made such a wrong statement before the court? Basing on that, the court will issue the court will initiate the proceedings.
Petitioner has to file the income tax of the.
That is not. First of all, you do this.
Please, my lord. My lord,
grateful.
in the trial court,
Yes,
why
please
he has
come.
not produced the before the trial court, my lord, in the single
No, first you
document?
file. We will see what is
We filed RTI in 23. In 28, last month they issued us. 28H they have given us the.
Yes, call the next matter. This is matter on 22nd of September.
It's interim order to be extended.
Interim order
Grateful.
granted is extended. What is the interim order?
It's a stay of the criminal CMS proceedings.
Miscellaneous.
Cell number 10, Syed Khalil Pasha for petitioner.
Wait for petitioner. 2 weeks time, compromise is taking.
Huh?
2 weeks time, may kindly.
No. Why compromise? Not even notice to the respondents. File a writ petition and say compromise proceedings. That's not acceptable.
Question is, but lok adalatali ಇದೆ. 2 weeks time ಕೊಟ್ಟಿದ್ದೆ. 2 weeks, please.
No. What is this procedure? I'm not able to understand. If
pray-
there is a settlement, please do it. Why are you questioning this impugned order? That notice has to go to them. And why? How will they know about the pendency of this? And just like they're filing a petition, and don't you withdraw this petition? If nothing works out, then you can
Next
file.
week, at least next week.
That's not right on your part to ask adjournment on that ground. List this matter next Monday. Yes, next.
Cell number 11, Pramodar for petitioner.
Petitioner, my lord. This is against the application regarding the interim custody of a child.
Where is the impugned order?
The impugned order is in Kannada, my lord. At the lecture, he
Please file a translated copy. I
Yes,
can't understand Kannada. The petition shall come up with a translated copy. List next week on Tuesday, Wednesday. Yes.
16-9. Cell number 12,
I appear for petitioner.
Yes.
Lordship husband's petition, the impugned order annexure E at page number 51. The maintenance which is ordered, your lordship, the petitioner, he has no objection or anything to challenge. As far the child is concerned, the maintenance is ready to pay the maintenance order.
Come to that order. Where is
Yes,
that
please.
order?
Page number 51, your lordship. Reasoning at page
Respondent is
58.
entitled for an amount of rupees 20,000 per month towards the maintenance. Also entitled for an amount of 20,000 per month towards maintenance of the child. So which part you are agreeing?
He is challenging only insofar as the maintenance order to the wife,
Why?
respondent. Because she herself, I have produced the assets and liabilities, 241 page number, your lordship. She herself has contended that her salary that time in 2017, she is working in an IT software company in Wipro, and her salary is 9 lakhs per annum.
Not filed in 2017.
No. I'm just bringing it to your notice. 2017 itself, her salary package was 9 lakhs. Now it is to 14 lakhs. My only contention is that, your lordship, that where she herself has said that she is taking her salary.
That finding, why did the
Please.
court grant maintenance?
Only on the ground of standard of living, the court has granted the.
What is your salary?
My salary is 1,80,000. It is mentioned in the page, paragraph number 19.
Salary as considered with the court.
Yes. Her salary is taken as 76 lakhs, 76,634.
Please come.
Yes,
Then
paragraph
ask
number
the
19,
petitioner
your lordship.
Submits that. The court had granted 20,000 maintenance to the wife and 20,000 maintenance to the child. As far as the maintenance to the child is concerned, the husband has no objection to pay. As far as the wife's maintenance is concerned, she is already earning 76,000 and 1,000 per month, and she is not entitled for maintenance. Considering the submission, there shall be stay of all further proceedings pursuant to the order dated so and so. As far as granting of maintenance to the wife is concerned, the husband shall pay the maintenance of the child as per the order. If arrears, if any, shall be filed, shall be paid within 4 weeks from today, or else the stay granted by this court stands vacated, even on that count. Then the hand summons to the respondent and shall file a memo to that effect by 14th of October. If the memo is filed, is the matter.
Great.
Next.
Cell number 13, Musagni. Allah.
Yes.
I am for petitioner, my lord.
Where is the order?
Petitioner husband. Annexure H, my lord. Page number 34.
Yes.
Relevant page is page number 40.
Respondent is hereby directed to pay. What is your income?
My lord, kindly page number 33 kindly may peruse, my lord. Annexure G, my lord. Bank statement.
I'm asking what is your salary that you can tell the court?
My lord, I am unemployed, my lord. I am not having any certain any fixed income, my
Have 8
lord.
acres of coffee estate?
No, my lord, that land is barren land, man. Only 2 acres of land is there, but it is barren land, not having any income. The trial court in its order clearly held that the respondent has failed to produce the relevant evidence regarding my income, my lord.
Why?
Though the respondent has contended in the trial court that I am having copy estate, I am having so much of income, they have not produced a document.
But what you have produced? What are the, along with the statement of assets and liabilities,
Yes,
what
ma'am.
are all the documents produced by you?
Except the revenue records, that is the assessment.
I'm not asking about the wife.
Yes.
I'm asking about you. What did you produce in support of your statement of assets and liabilities?
The bank statement, I am produced one blank statements, and the revenue records are like that is the R of record of rights.
Please, all that 7,000 will not interfere at this stage.
My lord, kindly page number
Please place all your
33 may kindly be produced, my lord, because my son, my mother is suffering from various ailments, my lord, and she is underwent some medical operations. So, and my lord, I am.
What is he ready to pay?
Pardon, my lord.
What is he ready to pay?
2,000 per month. I am ready to deposit.
Yes.
Yes. The
Notice to the
imperial order kindly be stayed, my lord.
I'll not stay with 3,000 to 2,000.
Restitution of conjugal rights, we have filed a first application.
Huh?
Restitution of conjugal rights, we have filed a suit, my lord. Then she has filed a maintenance, my lord. Page number.
Will not stay that order just like
my
that.
Lord, I got married the respondent.
To living together, my lord. But my mother-in-law was protected her. So it is a settled.
Yes.
The thing is that, my lord, respondent is bent upon to shift family from village to city, my lord, and that is the only
You
problem.
understand, all those are not the concerns of the court.
Yes, my lord.
So let's not go into that and waste the court's time. Please tell the court, first of all, I'm not convinced with, you should have filed all the documents that are filed before the family court.
I am ready to deposit 2,000 per month, my lord.
No, 2,000 I'll not, that's what I said. 2,000 will not grant stay. If you are ready to pay 5,000, I'll grant stay.
3,000, my lord, 3,000.
Yes, notice to the respondent. Petition is permitted to take out hand summons on the counsel.
5,000 maybe.
Respondent.
5,000 maybe.
Then counsel for the petition submits that. The court had granted 7,000 maintenance to the wife and the child without any material on record. It is submitted that he is not in a position to pay and is unemployed. Considering the submission, they should be stay 5,000 by 5th of every succeeding month, and the arrears at 5,000 within 8 weeks. Either of it is not complied, the stay granted by this court stands vacated. Next, and summons to the counsel appearing for the respondent and file a memo to that effect by 8th of October. Even if the memo is not filed, even on that ground also, the stay stands vacated.
The imperial order may kindly be stayed, my lord.
Huh? Yes.
Article number 14, N. Gautam Raghunath.
Yes.
Yes. Respondent may kindly be permitted to file wakalata on behalf of the respondent.
No, it's because it's coming up now. They have for interim order, there can't be any.
Your Lordship, this
For
is,
the court.
Your Lordship, interim order is not sought for. This is only on an issue, Your Lordship, where both of us have agreed upon it. They have, in fact, in their written statement before the lower court stated that they're.
The order impugned.
Your Lordship, the order impugned is that they cannot grant an order once the Special Marriage Act, they have registered it, then it cannot be, because this was filed as an OS seeking also a declaration.
Well, let's
That
see
the
the
pull-up.
impugned order. Let's see.
Please. 17, please, Your Lordship.
Page number?
17. Seeking decreeing of the suit in view of the admission based.
Further?
Your Lordship, I am on behalf of the wife. Your Lordship, both husband and wife already have a divorce by way of the personal laws, Muslim personal laws. But since it was registered under Special Marriage Act for purposes of visa and everything, we had argued specifically stating we can't go by way of a mutual consent. because we were governed by the Muslim laws, and already it was granted by, on behalf of the, both the parties.
The stand can be taken
Please, Your
that
Lordship.
our marriage is registered on the Marriage Act for some other purpose, but we are governed by some other law.
No, no, Your Lordship, in fact, we would find it easier to go under the Special Marriage Act and get a mutual consent. But other courts, in fact, have earlier held that you cannot go by way of a mutual consent because you do not have that provision at all. In fact, recently, Delhi High Court in a similar,
Without going into that,
please,
your marriage is registered under the Special Marriage Act.
please, please.
So you are governed by that.
Your Lordship, that is the difficulty, Your Lordship. Several courts have in fact held that you cannot get an order under the Special Marriage Act. When Special Marriage Act came subsequently, if I had registered it straight away under Special Marriage Act, probably then yes. Since the marriage was under personal laws, divorce was also under personal laws. For you to get by way of a mutual consent divorce under a Special Marriage Act would be difficult. It was what the judgment was in.
What is this application? No, this, what is this? Suit.
Please, Your
Suit is
Lordship.
filed for what?
Suit was filed for seeking declaration that the khula would be binding on us and cancellation of the Special Marriage Act. Your Lordship, might I
All
just...
self-contradictory statements by the parties.
No,
Why
no.
did you, who asked you to get married under the special, register under the Special
Your
Marriage
Lordship,
Act?
most Muslims are facing this problem, Your Lordship.
Topple.
No,
You
the
are stopped from raiding
Your Lordship,
certificate.
then they won't get their visas also, Your Lordship.
But what to do? For the sake of visa, court can't look at it that
Now, I
manner.
understand, but this is the ground reality that everybody is facing. Delhi High Court's recent judgment, Your Lordship may kindly see, on a very same aspect where for visa purposes, they've done it under the Special Marriage Act. In that, under 226, in fact, their lordships had to quash the registration of the Special Marriage Act certificate. But in this, I have gone one step further. In the lower court itself, I have asked for seeking a nullity of that.
No,
And
what is it? No, what I'm not able to understand is what is the business of the courts to interfere in these kind of things when parties, they themselves surrender to something and you take a certificate and you come to the court. No, you cancel that certificate. We want something. It's a,
no, we don't, Your Lordship, we don't mind being bound by the certificate. But then, when we file a mutual consent divorce,
what you have, that is what you have invited on your own.
Your Lordship might find a solution for us, Your Lordship, because most of us are finding this difficulty for any Muslim couple. They are having this trouble, Your Lordship. And that the law, in fact, has not been...
No, the judgment has to be like this. The court should pass an order saying that whenever you want to get a visa, please register it under the Special Marriage Act. And whenever you want a divorce without going to the court, you are bound by the personal laws.
No,
So
not
you
at all. If
take it,
no, Your Lordship, since I'm
registering
registering under Special Marriage Act, I might be permitted also under Special Marriage Act to get my divorce, but that unfortunately the courts are not allowing.
Where is that?
Your Lordship, in this judgment itself that I have given, Your Lordship.
They said that it is not permissible.
Your Lordship. Petitioner solemnized marriage on 2023 in accordance with the Islamic Sharia law. Since the couple intended to travel abroad, they sought to register their marriage as per local requirements as it's a precondition for grant of visas to certain countries. In circumstances, in the absence of an effective online mechanism for registration of a marriage solemnized under Muslim personal laws.
Whatever that follows, you will lose all that.
Whatever follows, please.
Under the Special Marriage Act.
Please.
Or whatever that registration is there, that has to go then.
Please.
And whatever the privileges or whatever you had, like because your visas and all, everything were processed under that, because it was registered under the Special Marriage Act.
Please.
All of that you will forego now.
We would have to forego, Your Lordship. We would have to. They will have to apply separately. The both of them have been facing difficulty. In fact, the husband came to the court, filed a written statement, said, I have no objection. So, therefore, what we had sought for is, under 12 Rule 6, since there's an admission by the other side, and there's a consent in the written statement itself, kindly pass an order. Even that, Honorable Court.
Because both your admissions, both your concessions will not give any right to the court to pass an order which is not permissible.
Your Lordship, then the court could have straight away said, then go and file a mutual consent under Special Marriage Act. But unfortunately, that is also not direction. This marriage was kept pending, this entire matter for 6 months, continuously doing several research. Arguments have been...
So where is the written statement? Where is the plain?
Please, Your Lordship. Page 20, Your Lordship.
When was the When was the marriage registered?
Your Lordship, on 29/12/2017.
When was the marriage? According to where did you say about we were married as per so and so? Issued by the official of Anjuman so Bangalore, a copy of the Nikah Nama.
Please.
When was the
Para 4,
Nikah?
Your Lordship.
25/3.
25/3/2023, page 23, Your Lordship. Page 23, fifth line. This was on 25/3/2023. What are you saying?
Kula was residing. This is what she's noted on.
No.
Then
Then
19.
they get married and
It is here only. 1 second. 26.
Para 3 at page 20, Your Lordship.
It's a special marriage.
Your Lordship, may kindly see page 20, para 3.
As per personal laws.
Registration of the marriage.
Yeah.
First.
That's what I'm
15,
looking at.
please.
Yes.
Let's move a little.
Section 18.
Please. Subject to the provisions contained in 2 of 24, where a certificate of marriage has been finally entered in the marriage certificate book under this chapter, marriage shall, as a form from the date of such entry, be deemed to be a marriage solemnized under this act, and all children born so and so, so and so, so and so, in this no children, of course, provided nothing contained in this section shall be construed as conferring upon any so and so. Such children would have to be incapable of.
No,
generally
which
going on
judgment
this.
says that the certificate that is issued under section 15, registration of the marriage, no, they are not governed by the Special Marriage Act.
There is one more reason I have initiated declaration.
Please. No, which judgment says that? Their marriage is, what is registered is under the Special Marriage Act. So why they are not entitled for a divorce under the Special Marriage Act?
Your Lordship, may I kindly see this, Mr. Judgment?
That is section 27 deals with the divorce
Please,
of the Special Marriage Act. So it is registered.
please.
Nobody is questioning the registration.
Correct.
So why they cannot file an application for divorce under the Special Marriage Act?
They're already divorced.
What is happening is it's being looked at that they are already divorced under personal law. So to get a second divorce under the Special Marriage Act becomes an issue.
No, that divorce. So why can't you take in this, when there is a certificate, you should have taken it. Because that's more easier, they might have opted for that.
No.
On what grounds can I initiate divorce?
Already a certificate is there. So why you should have filed an application on the Special Marriage Act? That wouldn't be a problem.
Your Lordship, provisions in that there is no cruelty or desertion or any such.
So let's see what are the grounds on which section 27 says.
Please. So A, B, C, D, Your Lordship, none of it. F, G, H also. Hmm?
There is a divorce by mutual consent at 28.
Your Lordship, the difficulty with this is if they are already given a kula, then under 28 they can't come.
That's the reason a suit has been filed. That's the reason 7 Rule 1.
Got it.
What is the procedure for a kula? How
Your
it is
Lordship.
documented?
Your Lordship, the representation is given.
By the girl. He has to come.
And then either
Once
of the parties.
Once you're Muslims and you're married under the Muslim law,
Correct.
you can't register your marriage. You have registered your marriage. And now what
No,
is
the
certificate
nikah is registered while they're doing, both of them sign it.
But still you have registered the marriage under the special marriage.
That is for purposes of technical purposes, Your Lordship.
You are complicating your life and
Your
making
Lordship, then would it mean that any Muslim can't travel at all because they have already got it registered and there is no clarity on that at all? Would it then mean that?
just because for the purpose of traveling, so however you are married,
Please.
once your marriage is registered under the Special Marriage Act, you have to have your divorce under the Special Marriage Act.
Your Lordship, but if the kula has to be done, then
let us assume you don't do the kula. You will take it by
then
a
yes,
Special Marriage Act.
then yes, Your Lordship, if they don't go back,
Do it. It is your problem what to do. That is not a general problem. So everybody now will take a divorce by way of a mutual consent. What will happen is we cannot pass a judicial order saying that, okay, they're Muslims, they're married under the Muslim law, registered under the Special Marriage Act for the purposes, for some other purposes. So though it is there, this registration we will cancel. Why should we cancel?
Your Lordship, might I then at least see clarity that we go and get a mutual consent divorce under the 28, then whatever kula they have to do, they can do subsequently because there needs to be, because none of them even have that clarity. Most of them do not know.
Both of it can't go together. Either that or this.
Your Lordship, problem for them then would be the Special Marriage Act, mutual consent would be looked at as a documentary. But if either of them would have to get remarried, they would need that kula. Otherwise, for them, remarriage is a problem. So they are, Your Lordship, until the UCC comes, we need this clarity. Otherwise, all of the women are going to face, already they have faced enough trouble. We have had judgments continuously coming in to save them, whether it is triple talaq or otherwise. We need further clarity. Otherwise, the difficulty for them tomorrow is, by way of a 28 of mutual consent, would not be technically taken that there is a kula. Your Lordship, might I again take Your Lordship towards the Delhi judgment? Just for a minute, Your Lordship.
The court said by mistakenly it is registered.
Your Lordship, subsequently, on account of irreconcilable differences, irretrievable breakdown of marriage, petitioners executed a Mumadarat Nama, which in a form of divorce.
No, it is pointed out by the counsel for the petitioner that in the light of the foregoing, the Special Marriage Act would not apply, and the petitioners, under mistake, registered the marriage under the Special Marriage Act. That's what is the
No. That has cleared over here in the first para itself. Since the couple intended to travel, they sought to register their marriage as per the requirement, since it was a precondition.
Where do you get that?
That is the first line itself, Your Lordship.
No, this is the only one judgment you have given.
Please, Your Lordship, on 23rd August 2024, court passed the following order. Petitioners solemnized their marriage on 11th October
The court on 23rd August 2024. This is the order of the court.
Please. And there the second line, in accordance with Islamic Sharia law, since the couple intended to travel abroad, they sought to register their marriage as per legal requirements, as it is a precondition for grant of visas to certain countries. So that is what is recorded. Now, if you go, Your Lordship, to paragraph 3, since they have executed so-and-so, which is a form of divorce by mutual consent recognized under Islamic law, present petitioners accompanied by affidavits, and the signatures are identified.
I think it requires some hearing and some law to be placed, because it will have its own
repercussions. I understand, Your Lordship. Might I otherwise request, if Your Lordship thinks that we must go under, then a time frame is given where anyway mutual consent divorces are.
So you say that if you go under the Special Marriage Act, it's a problem for you to marry.
That is true.
Under
That is true.
secular.
Please, Your Lordship.
So that's why we'll examine, come with some judgments and law on that.
Your Lordship, in this, under 226 itself, the Delhi High Court proceeded to quash that certificate itself, because it makes better. Your Lordships have vast powers under
But
that.
it's not under 26, it's 27.
No, Your Lordship, might I read this?
No, you're before this.
In
court,
ours,
it's
we have
27.
invoked both.
27. No, whether you invoke or not, but it's under 27.
I understand, Your Lordship. In this, Your Lordship, what they had done is that they had also directed that the Chief Secretary personally look into the issue, and compliance of the judgment in a time-bound manner was done. Since again, this would become an issue. So the registration certificate is annulled by way of this judgment, Your Lordship, which is what I thought in similar terms it could be granted. Unending weight, Your Lordship, for both of them.
There is a place and, the forum which is required for this to pass such an order. Under 227, who are the parties before in the suit?
Both the husband and wife. The wife filed it, the husband came on.
Then the Special Marriage Act, 226, when they must have made all the concerned parties to the petition.
Correct.
They are before the court. The court can pass such an order. In my view, I have my own reservations on that, even under 226 also, because it is more or less a public interest litigation. Now, by way of this order, we are saying something which is legally permissible and which is already done. We say, okay, they have done, let us now nullify it for some
No, it
reason.
need not be on a larger context. In view of the prayers sought for before the lower court, and
any order that's passed by the court, it becomes a precedent.
Your Lordship, this
legally
is
how is permissible. That is like very cryptic order. In that manner, such an order would
I understand, Your Lordship.
Couldn't have been passed, because just like that, interfering, like High Court setting in 226, 482 or 227 for everything, it can't exercise powers like that. So, but please come with some.
Please,
we'll
please.
examine. When do you want?
Next week, Your Lordship.
Yes, this is matter on 24th.
Please.
When counsel so and so submits that He has instructions to file wakalat. Yes.
Obliged.
Syed Khalil Pasha. Cell number 16, 15, Ravi MM. Cell number 15.
So petitioner in this case, my lord, the petitioner is challenge the order of the interim maintenance granted by the family court. The respondent, the impugned order is annexure A, my lord, the
How much is granted?
20,000 has been granted, my lords.
What is your income?
My income, my lords, as per the salary slip, my lord, the gross salary is 44,000 in the year 24 September. Since then, my lord, he was not getting any salary.
Why?
Since from some inconvenience in the department. Now he is in 15 days, he has joined the
It is
duty.
this maintenance to only to the wife or wife and the child?
Children, 3.
Hmm.
My lord, this petition is for restitution of conjugal rights. The petitioner is ready to join, but he has not deserted. She voluntarily reserved for want of separation from the mother. Even till today, he is ready to join. He is look after the children.
No, these are all the usual grounds we see.
No, my lord, see, this is restitution of conjugal rights.
The respondent submits that.
No, not the 20,000 millards he has not granted, only 44,000. Kindly, the
Submits that his salary is
no, he could not able to file his assessment liabilities.
granted 20,000. His salary is 40,000, the court had granted 20,000. It is on the higher side, and the petitioner is not in a position to pay the amount. Considering the same, there shall be stay of all further proceedings on the condition that he paid 12,000 per month. In the arrears also at 12,000, 12,000 by 5th of every succeeding month. Arrears at 12,000 within 8 weeks. Same default order and a memo to be filed by 15th of October. If the memo is not filed, or even on that ground also, the stay stands vacated. Yes.
Cell number 16. Arun C. Bhatt for petitioner.
Very important, Commissioner. My lord, the JDR before this honorable court, the wife.
Where is the impugned order?
Annexure A, my lord. Page 19, my lord.
IA number 4 by
4
filed by the
JDR at Annexure D, my lord. He sought for permission to cross-examine the decree holder. Permission to cross-examine the decree holder.
When the EP is filed?
EP is filed in the year 2018.
18.
Please,
When was the examination? When did you file this application?
He has filed the application on 22/3/2025, madam.
Why?
He has appeared before the court. He has appeared before the court in the year 2019. After that, due to COVID, he.
Let's see your IA that's filed.
Please, madam.
Your application to examine that, cross-examine the, where is that IA?
At Annexure D, my lord.
Annexure D. Yes,
D,
let's see
please, my
what
lord.
are the reasons.
My
stated.
grievance is recorded by the execution
For the
court.
reasons stated, the honorable court may be pleased to permit the judgment debtor to cross-examine the decree holder on the facts as narrated in the affidavit dated 15/12/2019. An affidavit was filed in the year 2018. What were you doing till 2025? First of all, an EP that is filed in the year 2018, why
please,
should it be pending till 2025?
Please, my grievance is recorded in page 14 of the.
Let's see, first of all, before that, we see what are the reasons why you are come.
Yes, ma'am. My grievance is, I have not served.
See your affidavit, not the grievance. See why you want to do it right now.
I have not served with the copies of the petition as well as the documents, my lord. After that, I filed a certified copy application. There also, I could not find the certified copies. Therefore, I filed the application for cross-examination.
Yes, please come to the order now.
Page 14, my lord.
Yes, please read.
Last para 7. The only objection of the JDR is that the claim made by the DHR is a false claim, not supported by any documents. He is disputing the documents produced by the DHR, and copies of those documents were not furnished to him, and the office has refused to issue certified copies since those documents are not exhibited. This is what my grievance. I filed the application.
The Honorable Court dismissed the,
Come to paragraph 9.
please. Moreover, the order sheet reveals that the cost notice sent to the JDR by court and RPID returned unserved. In response to the hand notice, the JDR put his appearance on 22/3/2019 and prayed time. Accordingly, the matter was adjourned to engage counsel by 22/3/2019, but he did not turn up. Therefore, notice was issued by the order dated 6/8/2019 and reissued from time to time till 10/4/2023 to both alternative addresses, but returned unserved. On 10/4/2023, instead of arrest notice due to oversight, it was ordered to reissue arrest warrant, and the same was continued, and arrest warrant were reissued from time to time till 21/2024. On that date, the JDR appeared through his learned counsel, that is when the arrest warrant were reissued through police commissioner, but not paid any amount. Again, the arrest warrant was reissued. Then on the next date onwards, he started making partial payments as detailed below. The details are there. Para 11, on the date of last payment, that is on 22/3/2025, the JDR has come up with the present application. So prima facie, there is no force in the objection of the DHR, that only with an intention to prolong the proceedings and to avoid the payment, the JDR has come up with the application. Please, ma'am.
Yes, you can.
Moreover, accept the claim of rupees 6,400 for coaching classes, brand brain rupees 800 per month into 8 months, which is supported by the receipt at document number 6A to 6B, that is 4 receipts for the months of August to November 2018. No receipt for the remaining 4 months are produced. All the other claims as detailed in the calculation memo are supported by the receipt issued by the concerned with signatures, and many of the receipts are with the seal of the institution as well. Hence, there is nothing on record to disbelieve the claim of the DHR for rupees 1,09,031 minus rupees 800 into 4, for which the DHR has admittedly not produced the receipt.
Yes, I've seen the entire order.
Please, madam.
Yes.
Some of the documents, kindly see.
Only question is, what are you doing from 19 to 25? Why should the court waste its time, issue all these warrants?
I have made a part payment
Not
in
part
between.
payment. When you have entered appearance in the year 2019,
Please.
why did you not appear before the court till 2025?
Because of the reason that the decree holder intentionally taken the wrong address.
No, you have filed your.
It is stated in the.
There was appearance in the year 2019. You have engaged an
My
advocate.
lord, this petition, this respondent filed another execution petition wherein she has taken the arrest warrant. When the JDR brought before the court, this was connected with on the same day.
The main order, have you questioned? The main order that is passed, have you questioned?
No, my lord.
You have not questioned.
Yes, that it is pending in MFA 3834 of 2018. Please, ma'am.
Yes, please come. The present petition is filed. Agreed with the order passed in I number 4 in execution case 317 of 2018, dated 21/7/2025, whereby the court had dismissed an application filed by the JDR with costs of rupees 5,000, and also for paying the balance amount. The matter was directed to be called on 30/7/2025, or else the court would take coercive steps. Basing on a order passed granting maintenance in MC number 473 of 2008.
Submission, my lord. It is not maintenance, educational expenses of the child, please, ma'am.
Educational expenses of the child in MC number 473 of 2018, date of order is 2/4/2008. execution petition is filed in the year 2018. And the judgment, the debtor has entered appearance in the year 2019. Thereafter, several times warrants were issued. And finally, he has come before the court on 2024, he has appeared before the court. Thereafter, he made some part payment of 37,000. Then, on 22/3/2025, he has come up with the present application that he wants to cross-examine the decree holder, and some of the documents that are filed were not supplied to the judgment debtor. The court, by order impugned, had dismissed the petition. While dismissing the petition, the court has categorically observed that the order sheet reveals that the cause notice sent to the JDR by court and RPAD returned unserved. In response to this, the hand notice, the JDR put his appearance on 22/3/2019 and prayed time. Accordingly, the matter was adjourned to engage the counsel by 22/3/2019, but he did not turn up. Therefore, arrest notice was issued by the order dated 6/8/2019 and reissued from time to time till 10/4/2023 to both his alternative addresses, but returned unserved. On 10/4/2023, instead of arrest notice due to oversight, it was ordered to reissue arrest warrant, and the same was continued, and arrest warrants were reissued from time to time till 21/2024. And on that day, the JDR appeared through his counsel. When the arrest warrant were issued through the police commissioner, but not paid any amount. Again, the arrest warrant was reissued. Then on the next date onwards, he started making partial payments from 7/1/2024 to 22/3/2025. That is an amount of rupees 37,000. And on 22/3/2025, the JDR has come up with the present IA, that's IA number 4. The decree holder has filed his objection stating that this is an application filed only with an intention to prolong the proceedings and to avoid the payments. The court had, in paragraph number 13, had observed when and how, paragraph number 13 has observed when and how the amounts are paid, and what are the delaying tactics on the side of the judgment debtor, and also observed that the decree holder is entitled for 12% interest per annum, but unfortunately the hands of the court, being an executing court, cannot go beyond the decree or tide, as there is no order for interest in the order under execution. And the court has come to the conclusion that since the matter is of the year 2018 and the list of 50 old cases on the file of this court, wherein there is a direction by the administrative judge to dispose of these matters by the end of September 2025, it is made clear that if the JDR remains unpaid, the balance amount and the costs now imposed, the court would be left with no other alternative. And the court has observed that this application filed only to protract the proceedings, and further directed the JDR to pay the balance amount by 30/7/2025. The land counsel appearing for the petitioner submits that the arrest warrants were not served on him, as the address that is furnished by the decree holder is not the correct address. It is submitted that as the documents were not given to him, he wants an opportunity to cross-examine the decree holder on some of these documents. The court, without considering all these aspects, had dismissed this petition. Next paragraph. Having heard the land counsel for the petitioner, peruse the entire material on record. It is a very unfortunate case where an order that is passed in MC number 473 of 2008, dated 2/4/2008, is now for execution before the court. Execution is filed in the year 2018. From the year 2000, when he was served notice on in the year 2019. Conveniently, from 2019 to 2024, for various reasons that are being stated, he had kept quiet. Even when he came before the court in the year on 2024, whatever the stand that is taken, that's the reason for filing the IA. He had not filed any IA at that time. He kept quiet for another 1.5 years from the date of his second appearance before the court. And now, and the court had rightly dealt with the conduct of the party and whether that IA 4 can be how the IA number 4 has to be decided. In the considered opinion of this court, the courts shall not come to the rescue of a litigant who is only trying to abuse the process of law without a valid reason. Accordingly, this writ petition is dismissed with cost of rupees 5,000 to be paid to the respondent wife within a period of 2 weeks.
Cell number
Yes, next.
17.
Yes.
Arvind Kamal.
I'm for the petitioner husband, my lords.
Yes.
I filed a petition for divorce on cruelty grounds, and evidence of both the sides were completed, and it was posted for arguments. I filed an application under orders 18 rule 17 to recall the witness, reopen the stage, as well as to summon the doctor. The main ground for me is that with respect to the permanent condition, pathological myopia.
Where
That's
is
a
the impugned order?
myopia.
Please come to the impugned order.
Yes, page number 13, my lords. So it's a joint order which has been passed, which has
You are
been
for the
dismissed.
husband.
Yes, my lords.
You are for the husband.
I'm for the husband. Yes, it is my case. It's for
MC for divorce on the ground of
divorce on cruelty. That non-disclosure of a particular act. That means the permanent disability was there with respect to the pathological.
was the marriage consummated?
On 14/2/2021 was the marriage.
When was the divorce application?
It is 16/11/23, my lords. And I have a child out of this. So we have not gone for section 12 because the child's future is there. It is not that we are not against, we are willing to pay any maintenance or anything. But very fact that it was very cruel on the part of the wife that they have not disclosed at all. Absolutely.
When was the evidence started?
My lords, it was started on 3/6/25. And it was concluded on 28/7/25. So almost every week there were 2 dates which was given. And then finally it was posted on 5/8/25, my lords.
No. When is this IA filed?
5/8/25, 5th August.
Let's see your IA.
On 8, yes, my lords.
Page number?
Yes, my lords. Page number 19, my lords.
19.
Yes, 19. That's annexure B1. That's for to recall the stage, my lords, under order 18.
Let's read.
Yes. For the reasons stated in the accompanying affidavit, the applicant prays that this honorable court be pleased to recall its order dated 28/7/25 for the purpose of reopening the case from the stage of main arguments to stage of further evidence of petitioner in the interest of justice and equity. That's IA number 7, my lords.
No, why you wanted it at this stage?
Yes, because for me, specifically during her cross-examination,
Where
she
did
has.
you say that?
Yes.
That I want to see.
We may go to page number 22, my lords. That is the one which is to summon the doctor. The first one is to recall the stage. Number 2 is to summon the doctor.
That is a supporting affidavit. Reason should contain in the affidavit.
Yes, it's there in the affidavit, my
So
lords.
where are they?
Yes, my lords. Hence, it is spread in the para number 3, if I may, my lords, or para number 2, I'll read, my lords. Page number 20, which they're almost similar affidavits for both the applications. I have filed this case against the respondent seeking divorce on the ground of cruelty and also cheating me by hiding the fact at the time of marriage that she is suffering from eye disease. That is that pathological myopia. Eye disease since her childhood and it is incurable. I have produced medical documents relating to eye disease of the respondent. The doctors who have examined her needed to be examined before this court in order to facilitate the honorable court and also to counsels of both the sides to understand the medical terms in medical records. Hence, it is prayed that this court allow my application recall and reopen the stage for the stage of main argument to the stage of further evidence of the petitioner in the interest of justice and equity. I have merits on my side. Examination of the doctor in order to understand the
Please
medical.
come to the present impugned order.
Yes, my lords. Page number 13.
Page number?
From 13 it starts, my lord. Reasons starts from page number 15.
Yes, please read.
Yes. Point number 1, by careful perusal of the materials placed before the court, it reveals that the petitioner has filed the petition against the respondent for seeking decree of divorce on the ground of mental cruelty. In petition averments, the petitioner has taken several contentions and also made allegations against the respondent. It is also made the allegation in relating to the eye disease of the respondent. The petitioner has stated that respondent is having rare eye disease for which she may lose her eyesight at any point in time. With regard to this contention, the petitioner has produced medical certificates. Admittedly, the respondent has not denied the problem of eyesight, but she has stated that there is no threat of loss of eyesight and retina. The respondent and her son are having very good eyesight and not facing any problem so far. So in the objections, the respondent has denied it so and so. My lords, that's denied with regard to threat of losing eyesight as alleged by the petitioner. In the evidence also, she has not supported the contention of the petitioner. The respondent has stated that presently she is using contact lens. Thus, the respondent has not admitted the allegations of the petitioner. Therefore, due to the said reasons, after closing of the evidence, respondent the petitioner.
To come to paragraph number 8, from the below about 5 lines.
Yes,
the
my lord.
court says it was never your case with regard to her health condition that constitutes cruelty. Was not your case.
It is my case, my lords. It's one of the case among other grounds. It's one of the cases major because this act of the wife without disclosing that act, because this condition not.
That's what
Yes.
the court says.
It is no doubt he also taken contention with regard to eye problem of the respondent, but for the reason of apprehension of petitioner with regard to losing eyesight by the respondent, the contention of the petitioner is in respect of causing mental cruelty cannot be considered and accepted. My lords, at this, what the learned judge says is that this action of her non-disclosure does not amount to cruelty, is what is the learned judge's extraction out here. Yeah, my lords, in this case, if may be permitted to place 2 citations, please. One Madhya Pradesh and one Uttarakhand High Court, my lords. In a similar situation, a doctor is important that he is examined.
Not
because,
necessary those judgments.
yes.
Please come. Then counsel for the petitioner submits that. An IA that's filed under order 18 rule 7 rule 17 CPC under section 2 under order 16 rule 1 read section 156 CPC 151 CPC for recalling the petitioner's side evidence and issue summons to the doctor to adduce evidence came to be dismissed. It is submitted that they has filed the MC on the ground of reality. One of the ground taken is that along with the other grounds that she is having some incurable disease to the eye, and as it is not disclosed, it also amounts to cruelty. This the matter is posted for evidence on 36/20/25, and the evidence was concluded on 28/7/2025. And on 5/8/2025, the present application came to be filed. The court had dismissed the same, that's being at a belated stage, considering the fact that this is an MC of 2023. 2023. Court ought to have given a chance to the petitioner husband to adduce evidence. In that view of the matter, they shall be stay of all further proceedings in MC number so and so for a period of 4 weeks. The petitioner shall take out hand summons on the counsel appearing for the respondent and shall file a memo to that effect by 24th of September, or else the stay granted by this court stands vacated.
Much obliged.
Yes, next. Next.
So number 18, here for the petition.
I represent respondent, Lords.
My lords, in this
My
matter.
Lords was asked to furnish a affidavit on behalf of the respondent in this case, my Lords. Affidavit is filed, my Lords.
May I submit?
What is the affidavit that is asked to be
In
filed?
fact, we give the affidavit today. We could have served it earlier from the last 1 hour we are sitting here.
The respondent shall file an affidavit before this court disclosing.
Yes.
When she lost the job, what was the salary she was receiving? When she joined the job?
Yes, yes,
Right
my
now,
lords.
what is she doing?
Yes.
Everything
In
I have
fact-
detailed affidavit is filed, my Lords.
In fact,
On
I-
6/9/2025, I have filed, my Lords.
Why you have not served on them?
Lords.
So in fact, we have got a stay when the matter was first taken up. There was a stay that this honorable court gave on the precise grounds that she has stated in her affidavit in the application that she has lost her job and actually she's working. We have produced proof of her working. Kindly see.
Please read her affidavit.
Yes.
Take that.
Yes.
Let's see that.
Now in the affidavit, my friend has stated para 3. I state that when I lost my job on 19/6/2020, I was working for Team Lead Services. I have produced, etc. Then he states in the same para, I have produced appointment letter dated 8/12/21, Annexure D, letter of confirmation and salary slip for July 25, Annexure, where I have drawn net salary of 51,499. So now in January, according to him, she is getting 51,500. And in fact, her claim for maintenance was that she needs 40,000 per month. So where is the need for any maintenance? In fact, I have produced her TDS certificates of 22, where she is getting more than 51,000. I will just see even the salary slip that my
What is
friend.
this? I'm not able to understand. Read paragraph number 3.
3, yes.
My Lords, before that, my
I
Lords,
state that
if
one
we
minute,
read
sir.
para 2, my Lords, para 3 will come.
Yeah.
Para 2 is,
I will
when I
read-
filed the application, I was jobless.
Paragraph 3.
I state
Paragraph
that
3, last 5 lines. I
Yes.
have
Yes.
to.
appointment letter dated 8/12/21 at Annexure D, letter of confirmation dated 8/9/22 as Annexure E, and salary slip for month of July 25 as Annexure F, where I have drawn net salary of 51,499. Now the family court order itself was on June 22. That means she was already appointed. In 21, she was already appointed. They are on oath. She has in fact
My
stated a false.
my Lords.
1 minute, 1 minute.
Yes.
What is the date of order of the?
Yes,
family
my Lords.
court?
My Lords, I filed the application on 24/9/2020, sought for maintenance.
49.
2020. I sought for maintenance of 40,000. As on that date, I was jobless.
Next.
Yes, my Lord.
When was
Then
the order passed?
the order is passed on 16/3/2022. 16/3 matter was posted for
sorry.
order.
15/6/22.
15/6/2022 is the order passed.
No, 15/6.
Yes, 15/6.
So according to you, I was sincerely trying to secure a job. Ultimately, I was able to secure
Yes,
a
my
job.
Lord. Para 3, I have.
1 minute, 8/12/2021. In Axis Bank.
Yes,
I was
ma'am.
put on probation till I was confirmed by a letter of confirmation. That's on 8. So even when you are in probation, you must be getting the salary.
My Lords, there was no guarantee of my employment.
That
It
should
is
be
only a
brought to the
probation.
notice of the court.
My Lords,
That should be not brought to the notice of the court. It
my Lords, I
certainly-
did a mistake.
Certainly amounts to.
My Lords, it is not
suppression
this
of the
way.
fact.
It is not, may make one submission. It is not my intention to suppress the material facts. What has happened is,
That time, if
My
not
Lords.
that time, till the court asked you, did you tell the court? Till they file an application, did you come before the court and said, I'm earning 51,499 per month?
yes, my Lords.
He didn't say. So by suppressing and misrepresentation of facts, your client wants to have
Lords.
an order from the court.
May I make one
And it
submission?
is a fit
My Lords.
case where perjury
My Lords.
proceedings have to be.
It is subsequent to filing of an application by me. Your Lordship may kindly see, when I filed the application, I was unemployed. I was not having a job at all.
The pendency of the petition, that is on 8/12/2021, by that day, you were earning something that was not brought to the notice of the court.
My lord, I say, my lord, I beg to say this, my lords. I was on a probationary job. Probationary job is for only 6 months.
Two things, either I'll allow this petition by setting aside the order, or if you want to argue anything on merits, I will straight away say that the perjury proceedings be initiated against your client.
No.
Not the purport of section 24. Please come.
My lords, let it be modified, my lord, at least.
No.
Some extent.
Agreed with the orders.
My lords,
That
let
is-
the order be.
That is the price she is making. She is paying for her conduct. Agreed with the orders passed in.
My lords, I may be permitted to, this petition may be allowed, my lords, instead of all that.
Yes.
And a liberty may be given if at all a fresh application could be filed, liberty.
But I'll not grant. If I have to grant, I have to, consider so many issues. Agreed with orders passed in MC number 5368, in I number 4, in MC number 5368 of 2019, dated 15 June 2022, whereby the court had granted maintenance of an amount of rupees 20,000 and also litigation expenses of 10,000. The husband is before this court. When the matter came up for hearing, then counsel for the husband submits that, then counsel for the wife submits that she is employed and she is not asking for any maintenance from the husband. Accordingly, the order impugned, because if you want me to record, I have to record every paper, every
It'll be
document
worse.
that's filed.
My lords,
Much worse
it
if
is-
my lords record
my
all
my
that.
lords, my humble submission is this, my lord. It is not that, otherwise why I could have come before this honorable court, even enclosing the termination letter,
No
everything.
option. You have no option. You are compelled to do it.
My lords,
It has been
I
voluntary. You would
have
done it
come with
long
clean
back.
hands, my lords.
No, unclean hands.
My lords, at that point of time, I have stated in my, on oath I have stated,
I can record all the contentions. I can record everything, but that will go against you. If you want only on this statement, I can close the matter, or else I have to record everything. Your contention.
your lordship may kindly set aside the order, my lords, and let the trial court decide on its own
Yes.
on the merit.
No, then there is
Thereafter,
set
yes.
aside and allow the petition, like my lords were
Yeah,
saying.
that's what
with
I am
the
saying.
clean,
If
ground.
order is set aside, a petition is allowed.
Submits that as per his instructions, the wife is employed, and that factor could not be brought to the notice of the court at the earliest point of time. As such, she is not seeking any maintenance from the husband. Considering the same, the order dated so and so is set aside.
And
the
my lords,
petition-
whatever amounts were deposited by me, I can withdraw the same.
Whatever the amount that are deposited with the husband already, the husband
The
is at
High Court
liberty.
can be.
Yes,
can be
please.
Cell
Great.
number 19 at 10:20. Cell number 20, M.R. Nagbhushan for petitioner, Madhu CH.
Yes.
I am for the respondent in this case, my lord.
Yes.
Passed under 24 of Hindu Marriage Act by granting the 6,000 rupees monthly
Come to the order.
in page number 78, madam.
78.
6,000 per month granted, madam.
What is your income?
No, madam, I am doing coolie only.
Still
I am
also
earn-
6,000 is a reasonable
I
amount.
am earning only 3,000. I have to take care of my parents also, my lordship.
How can you earn 3,000 as a daily wage worker?
I am doing only coolie business.
Coolie is
working.
like a minimum 15 to 18,000.
When its job is available, I used to go and earning, my lordship.
That
My
you
lordship,
can't
in lieu of the
consider.
assets and liability filed by the both the parties, my lordship, she only, my lordship, in my pleadings, my lord clearly stated that marriage taken place in the year of 2016. She is not adjusted with my parents. Accordingly, she only voluntarily withdraw our company. Even you are also ready to reunion, my lordship. Ultimately, you have filed the petition for a divorce.
Then how will you take care then with 3,000 rupees?
She is not adjust with my parents. She is forcing me to make a
Comes
separate
back.
house.
She comes back with the children. With 3,000 rupees earning, how can you take care of your mother, your wife and the children?
My lord, my mother also working working in neighbor houses only. Accordingly, we are accumulating the money and living together, my
No,
lord.
we can't compel her to come and live with you. Yes,
That's a
Mr.
fix-
Counsel?
Please, my
Oh,
lord.
is there any-
Only 6,000 amount has been awarded, my lord.
No, no. Is there any scope for settlement that she wants to join the husband?
No, my lords. He himself has filed for dissolution of marriage, my lords. There is
Anyhow,
no,
he has filed, now he says he's ready to take her back. Why don't you get instructions from your client?
please, my lords. Kindly have it next week, my
This
lords.
matter
I'll
for
correct the
mediation.
mistake.
Shall we refer this to mediation?
Mediation,
Please, my lords.
15, please.
Where do the parties stay?
Both are residing at
Both are
Tumkur
residing
only.
at Tumkur, my lords.
Both the parties shall appear before the mediation center in Tumkur on
My lordship, not Tumkur, my lordship, here only.
Bangalore. They'll come.
Bangalore.
In the mediation center, Bangalore, on 18th of September. Yes, next.
Well, interim order may be extended.
Interim order earlier granted is extended till then. Yes.
21, yes,
Obliged.
or Muralidharan for petitioner, Gautam Raghunath for respondent.
My lords, I appear for the respondent in this matter. My lords, in the last hearing date, I filed my statement of objections to the main petition, my lords. My lords, in this matter, what has happened is that
She has to argue that's her matter. He's a petitioner. Yes.
My lord, before the arguments, I just wanted you to know that there are two more cases have been pending before this honorable court. One is MFA 114 2020 and one more case is MFA 2642. So 2022. My lord, I would request this honorable court to connect these matters.
Not necessary. MFA, the whole, it is a fine, against a final order, there is an MFA. This is a interlocutory order. We have to deal with it before this court. It won't be transferred to the, it won't be placed along with the, before the division bench. Yes. Where is the impugned order? Come to the impugned order.
My lord, I request 1 week time for the arguments, my lord. My senior would.
Does this matter in the month of November? Yes.
Cell number 22. 22, Prasanna VR. Fatima SK. for
Husband's
respondent.
petition was not the
Pass over. Yes, next.
Cell number 23. Cell number 23.
For the petition, my lords, I may be permitted to file an application, my lords, that is respondent number 2 has attained majority, bringing to
File
notice.
it before the court.
Yeah,
All the
yes, my lords.
applications can't
I may be
filed.
permitted, my lords. I'll file the necessary.
From counsel
My lord,
the petitioner.
one submission. The thing is, they are trying to protract the proceedings, my lord. They let it maybe pass over. The thing
This
is,
is matter
even on the
on
last date of hearing also, they had
of
taken.
September. Mr. Counsel,
Cell number
how can I take
24.
all those documents before this court like that? Understand?
They could have done it
List it on
yesterday or day
September 15th. Yes. Let's
24.
not waste one more
Lords,
minute.
it may be
on
taken
that.
up 19, my lords, my humble request.
No.
19,
It will
19.
not be taken on 19th, it will be taken on.
Any day after 18, my lords, my humble request, that's it.
Why?
My lords, I'll be admitted to the hospital.
Then I will deal it today itself. After.
I'll make the necessary arrangements if that's the case.
Yes.
15, grateful.
Cell number 24.
Yes, I am for the petitioner, my lords. This is husband's petition. The interim maintenance has been granted 12,000 on a ground that, my lord, some of the amount has been shown in the, my lord, my account.
Counsel for the petitioner is present, no representation.
May I request, my lord, one more thing. My lord has granted, my lord, 6,000 as an interim maintenance by granting stay. I deposited all the arrears. That may be made confirmation and sent back the matter for evidence, my lords. It is my petition.
The respondent heard the counsel in part. List this matter on Tuesday as part heard. Yes.
Applies.
Cell number 25. Manjunath V. Rayappa. 25.
Yes.
Anita N.
Pass over. Next.
Cell number 26.
I prefer petition.
Cell number 26.
Appear for the.
for respondents.
Sir, your lordship,
The
interim order.
orders have been complied with me. And two, I was told that the child is
Suffering from some phobia.
phobia, my lord.
Let the same arrangement be continued for another 2 to 4 weeks. Then she will get accustomed to this new environment.
No, my lords, it is false. My lords,
False or true, we will take it slowly. Girl is too young. So we'll take it slowly. What is the difficulty? I don't understand.
no, my lords, it was very much attached to grandparents
Maybe
and
let
father.
it happen. We will consider it at an appropriate point of time. I told you. No, things are happening. Let it happen. Let it happen for another 2 weeks. Earlier arrangement.
3
What
4
is the
weeks, no
date?
issue.
Huh?
3 4 weeks, no issue. Man.
It is very strange.
This court has passed an order.
And Millets, the child also wants to be,
We will meet the child after 2 weeks. We'll meet the child after
for
2
more
weeks.
time, please.
That's what I'm saying. I'll meet the child after 2 weeks and then pass orders. This court has passed an order on 38/2025, whereby this court has permitted the father to pick up the child from the grandmother's place at 10 a.m. in the morning and drop her back at 6 p.m. in the evening. It is submitted according to the counsel for the father. The visitation went on well. According to the counsel for the grandmother, the child is little hesitant, which is denied by the learned counsel appearing for the father. Considering the age of the child, this court deems it appropriate to continue this arrangement for on what is the date today? On 13th, on 14th, and also on 21st. The Melissa's matter on 22nd. On the day, the party shall be present before this court in the chambers at 5 p.m.
Macho.
Yes.
Let's, for picking up, they insist for grandparents. That may be restricted, please.
Let it be. After 2 weeks, we'll do it. Yes, 27.
My lord, they have not complied with that. Before this date, they had to pay that school expenditure.
No, they have not furnished any details.
He's
Okay,
ready
ma'am.
to do
Okay,
it.
ma'am.
Don't make it an issue at all. Yes.
27 Syed Umar.
For the petitioner, my lord.
Respondent.
My lords, the respondent had filed a CMS case in the family court, my lords. The family court had ordered 25,000 of interim maintenance. As of now, they have also filed a case, a DV case, my lords. There also, he has paid 2 lakhs, and here he has paid
So
50,000.
let's see. In DB case, how much is paying?
He paid 2 lakhs, my lords. 20 lakhs was ordered. He has currently paid 2 lakhs.
Hmm.
And here in the family.
Compensation. It is a compensation.
Yeah.
Ah.
And here in the family court, 25,000 has been ordered, my lords. He has currently paid 50,000. Currently, he is unemployed, my lords. So we have filed an IA for the stay in the family court.
Family court matter will not be stayed.
No, not the matter, my lords. For the interim maintenance, my lords.
This court has not
25,000.
considered that. No interim order is passed.
Lords?
No interim order is passed by this court.
No.
This will be passed only on the condition of some amount. What is the amount he is ready to pay?
He's ready to pay 10,000 per month.
My lord, submission.
Children and both the
No, no children. my lord.
only wife.
Only wife.
My lord, submission. Para number 26 of his petition.
Hmm.
I further submit that the respondent had filed a case in Judicial Magistrate Court, and Honorable Court has passed an order, Criminal Miss 61/2021 on 5/10/2024 to pay a sum of rupees 20 lakhs as a composition, my lord, not an
What is the
maintenance.
compensation?
My lordship,
But how many will pay compensation? 12 lakhs, 20 lakhs?
20 lakhs, my lordship.
25,000? What
It
is
is source of income. Source of income is there. my
What
lord.
is there before the court?
My lordship, next paragraph, my lordship.
Hmm.
The trial court has failed to appreciate the fact that the petitioner's parents are old aged and they are suffering from many health issues. And petitioner is the only earning member and he should take care of them for daily needs and medical expenses, my lord. Here, my lordship, I have been cheated, my lordship.
Going to all
The
that.
petitioner.
Please tell the court what is the evidence on record with regard to his
My
income.
lordship, I have published, my lordship, the salary slip.
Where is
On
that?
page number 22 to 27, yesterday I had filed a objection, my lord, along with the document. my lord.
Have you served a copy on him?
Yes, sir. Yes, my lordship, I have sent through RPD, my lord,
There
objection.
is nothing here.
I received the
Fine.
copy just.
It is submitted that the respondent has filed his objections. The registry is directed to place the same on record. This is the
One of the copies
matter.
has been served, my lord.
This is the matter on 18th, and a copy of it is served on the counsel for the petitioner before this court.
Case number 28,
Yes.
Shortcut maybe.
18-9, sir.
Yes.
Case number 28, we are Balraj. Bento Isaac.
Yes.
They represent the petitioner. The petitioner husband has filed the present writ petition challenging the direction issued by the learned family court In so far as, my lord, its direction, kindly go to, my lord, ink page 36.
40,000 is granted,
Huh.
which includes.
Regarding payment of maintenance and litigation expenses, I have no quarrel. Only, my lord, page 36, para 2.
Yes.
Petitioner is directed to pay 50% of the EMI of housing loan for the Kudlu house from the date of the application till disposal of the petition. Both the petitioner and the respondent wife jointly, my lord, purchased the site in question, and petitioner, by investing most of his private funds, my lord, by raising loan from the bank, they have constructed the house. 2 portions have been let out. And in one portion, my lord, respondent is residing. No, I am not residing there. Still the loan amount is there.
No, through how much amount you're getting by way of rent for the one portion you have let in?
Well, a total amount of the rent from, there are 2 tenants, total amount of rent is in assets and liability I had mentioned as 28,000. Current is 25,000, my lord.
25,000. What is the EMI?
EMI currently is 44,000.
So 44,000.
50% comes to 22,000. We are only asking for 22,000 from his side as per the orders. My lord may kindly consider he is not paying any amount for the maintenance of the Kudlu property. Kudlu property, if we see there will be a tax paid receipt, water charges, electricity charges, all the things in a common. I am talking in a common. He is not paying a single penny on that. And even if we consider the rent amount, my lord, rent amount keeps on fluctuating. Default, it can't be considered as a stagnant amount, which we can consider for the payment of the EMIs. My lord, I will continue after, if he wants to continue, I'll continue.
It appears to be a reasonable order. No, if court didn't ask you to pay the entire one.
My lord, the rent, my lord,
That she will, her part of it, she would be paying it.
my lord, that amount, if that amount is, my lord, deducted, whatever EMI, my lord, is there, out of 42,000, my lord. 42.
No, it can be done this way also. 44,000.
42,000, if I am correct.
44.
44,000. Half of it would be 22,000. Whatever now that rent you are receiving, if that is paid towards the EMI, it is paid towards the EMI. So the remaining would be 22,000. Pay half of it, both of you, because already court had granted 40,000 maintenance.
He is giving that 40,000 maintenance for the educational expenses and the extracurricular activities of 2
That
children.
we are not challenging.
What are you doing?
I am also in additionally taking all the care of the other needs of the children. I am also
No,
paying,
what
my
are you
lord,
doing?
from
I'm
the
asking
rent
what is your
amount, my
income?
lord. I have
What is your
mentioned
income?
my income is 1,50,000, my lord.
1 lakh?
50,000.
Annexure L, assets and liability.
What is the income of the husband?
My lord, as mentioned in his assets and liability, and as considered by the honorable lordship of the family court, it is 2,45,000, which is mentioned, which is the false statement, which I will come if my lord takes annexure F. Annexure F, if my lord takes at page number 130. At page number 130, my lord, last 4th entry of writ petition. Funds transferred, it is a salary account from TH Works Technology, dated 29/8/22. It shows that 3,214 rupees is been earned by him. Now, my lord, kindly take at page number 151, my lord, and it's assets and liability of this, of the petitioner, where he carefully suppress the amount to be 2,49,000 only. After all, and after all deduction, he gets only like 1,61,000 or something like that. He is mentioning.
Page 151, I have stated. 2,41,000.
49.
2,49,000. Page
Rather,
151.
My lord, kindly see why I'm saying this.
We are not disputing the payment of maintenance and litigation.
When you're earning much better than the wife, then
My lord-
whatever the contribution that has to be, it should be proportionate.
My lord,
For the children,
she is
not
also
for the
earning.
em-
She is also, she is,
So even if it is accepted, 140, 250, there is a difference of 1 lakh. So in contribution to the EMI also, because both of you are joint owners.
now she is receiving a rent and my lord, she has raised an OD of 2,50,000.
Now, this order of the family court,
She is residing there.
no, she
I am residing in a rented house.
how much, that's what the minor children of the respondents are entitled, 2 children are there.
Please.
Maintenance of 4,000, which includes education.
They are staying in parents' house, in her parents' house.
Extracurricular expenses from the date of application till disposal of the petition.
That we are not.
What are the educational expenses of the children?
My lord, school fees is around 80,000.
80,000.
So, and other expenses like extracurricular expenses and everything I had stated in my.
It comes to
around 1 lakh plus 1 lakh, around 2 lakh we can consider 1,77,000 or something I had mentioned in
But
my.
why did the court say like only 40,000 to be paid by you?
That it's
But 40,000 they have not challenged.
Educational expenses of the children.
Whatever is there, I am directly paying to the school.
No, proportionately it should be paid by the parents basing on their income, isn't it?
Entire school expenses I am ready to bear, I am bearing.
No, it's only 40,000.
And now it is an order, but monthly, my lord, 40,000.
It's monthly 40,000.
Monthly 40,000.
Towards extracurricular activity and.
So it is
Around
40,000.
5 lakhs. Around 5 lakh, nearly 5 lakhs.
Monthly expenses around 1
Plus
lakh.
4 lakh 80,000.
80,000.
You're telling about the monthly expense of 1 lakh. How can it be
How
monthly?
can-
Expense, my lord, for 2 children's medical expenses.
How can
Other
it be?
all the expenses,
School
my lord, I have
expenses, you have
quoted
to-
the school
No,
fees
school expenses should be per annum.
per annum. Correct.
So how much?
I will produce the materials if needed.
My lord, on kindly come to page number 71 where I have quoted all the expenses. They have already produced that
Let's see.
amount.
70?
My lord, as far as this maintenance amount, nobody has a challenge on that. The current amount is EMI. I would like to highlight where their contentions are very clear that I had taken the overdraft.
Whether
of
they
the-
have raised or not, for arriving at a just conclusion, what is the contribution of both the parties? I have to understand it.
My lord, can 20,000 rupees monthly expense for per children is enough for.
Let us see, what is that it is coming
Yes,
to?
please, please
It is
come to
4
page
lakh
number
80,000
70.
per annum. That is what it comes to.
Yes.
So what are the educational expenses per annum to the children?
Currently, it is 40,000. Page number 71.
So 40 plus 80.
80.
80 is the annual expenses of the children's school.
Yes, per annum.
Then
And the school uniforms.
where is
bags,
that, which page number you have stated all this?
Page number 71 of their writ petition, ma'am.
71.
17,000.
So you said 1,17,900 per one child.
Per month.
1,79,000. This is
For two
it's
children.
an annual income.
2 children.
For two-
Annual
Two children.
monthly.
For 2
Two
children.
children's, my lord.
No, it's a yearly expenses.
Monthly expense for 2 children's.
School fees, school uniforms, everything monthly.
Comes to the, that is, okay, that we can consider as an annual income, my lord. But average, we can say food, cook, expenditure, all that things, the honorable lordship had considered and assessed and everything was discussed.
No, you are happy with it because honorable lordships have considered. They are not, they are unhappy. I have
They
to
are unhappy
consider.
only for 50% EMI, my lord.
Yes. So shall I pass an order that they will pay
No,
only
my lord,
if I
there
don't want
are
if you do not want me to look into other aspects, I will say that 22,000 already you are getting from that. Minus that,
No, my
whatever
lord.
is the amount,
There
50,
is the questions of raising the EMI quantum. The question is only for the EMI. EMI is, we are stating is 44,000 and he is saying that as I am getting this 28,000 of the amount and as I have taken the overdraft of 2,50,000, I should not, he should not pay. And the calculation for him is like this, my lord. I would like to state that EMI he was paying was 41,509, which he was paying. He says that from 2016 to February 2023 he is paying up to 41,509. My lord, I will take annexure F for showing that how much my contribution also is there. Then rent minus 28,000, then it amounts to 13,509 divided by 2 is 6,754. That is what their claim is. But my lord, they have very carefully suppressed the fact that the overdraft of mine, 2,50,000, has came out only after the desertion, his desertion. That was also when I was left with no money or nothing. He had taken everything with him, and I had an extreme necessity. That's why I had to take an overdraft facility of 2,50,000. But prior to me, he has taken 32,12,000 overdraft facility, and for that purpose, the quantum amount of the EMI has been increased. Is not shown in the by him. He has very carefully suppressed that. He has taken an overdraft facility of 32,12,000. Why should I be burdened for paying that interest on that overdraft facility? And one of the overdraft facility has came up only after he left me. That is 1,77,000. Why he is not bringing that before the picture? It is on 19 December 22. On October 10th 22. 22nd October 22, he had left us alone without any means. It was because of me I was taking care of my children and myself. Now, my lord, I will come to annexure R3, my lord. Annexure R3 filed by respondent, my lord. At page number,
We'll continue after lunch.
23, my lord, 41,000.
Continue after lunch. Yes.
My lord, serial number 31, my lords. I appear for the respondent. I'll file my statement of objections, my lords. Kindly have it in the next week, my
Object
lords.
the adjournment, my lord. Senior will be coming. We need to argue the matter. Kindly pass it.
31. Grateful, my lords.
November की date को दिन date को देखो.
November. That is serial number 20. 1711. 1711.
ಲೀಲಿ
Sir.
ಒಂದು TCR ಬೇಕಾಗಿತ್ತು. TCR ಬೇಕಾಗಿತ್ತು. ಮೇಡಮ್ ಮೇಡಮ್ ಅಲ್ಲಿ ಫ್ರೀ ಆದಾಗ ಒಂಚೂರು ಮೇಡಮ್.
ಏನಾಯ್ತು ಇದು ಲಾಸ್ಟ್
ಎರಡು ವಾರ ಅಷ್ಟೇ ತಿರುಗಿ ಇಲ್ಲೇ ಬರ್ಬೇಕಲ್ಲಪ್ಪ 17-18 ಬರ್ತೀವಿ. ವೆಕೇಶನ್ ಕಳೆದು 8ನೇ ತಾರೀಕಿಂದಲ್ಲ 8ರ ತನಕ ವೆಕೇಶನ್ ಇದೆಯಲ್ಲ ಒಂದು ವಾರ.
ಮೇಡಮ್
ತಂದು ಅಲ್ಲ ಅಂದೇಳಿ ತಂದು
Court officer. Court officer.
ನಾ ಕರೆಕ್ಟ್ ಆಗಿದ್ದೀನಿ ಅನ್ನೋದಕ್ಕೆ ಹಾಕತ್ತಾರೆ ಬರೀ ಇನ್ನೊಂದೇ ಬಂದ್ಬಿಟ್ಟು ಎಲ್ಲವ ಯಾಕೆ ಬರ್ತೀರಾ ನೀವು?
ಏನ್ ಫಸ್ಟ್ ಏನ್ ಹೇಳ್ರಿ ತಿನ್ಬೇಕ ಬೇಡ ಡಿಸೈಡ್ ಮಾಡ್ಬೇಕು.
ಬಿಸಿ ಬೇಳೆ ಬಾತ್ ಖಾರ ಖಾರ
ಯಾವ ಯಾವ ಮೂಲೆಗಿದು ಯಾವ ಮೂಲೆಗಿದು
ಏನು
ಒಂದಂದ್ರೆ 1/4 kg ತತ್ತೀನಿ
1/4 kg ತತ್ತಾರೆ
ಹೇಳಿ ನಾನು ತರಲು ರೆಡಿ ಹೋಗಿ
ಬಿಸಿ ಬೇಳೆ ಬಾತು ತಗೊಳ್ಳಿ ಹೋಯ್ತು ಖಾರ ಬೇಡ ಬರ್ ಸಾಕು ಖಾರ ಕೊಡಿಲ್ಲ ಎರಡು
ನೀವು ಹೇಳಿದ ಎರಡೇ
ಬೇಡಲ್ಲ
ಇಷ್ಟೊಂದು ತರಬೇಡ ಪ್ಲೀಸ್ ಹೇಳು ಏನು ತಿನ್ನೋದು ವೇಸ್ಟ್ ಆದ್ರೆ ಅಕಸ್ಮಾತ್ ನಾವು ಬಿಸಾಕೋದಿಲ್ಲ ನೀವು
ಏನ
ಬಿಸಾಕಕ್ಕೂ ಆಗಲ್ಲ ಅದನ್ನ
ಜಾಸ್ತಿ ಆಯ್ತು ಈ ನಾಳೆಯಿಂದ ಕಡಿಮೆ ತಗೊಂಬರಪ್ಪ
ವೇಸ್ಟ್ ಅಂತೂ ಮಾಡಕ್ಕಾಗಲ್ಲ ಅವ್ರು ಕನ್ನಡ ಬರಲ್ಲ ಕೇಂಬ್ರಲ್ಲಿ ಯಾರು ಕನ್ನಡ ಒಂದೇ 4 ಗಂಟೆ ಬಂದ್ರು
ಗೊತ್ತಾಯ್ತಿಲ್ಲ
ದೊಡ್ಡ ಮಾಡ್ತಾರಲ್ಲ ಬರೋದು ತಿಂಗಳು ಓಕೆ ಏನೋ ಸಮಯದಿಂದ ದೂರ ಎಲ್ಲ ಬೆಳೆಸಿಲ್ಲ ಮತ್ತೆ ಕೇಳೋದಂತ ಒಳ್ಳೇದಾಗ್ಲಿ ಅಂತ ಹೇಳಿ ನೀವು ಒಳ್ಳೇದು ಅಂದ್ರಿ ಆಮೇಲೆ ಒಳ್ಳೇದಾಗ್ಲಿ ಹಂಗೂ ಮಾಡಿಲ್ವಾ
ಮಧು ಇದರಪ್ಪ ಮನೆಗೆ ಹೋಗ್ಬೇಕಾಗ್ತದೆ ಬಂದ್ಬಿಡ್ತಾರೆ ಹಾಕೋ ವಿಷಯ ಸ್ಟಾಕ್ ಅದ್ನೇ ಹೇಳಲ್ಲ
ಹೇಳ್ತಿಲ್ಲ ಅದು ಎಷ್ಟು ಅಂತ ಹಾಕಿರೋದು ನಿಮ್ಗೆ ಇಲ್ಲಿದೆ ಜಾಸ್ತಿ ಇತ್ತು ಎಲ್ಲ ನಾವು ತಿನ್ಬಿಟ್ಟಿವಿ ಇಲ್ಲಿ ಕೊಡುವ
ನಮ್ಗೆ ಗೋಂದಿ ಕರ ಬರ್ಲಿಲ್ಲ
ಅದು ನಮಗ್ ಮಾತ್ರ ಏನ್ ಪ್ರೀತಿ ಅಲ್ಲ ಮೊದಲು ಬಂದ್ರೆ ಬಟ್ರಿ ಯಾಕೆ ನಕ್ಕರಿ
ಊಟ ಮಾಡುವಾಗ ನಗಂಗಿಲ್ಲ
ಬೀದಿಗೆ ಬಂದ ಭಗವಂತ ಅನ್ನ ಹಂಗೆ ಮನೋರ ಚಂದ್ರ ಬಂದಾಗ್ಬಿಟ್ಟು ನಾನೇ ಮಾತ್ರ ಬೀದಿಗೆ ಬಂದ್ಬಿಟ್ಟೆ
ಸರಿ ಊಟ
ಟೊಮೆಟೊ ಬಜ್ಜಿ ಕಷ್ಟ
ಭರತ್ ಈ ಮೀಟಿಂಗ್ ಅಲ್ಲಿ ಅವನು ಇಷ್ಟೊಂದು ಅವನು ಹೇಳಿದ್ನಲ್ಲ ಅಷ್ಟೊಂದು ಮಾತಾಡಿದ್ನಲ್ಲ ನೆಕ್ಸ್ಟ್ ಬಂದ್ ಜನರಲ್ ಮಾಡಿ ಮೀಟಿಂಗ್ ಅವ್ರ ಜೊತೆ ಹಾ ನೋಡ್ಬೇಕಾರೆ
ಮೇಡಮ್ ಒಟ್ಟೆ ವೈರ್ ಬಸಿಕ್ಕಿದೆ ಅಲ್ಲ ಗೊತ್ತಾಯ್ತು ನಿಂತು ನಿಮ್ ಮಾತ್ರ
ನೀವು ಸುಮ್ಮನೆ ತಿನ್ನಲ್ಲ ಹೋಗಿ ಅಲ್ಲಿ ಇದು ಮಾಡ್ತೀರ ನಿಮ್ಗೆ
ಡೈರೆಕ್ಟ್ ಆಗಿ ಕೇಳ ನಾನು ಎಲ್ಲಿಗೂ ಬೇಡ
ಸೂಪರ್ ಮಾಡೋದು
ಡಬ್ಬ ಯಾತಕ್ಕೆ ಸೌಂಡು ಮಾಡುತ್ತೆ
ಸುಮ್ಮನೆ ರೇ
ಏನೋ ಹಾಡೆಲ್ಲ ತಂದ್ಬಿಟ್ಟ
ನಿಮಗೆ ಯಾಕೆ ಮಾತಾಡ್ತವ್ರೆ
ಏತಕ್ಕೆ ಮಾಡಿತ್ತು
ಯಾವ ಮಂದಿಗೆ ಗೊತ್ತು
ನನಗೆ ಎಲ್ಲ ಕೇಳ್ಕೊಂಡ್ಬಿಡ್ತು ಅದನ್ನೇ ಬೆಳಗ್ಗೆ ಸಂಡೆ ಹೋಗಿ ಮುಂದಕ್ಕೆ ಆಡೋದು ಹಿಂದಕ್ಕೆ ಆಡೋದು ಮುಂದಕ್ಕೆ ಹೋಗೋಣ ಬಿಟ್ಟು ಬೇರೆ
ನಾನು ಬೆಳಿಗ್ಗೆ ಹೊತ್ತು ಕೇಳೋದೇ ಇಲ್ಲ ಕಣ ನೀವೇ
ನೀನೇನು ಬೆಲ್ಲ ಕೇಳ್ತಾ ಬೆಲ್ಲ ಬಿಟ್ಬಿಡು
ಮಾತೇ ಕೇಳಂಗಿಲ್ವಲ್ಲ ಈಗ ಏನಂಗೆ ಮೇಲೆ ಬಿಡ್ತಿರಲ್ಲ
ನೀನ್ ಅವತ್ತು ಕಾರಿಡಾರ್ ಎಲ್ಲ ಹೂವಾರಿ ಅಂತ ಹೆಂಗ್ರಿ ಅಂದೆ ನೀನು ಹೂವಾರಿ ಅಂದವ್ರಿಗೆ ಹೆಂಗ್ರಿ ಮಾತು ಕೇಳ್ತಾರೆ
ನೀನ್ ಏನಂದೆ ಅದಕ್ಕೆ
ನಾವೇನು ಆಯ್ತು ಟೈಮ್ ಬರುತ್ತೆ ಹೇಳ್ತೀನಿ ಅಂದೆ
ಅಲ್ಲ ನೀವೇನು ಮಾತಾಡ್ಲೇ ಇಲ್ಲ ನೀವ್ ಮಾತಾಡಿದ್ರೆ ಹೂವಾರಿ ಅಂತ
ಇವಾಗ ನೀವು ನೀವು ಪದ ಬಿಟ್ಟು
ನೀನು ಇದ್ದೀಯ ಜೊತೆಗೆ
7 ಗಂಟೆಗೆ
ಒಂದಕ್ಕಿಂತ ಜಾಸ್ತಿ ಇದ್ದೇಗೆ
ವಿಪದ ಅಲ್ಲ ಬಹುವಚನ
ಒಂದಕ್ಕಿದ್ರೆ
ಒಂದಕ್ಕಿಂತ ಜಾಸ್ತಿ ಇದ್ದಾಗ ವಿಪದ
ಬಹುವಚನ ಒಬ್ರು ಇದ್ರೆ ಏಕವಚನ
ಯಾರು
ಕನ್ನಡ ಲೆಕ್ಚರು
ಹೇಳ್ಕೊಟ್ಟಿದ್ರೆ ಹೇಳೋದಲ್ಲ
ಕನ್ನಡ ಲೆಕ್ಚರು ನೀರ್ ತಗ ಈ ಕಡೆಗೆ
ಅಯ್ಯೋ ನೆನ್ನೆ ಸಿಗಾಕಬಿಟ್ಟಿದ್ದಲ್ಲಪ್ಪ
ಹೈ ನೀರ್ ಕೊಡ ಬರೀ ಅಂತ
ನೆನ್ನೆ
ಎಲ್ಲಿಂದ ಬರ್ತೀರ
ಕಪ್ಪು ಚುಕ್ಕೆ ಅನ್ನೋದು ನೀವ್ ಹೇಳ್ಬೇಕಾಗಿಲ್ಲ
ನೋಡೋಣ ಇಲ್ಲಿ
ವಿಡಿಯೋ ಹಾಕ್ಬಿಟ್ಟ ಏನೋ ಬರ್ಬಿಟ್ಟಾಗ್ಬಿಟ್ಟು ಕಪ್ಪು ಚುಕ್ಕೆ ಕೆಂಪು ಚುಕ್ಕೆ ಬಿಳಿ ಚುಕ್ಕೆ ಬೆಳ್ಳಿ ಯಾರೋ ಒಬ್ರು ಡಿಸೈಡ್ ಮಾಡೋದಲ್ಲ ಜನಗಳು ಡಿಸೈಡ್
ಕೂಡ ಕಡಿಕೆ ಆಯ್ತಾ ನಿಂದು
ಹೋಗ್ಬಿಟ್ರಲ್ಲ.
ಇರ್ಲಿ ಬಿಡಪ್ಪ, ಇರ್ಲಿ ಬಿಡು, ಇರ್ಲಿ ಬಿಡು,
ದಾಖಲೆ ಕೊಡಲ್ಲ. ನಾಳೆ ಸೇವ್ ಮಾಡ್ಕೊಬರ್ತಾರೆ ಪಕ್ಕ ಟ್ಯಾಬ್ಲೆಟ್ ಹಾಕೊಡ್ತೀನಿ.
ನೋಡಿದ್ರು ಸಾಹೇಬ್ರು ಹೋಗ್ಬೇಕಾರೆ.
ಇಲ್ಲ ಇವತ್ತು ನೋಡು ನಾಳೆ ಕರ್ಕೊಂಡ್ತೀನಿ ನಾನು.
ಆಯ್ತು ಆಯ್ತು ಆಯ್ ಭಟ್ರ ಐ ಡೋಂಟ್ ನೋ.
ಲೆಕ್ಕ ಆತರ ಮನೋರ ಬರ್ದಿರೋದು ಯಾವ ತರ ಅರ್ಥ ಮಾಡ್ತೀವಿ? ಓಟ್ ಹಾಕಿರೋ ಅರ್ಥ ಅನ್ಸುತ್ತಾನೆ.
ಓಟ್ ಹಾಕಿರೋರು ಅಲ್ಲಿ ಕೊಡುವವರು ಕೊಡೋರು ನೀವೇ ನನ್ನ ಮುಂದೆ ತಂದಿರೋದು ಅಂತ ಹೇಳ್ತಾನೆ. ಕನ್ನಡ ನೀನ್ ಹೇಳೋ. ಇದು ಪುಣ್ಯ ಕೊಟ್ಟಿದ್ದು ಅನ್ನ ಸಾಂಬಾರ ಅದು ನೆಕ್ಸ್ಟ್ ಪುಣ್ಯ ಕೊಟ್ಟಿದ್ದಾರೆ. ಪುಣ್ಯ ಕೊಟ್ಟಿಗ ವೇಟಿಂಗ್ ಕೊಡಬೇಕಲ್ಲೇ. ನಿಜ ನಿಜ
ನೀರು ಕೂಡ ಹಂಗೆ
ಇಂಡಿಪೆಂಡೆಂಟ್ ಆಗಿ ನಿಂತ್ಕೊಳ್ಳೋದು.
ಎಣ್ಣೆ ಖರ್ಚಿಗೆ ಎಲ್ಲ ಸಿಗುತ್ತೆ.
ಪ್ರೂಫ್ ಐತೆ
ಸಿಗುತ್ತೆ ಅಂತಲ್ಲ
ಓದೋರ್ಗೆ ಎಷ್ಟು ಐಟಮ್ ಗೆಲ್ಸ್ಕೊಡಿ ನೀಟಾಗಿ. ಅನ್ನ ಸಾಂಬಾರ್ ಗೆಲ್ಸ್ಕೊಡಿ. ನೋ ಅನ್ನ ಸಾಂಬಾರ್ ಬ್ರೋ ಮಕ್ಕಳು ತುಂಬ
ನೀವು ಬೇಕಂದ್ರೆ ಮಕ್ಕಳು
ಅವರು ಪಾರ್ಟಿ ಮಾಡೋದು ಹುಡುಕರೇ ಅಲ್ಲ ಸರ್ ಇಲ್ಲ ಎರಡು ಕಡೆ ಕಿತ್ಕೋಬೇಕು.
ಈಗ ಹೇಳಿಲ್ಲ ಅಂದ್ರೆ ಕೊಟ್ಟಾಗ್ತೇನೆ. 30ನೇ ಇಸ್ವಿ 4ನೇ ತಿಂಗಳು 31ನೇ ತಾರೀಕು ಇರೋದಿಲ್ಲ. 4ನೇ ತಿಂಗಳು
Sir.
Yes, continuation.
Serial number 28. Page number 1.
Per annum. Hmm. Hmm. Hmm.
May make one alternate submission. If both of us file, my lord, memo of calculations, that may make things easier. So that
Both the parties shall place before this court specifically their income and the expenses. And with regard to the mother, what are the expenses of the children? Basing on that, orders will be passed by this court. When can you file?
1 week, 1 week,
List on 25th.
please.
Yes,
Serial
next.
number 29 at 10:30. Serial number 30, Bindu U, for petitioner. Arvind Kamath.
This is father's petition seeking interim custody of the minor daughter, my lords. Both of the husband and wife, they are hailing from Mysuru, my lords. They got married in the year 2010 and child was born in the year 2015, my lords.
So there are two petitions. One
Yes,
is
ma'am. So
18425 is arising out of.
that is arising out of MC, my lords, wherein an application for interim custody of the minor child has been filed, which has been rejected by the trial.
Then next one.
The second one is arising out of GNWC petition, wherein similar application has been rejected by the trial court, my lords. In the MC petition, my lords, it has been rejected.
Having already filed an application GNWC, then what is the significance of this IA?
Yes, my lords, I will bring to your lordship. The MC is filed in the year 2021, my lords, by the wife.
Whatever is the year.
Wherein
Now two
father
applications
was-
are filed, two orders are passed.
Yes, yes, my
Either
lords.
of it you have to forego.
Yes, this
No, I'll
application.
say, in view of the application that's filed in the GNWC, I will dismiss this, I'll confirm this order by dismissing your application. And the next one in GNWC, we'll hear it.
Both, my lords.
Yes.
Yes.
Where is the order?
In GNWC, my lords, 19382, that is the second petition, my lords.
No, I'm looking at 18425.
18425.
Where
That
is
is the
included?
petition arising out of the MC.
Yes, this we will discuss.
This is the MC petition filed by the wife, wherein application has been filed on 25/11/24, my lords. Objection has been filed on 7/12/24, and orders has been passed only on 1/4/25, my lords. Since the father was not getting any access to the minor child, successive application has been
So
filed
that's
in.
what the court was right. Hence, this court has come to the conclusion that the respondent has made for sufficient allow the application filed by and so and so. Further, this court is of the opinion that the custody rights of the child will be decided in the exclusive petition.
Yes, my lords. Please.
Filed, and so we'll confirm this order. Agreed with the orders passed on I number 13 to 15. In MC number 532 of 2021, the father is before this court. The father has filed I number 13 under section 151 of CPC seeking custody of the child. Custody of the children during summer vacations April 2024. And I number 14 filed under Order 39 Rule 1 and 2 of CPC seeking for grant of temporary injunction restraining the mother from shifting the residence of the child. And I number 15 is filed under Section 26 of the Marriage Act seeking custody of the child from the respondent. The court by order imputed and dismissed all the IAs, observing that already GNWC number 23 of 2024 is filed with the father, which that petition, GNWC, which is filed exclusively for the rights of the pertaining to the children. All these applications will be decided by the court and dismiss the application. Learned counsel appearing for the petitioner submits to the court ought to have considered this application. Even in the MC proceedings also, court can consider the application for visitation. Next para. Learned counsel for the respondent has submitted by supporting the judgment of the court in that is order impugned. Next para, having heard the counsels for instead material on the court. When GNWC is filed, already certain applications were filed in that. Now, considering these applications by the court is not necessary. The submission of the learned counsel that even in the MC proceedings also these applications can be considered. There is no dispute about that. But in the light of the fact that already GNWC is pending and already applications are moved in that, this court finds no reasons to interfere with the order passed by the family court, accordingly dismissed. Give the next.
As regard to the second petition, my lords, WP 19382 of 2025. This is arising out of the GNWC petition where father had filed an application seeking entry custody of the minor child, my lords. In this case, the trial court by impugned order vide annexure A, my lords.
Point 1. Same. There is another petition.
Impugned order vide annexure A, my lords.
Page number?
Page number 18, my lords. The reasoning comes. Start from page 23, my lords. In that relevant para, my lords. Para 9 onwards, my lords. On the other hand, respondent opposed the application of the petitioner, contending that petitioner has exercised visitation rights of the child as per order of this honorable court dated 5/2/2022 in MC number so and so on all Sundays between 10 to 1 p.m. and between 10 a.m. to 2 p.m. as extended between them by filing a memo dated 23/2/2024 before the court in MC 532 of 2021, except the Sundays when the child was sick and out of station. The petition never visited the child for a period of more than 2 years before filing of MC 532 of 2021. Thereafter, my lords.
Come to para 10.
Same para, my lords.
10.
10, my lords. It is to be noted that this court by order dated 5/2/2022 passed in MC 532 of 2021 had already granted visitation right to the petitioner hearing to visit the child on every Sunday between 10 a.m. to 1 p.m. Subsequently, on 23/2/2024, both the petitioner and the respondent herein have filed joint memo before the court in MC 532 of 2021 and thereby got increased the visitation hours from 10 a.m. to 2 p.m. instead of 1 p.m. on all Sundays. It is also not a dispute that the respondent herein had shifted her residence along with the minor ward to Hubballi on account of her job by filing a memo dated 15/4/2024 in MC number 532 of 2024 before this court intimating the same. It's also to be noted that when the petitioner hearing has filed present application, advocate for respondent submitted that respondent has no objection for the petitioner to make a WhatsApp video call and speak with the child for reasonable amount of time between reasonable hours since the child is staying at Hubballi, which is far away from Mysuru. The petitioner has not, this is the reasoning what has been given by the trial court, has not clarified in this application whether he is exercising his right of visitation of the child by going to Hubballi after the respondent had shifted her residence to Hubballi along with the child. Further, petitioner has not stated any special reason as to why he wants interim custody of the child, that too when the child is staying far away from Mysuru. It's also to be noted that minor child is of 8 years old and studying at a school in Hubballi, and if the petitioner is ordered to be given interim custody of the minor child, it will be difficult for the child to adjust with the new atmosphere. Further, the child never stayed with the petitioner from her young age, and that may be again difficult for the child to adjust
by
with
way
the
of this
petitioner.
application, what do you want?
My lords?
What do you want?
Father is requiring an interim custody of the minor child. The last visitation was on May 2024, my lords, during which time in the April, she has filed a memo before the trial court stating that she shifted her residence under the guise of an employment from Mysuru to Hubballi, my lords. In Mysuru, they were residing almost in nearby area. Father was exercising visitation rights, and there was very good relationship between the father and child. But the moment she finds that there is a close relationship, a bonding is growing up between the father and the daughter, my lord, she, by filing a memo, she shifted her residence, and thereafter disconnecting all possible ways, not attending the mobile numbers, calls, video calls, whatever is there, and the address what has been, and thereafter she files a transfer petition seeking transfer of the very same petitions what has been filed by her at Mysuru to Hubballi, my lord. That has been dismissed with the direction that that has been disposed in a time-bound manner, my lords. Now the time has been extended till end of this year, my lords, and during which time no connection with the minor child at all. There are grandparents also with the father. He is not in a position to go to Hubballi because first of all, there is apprehension that during the mediation of these two cases, MC and CMAs,
question of giving the custody of the child at this point of time will not arise. If you want to go to Hubli and you want to exercise the visitation, we'll think about it.
my lords, first of all, she has not clearly given the address. She has given
That
care
can-
of some
that can be
person.
taken care of.
Secondly,
Now-
there is a threat of filing false criminal cases and all against him. And for
can't
him
help it.
also, aged parents are there.
We
And
can't help them.
he has to travel from Mysuru to Hubballi, my lords. And he has to come back. Even the grandparents also, they are having a very good bond. I have all the photographs were in
Photographs are required. Where the maternal grandparents stay?
Mysuru only. Both of the permanent residencies at Mysuru. She left the place and now shifted to Hubballi under the guise of an employment. Even at Mysuru, she was residing.
Why not the child on holidays come to Mysore to the maternal grandparents' place, and why not the father exercise the visitation in Mysore?
In Mysore, because they are staying currently in Hubli, my lords.
No, I'm saying in a vacation.
I'll just talk to, and maybe
This 20th is the birthday of the minor child. When? 20th of this month, next week, my
it's
lords.
important that
And
both the
coupled with
parents
the
can.
Dasara holidays.
October.
September, my lords. Coupled with the
20th of
Dasara
September.
holidays, my lords.
It happens to be a Saturday.
Yes, my
But
lords.
that day you can go to
And
Bangalore.
so far as
This is coupled with the Dasara holidays, 22nd onward school holidays, I came to know,
Please
so
find
that the
out.
child can be.
The council for the respondent shall get specific instruction. When are the school holidays? The entire calendar of the holidays of the child shall be placed before the court. And further, on holidays, whether
my lords, will this be okay that my lordship can also talk to the child once, because that may really make some
Years
difference.
old,
It's
but
in
she
8 years,
can't
9 years now.
let's see, first of all,
9
let
years,
exercise
because
visitation
she's
go
been
on.
always since beginning. We have no objection on as such for a visitation right. I've got employment and hence I've gone to Hubli. I'm earning 25,000 and
Nobody is
Yes.
saying you to come back to Mysore.
yes.
Now your parents also stay in Mysore.
Yes.
If you don't believe in him, at least you believe in your
No,
parents.
question that does not arise, my
So
lords,
you
because
send them to your parents.
yes, my lords.
She'll exercise the visitation
Even
during the vacation.
even during when they were in Mysore also, they never expected that the child be in their custody. They only came during the visitation time.
When can you get these instructions? This is the matter on 23rd. 23rd.
My lords, on
20th is the
23rd, I'm
birthday,
not there
my
in
lords.
station, my lords. On
20th is the
19th.
birthday of the
Maybe
child.
first week of October, my lords.
No, my lords.
19th.
My lords, on 19th, I'm going out of station. Maybe again 16th or
18th
17th, my lords.
16th.
16th. Yes,
Yes,
my lords.
next.
Serial number 31.
Yes,
Pratima
31.
SK for petitioner Madhu or
This is the matter where your lordship had intervened in the chambers and the respondent had not, and was of the opinion that the visitation should be in front of the counselor in the Karnataka Mediation Center.
Yes.
Please, my lords, every Sunday.
Where is the order?
Well, it's impugned order is at page 63, my lord. 68 is the operative portion. I would come to the last page. Well, it's the last page, in page 68, my lords. The petitioner father is permitted to meet the child on every Sunday from 10 a.m. to 5 p.m. and he is permitted to take the child with him to the park or the shopping mall by keeping the point of security to the child.
We'll keep this pending. Let the father have the visitation in the mediation center. Let the counselor place a report before this court. Basing on that, we will.
Please, my lords, please. I have no objections.
Agreed with orders passed 9 number 8, whereby the father is permitted to meet the child on every Sunday from 10 a.m. to 5 p.m. and he is permitted to take the child with him in the park or shopping mall by keeping the point of security to the child. That order is questioned before this court. This court had interacted with the parents as well as the child. After interacting with the parties, this court is of the view that the visitation can take place at the mediation center. Hence, until further orders, this court deems it appropriate to modify the order impugned. Next, on Saturday.
Plus Saturday, let it be after 3 p.m. because the child has school on that day also, or
Saturday,
after 4 p.m. also. my
On
lord.
Saturday, between 3 to 6.
4 to 6 minutes to start with because it's before the counselor, 2
Between
hours.
4 to 6, the father can exercise the exclusive
Plus should it be
exclusive visitation in the presence of the counselor. Mother shall not be present. The counselor shall place a report before this court basing on how the visitation is going on, what is the state of the mind of the mother, the child, and the father, and what is the bonding between the two. The father can exercise the visitation on September 13th, September 20th, lives this matter on September 22nd.
He is not available on September 30th. my lords.
Huh?
September 13th he is not available. my lords. He
No, I
stays in
didn't say
Mumbai.
13th, September 20th.
20th, my lords, please.
Oh, 13th is not available. So 20th and 27th. 27th is a holiday.
20th is third Saturday, not an holiday.
Fourth Saturday.
20th
But I
is
think
not
it is a working Saturday, if
Working-
I'm not mistaken.
20th is a working Saturday.
working Saturday. my lords.
Yes.
20th, and this is matter on 24th.
Grateful.
Grateful.
Your client is not understanding. He is completely in a kind of illusion.
Please, my lords.
And he is neither here nor there with that
I have
kind
also
of.
given the advice, my lords, but he is not ready to take it.
I don't think you can, the advocate can advise him. He requires some,
Please, my
he
lords.
should be sent to NIMHANS to correctly evaluate what is happening with him.
Lords, I'll interact this with him, my lords. I don't know what he think.
He says he doesn't want his wife. He will not give divorce now.
Please, my lords. I said,
He stays in Bombay.
Please,
It's
my
difficult for him to have the visitation, but still I'll continue. Something is thoroughly wrong with him.
My lords, I even suggested for the settlement, my lords, but he is like,
No, that's the problem. He filed divorce, isn't it?
Yes,
Please,
he
my lords.
filed.
And he
File in
says, no,
Mumbai,
I
my
will
lords.
not give divorce. Then we'll tell the court to let him withdraw that petition when he doesn't want. I'll record that he doesn't want divorce.
not now, my lords.
No, neither he's not living in peace or not he's letting other person live at peace. Yes, 32.
Serial number
Great.
34.
And if he fails to come and exercise the visitation,
On 20th, right?
we'll set aside that order and send it back.
20th, my lords.
No, if he fails to, yes,
Grateful, my lords.
yes, next.
Serial number 32. Vikas M for petitioner. Murthy DL.
Respondent.
No representation. This is matter for dismissal on 26.
Serial number 33.
Also, the respondent is present.
33.
Consider direction to pay the amount, my lord, within eight
And
weeks.
Mudappa.
Well, to this day, they have not paid any amount of the maintenance.
Where is the
And the
interim
very
order?
sentence, my lord, that I'm employed. What has been made submission earlier. She is not employed, they are aware of it.
Interim order is complied or not?
My lords, we still have 3 weeks time to comply. 8 weeks is the duration.
This is on 1/8/2025.
Yes, ma'am. Within 8 weeks is the order. my lords. 4 weeks.
Time is there.
Time is there.
For the arrears, 8 weeks.
One
Ma'am,
modification.
8 weeks was given, my lords. He has still not paid.
We still have 4
So
weeks.
8 weeks is not completed. It will complete in the month of October.
I'll take your lord. 8 weeks, no, 8 weeks are not completed.
Anyhow,
The implement order, my lord,
no,
pays
please understand, an order is passed let your client get the sum amount, we'll hear it.
Yes.
This is
One
matter.
small modification, my lords. I
What
mean,
modification?
on annexure J, my lords, had sought for withdrawing of the petition. That has been allowed. So in the interim order, my lords, it is only the arrears that I'm liable to pay.
No, you.
Can you look into the interim order?
You withdrawn the MC.
I withdrawn. It
Regarding
was
that, my
filed even
lord.
prior to the filing of this petition, my lords. It was pending consideration, and when this petition,
What remains to be adjudicated in this?
only the
Regarding
interim
that, the court has
maintenance.
made very,
No,
Only
what
the arrears
happens
on the
is-
interim maintenance.
No. Now what will happen is, what was the amount that is granted by the court?
15,000.
15,000 remains to be, because you withdraw the petition. When
Yes.
once the main petition is withdrawn, nothing to be considered in this. Till the date of withdrawal, from the date of interim application, they are entitled for the maintenance. They'll file a EP for that. Let us
Precisely, my
clarify.
lords. Though the interim maintenance order is challenged before this court, it's pending. After filing of this petition, that order was allowed, my lord. That order
When
was
is
passed.
that? That also we'll look at that.
Please.
Give that.
This is the order. 37, it was passed.
30?
37.
Then
But to
that is
avoid
37,
payment of
this
this,
is
my lords,
1/8.
they made
1/8.
an application to
So
withdraw.
that 15,000 only you have to pay.
The court has made clear that the amount should be paid.
Lords, but
And withdraw, the amount should be.
the assets and liabilities, what they have filed, there are prima facie false
When
statements.
once the main petition is dismissed as withdrawn, whatever the interim order, that comes to that.
Then
nothing
what
to be
remedy would
decided.
I have, my lords, to even question the interim maintenance?
But why did you sought for, the withdrawal
Lords,
of that?
because she's not ready to come back. And I have filed a petition for divorce. And that is pending.
Please come. The present writ petition is filed against an interim order where in a MC, where the family court had granted maintenance of an amount of rupees 15,000 by order dated 12/3/2025. The questioning the said order, when the writ petition is filed, it came up for before this court on 1/8/2025, and this court had reduced the amount from 15,000 to court had passed an interim order directing the husband to pay 5,000 per month to the wife by 5th of every succeeding month, and also the arrears at 5,000 within a period of 8 weeks. Today, when the matter came up, when counsel for the petition submits that, by order, he has filed a memo on 7/12/2024, and the court by order dated 30/7/2025 has permitted the husband to withdraw the MC. Now the main MC itself is withdrawn. Nothing survives for consideration in this petition. The court has awarded 15,000 as maintenance till the date the MC was dismissed as withdrawn. From the date of application till that date, the wife is entitled for maintenance. In view of the same, clarifying this aspect, this court finds no further reasons to entertain this petition. Accordingly dismissed. It is left to the wife to execute the order. Yes.
Number 34, final hearing. Govini Rajesh Rora for petitioner, Reshma Timaya.
For the petitioner wife, your lordships may kindly recollect that you called for LCR. My main point was that the assets and liability statement filed by the husband are two, and the second one also, the income tax returns are not filed. And even the copy which has been furnished by them here also does not have. It has merely acknowledgement of the ITR, one page of 2 years. That is in the trial court record, my lord. Here, what they filed is just the proof of filing ITR. 2.
The Minister Judiciary is directed to call for the trial court records by
Yes.
9. Where are they?
They have come. Two affidavits were filed by him. One was in May 23. The other one was in July 2023. Well, there is no discrepancy in what they have filed here and the trial court and what I have filed in the writ petition. It's all the same. The records are the same. So in May 2023, what he filed, he leaves his assets and liabilities blank of the income tax statements, amongst others. And thereafter, when we complain to the judge directs, the family court judge directs, and he files in 13th July 2023, one more assets and liabilities, where he says, yes, all returns filed, but he does not file, and he files only the acknowledgement of having filed an ITR where nothing is to be seen because it's an ITR 2 form. We don't even know what is his, not even form 16 is filed. Besides that, your lordship may recollect, I also pointed out one paragraph where he has divested the family home, the marital home, in the name of his mother, which was not there in the previous assets and liability statement. And then in the second one, he says so without giving the copy of the release deed. And many more points. My lord, my only humble submission is the assets and liability statement filed by him may kindly be directed to be filed the whole truth. Because how do I proceed with the divorce petition which I have filed, my lord? Because as per Honorable Supreme Court direction, if both, and I have filed mine in toto. So if in toto, if it is filed, then my lord, I will take it forward. I'm already at it is a stage of evidence. That's my humble submission.
No, why can't it tell you? For that, the lower court record has to be called by this court?
Because they filed
whatever it is that you can, for that purpose, the writ petition will not be, can't be entertained.
No, Milad, I have of course challenged the trial court
Then
record.
that's a different aspect.
That is a different aspect. I have also said that because he has lied and he has suppressed the materials, that he should be directed for criminal prosecution, all that. I have got number of prayers, my lord. But my humble submission is, the last time when we had partly argued the matter, this is where your lordship has been kind enough to call for the
then they have filed. According to you, it is not filed.
It is not filed. And
That's
therefore,
why
your
I've
honor.
asked them to, and that's why it's called for.
Yes, ma'am. To save time and labor, my lord, last 2 pages of his affidavit dated 13/7/2023. Last 2 pages, my lord. His affidavit of 13th July 2023. He has only 2 acknowledgement.
What do you do?
My lord, kindly see mine. It's in bounded volume, my lord, brown color bounded volume. Page 35. I filed the full acknowledgement, full return, I'm sorry. Kindly see from page 41 is my income tax return. Page 41 of that brown color paper book, which is my assets and liabilities. Page 41. Because I have been a housewife throughout. After separation, I attempted during COVID times to work, and that is the only return I have filed. Kindly see page 41 with the computation of income statement, acknowledgement, bank statements, capital account, P&L, as well as the deposits receipts, everything, my lord. I have declared everything. I have come with clean hands. They, my lords, have not filed. Then I complain. Then they are directed to file. After that, they play fraud upon the court. Plus, she's only been a BCom, 18 years of marriage. She has been a housewife throughout. After she has thrown out, she has tried and struggled to get one job in COVID. And that also to sell a particular product, they said, and the company only closed down. She was thrown out. My lord's maintenance order has been granted, my lord. My only humble submission is these. Yes, much obliged, much obliged.
Yes, file the income tax return verification form 2018-2019. Gross total income 31,26,967. Then for the year 2021, 48,90,867. Only these two documents are filed.
And my lord, kindly see in his para F7 of that affidavit, he says, yes, 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 after having forced upon him the honorable court.
No,
So
what are supposed to be filed?
the entire return, my lord, kindly see the form of the honorable Supreme Court. It says, if yes, 1 year prior to the marriage, 1 year prior to separation, and at the time of application of maintenance, where he says, yes, 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 it is written in the form. If yes, submit the copies of income tax returns for the period given. So the income tax returns, my lord.
Of which year, that you can tell the
Yes, my
court.
lord. In this particular case, in the facts of this
Yes.
case, it is 7/8, 2007 and 2008, and then it is 2009, 2010 and 2020, 21. Sorry, 2018, 19 and 2021.
2009, 2010.
2007, 8, 2018, 19, 2020, 21. 3
9,
years.
10 not necessary.
Well, no, no.
So 2007, 8.
Yes.
2018,
19.
that's already filed here.
Yes. No, my lord, that is not filed. That's exactly the point. That is only one proof of having filed. Where are the details? The return is in ITR 2, my lord. My lord, my return is ITR 1. My lord, when we file an income tax statement, it should have all the details. Where is his income from? Salary or form number 16 will be there. Annexures will be there. Profit and loss accounts.
2018, 19,
And 2021.
is sufficient.
Yes, madam. 3 years.
Yes.
He has not filed a
Yes.
single one.
Was this,
Please, my
as
lord.
per the judgment of the apex court.
Before my lord, touching the case on merit, I want to make some submission, my lord. This is a petition filed in the year 2020, my lord. For 1.5 years, my lord, she did not turn up, my lord. Now the case is ripe for evidence. Now no stay has been granted, my lord. Now I know my limitation as far as the interim order is concerned, my lord. Interim order, my lord, they will not go into deep into the matter. What is her income? What is my income, my lord? Only comparative statement, my lord. Thereafter, my lord, a direction may be given within 3 months could be disposed of. Only 2 witnesses will be examined. It will be closed, my lord. As far as I am concerned, my lord, while my lord granting interim order is concerned, prima facie matter will be looked into, my lord. It is not at this stage, my lord, could you look into whether to produce it or not.
Am I granting interim order? I'm
My-
going to dispose it off.
Please, ma'am.
I'm going to dispose of the petitions.
Please, ma'am.
So,
My
as per the
submission, my lord.
judgment, what are
Two
the
more
documents to be filed?
Two more
What
submissions
are
to
not
two more submissions to be made, my lord. Now, according to my, I declared my income is 1,40,000 rupees per month, my lord. Lord, and also I have shown, my lord, I have to look after my child, my lord. Is with me for last about 14 years. 7 years she left deserted, my lord. The master merit of the case is not merit. Her case, my lord. They have filed the divorce petition. I have not filed the, my lord. All along we waited so that she'll come and give some love and affection to child and tata meet, my lord. Not as far as child is concerned, my lord. She's growing as a law-abiding citizen, my lord. In a very good school, spending lakhs of rupees there, my lord. Now thing is, my lord.
No, nobody is with the wife.
Please.
Only one child.
One child. Only
Now-
one girl child. Visitation rights are granted.
Submission. Now,
She is going and visiting.
She is not
That's
an Indian
it.
girl. She has become, and also now probably may next month or so she may enroll. She may come as an advocate before the court.
That is advised
Thing
by
is,
me
my
to
lord,
study something because she's
one
not getting
second.
job.
We also tried our love story, my lord. She's not that, my lord. She's incapable of meeting her case is also 50,000 rupees month. She's also drawing. My income will already show me 1,20,000 rupees I'm spending. I have to take care of my old parents. And also, my lord, she was residing in my house also, my lord. Now, her father, my lord, I have produced some document to show that, my lord, more than 100 crores, my lord. Now they have running a company, my lord. Let him say, my lord, not at all running, my lord. Only one daughter is there, my lord. My observation, without touching all these things, my lord, that the direction may be given, my lord. Some order may pass, my lord. We have ready and willing to pay some 25,000 rupees already there now, my lord. If she is, my lord, it's not enough for her, my lord. Look into, my lord, their financial background, my lord. I am the person, the only son. Take care of it. Their only case is that, my lord, I should detach from my father and mother. I have to give life to her. And therefore, my lord, in the apartment, my lord, 2 apartments I have taken. One I have given to my father and mother, my lord. One I am living there, my lord. Not even a day she has visited. After filing of the petition, my lord, she will come on some birthday, give 1 or 2 grams gold and go there, my lord. So far, you have not taken, my lord, her to. Lord, my submission, all matter will be taken into consideration, my lord. We'll go deep into the matter in the evidence, my lord. 2020, 5 years is already lapsed. And whatever the order is there, let it be there, my lord. And my instruction, my lord, is not correct on my part, say, my lord. Some balance amount to be paid really to the extent of 5 lakhs, my lord. I already told you, my lord, it has to be paid between 2-3 installment, you are going to pay it also, my lord. My only thing is let the direction be, within 3 months, my lord, we will cooperate and close the case. These are the matter, we can prove it before the court, only another 2-3 months.
Sir, all the submissions you have made, we are again coming back to the same question. What is directed to be filed? Why you have not filed?
No,
What is
17 pages, ma'am.
What is the reason for the?
The pan is there only for them, my lord. Yeah, no, my lord, my instructions are, my lord, the 2 pans are there, my lord. One is for business, my lord, another is for, my lord. Let her disclose her all these, you will also disclose, my lord. It is not but suppression of anything, my lord. Once it's suppression, I am also aware of, my lord, section 195 is there, section 193 IPs are to face all the consequences thereof, my lord. Now, for the purpose of, my lord, considering interim application, my only request, my lord.
Oh, all these documents are directed to be filed
Yes.
by the Honorable Apex Court only for interim application, nothing else. Why, if he is not filing, there is something in it.
Yeah, just I will take instruction. In the meanwhile, my lord, for only, my lord, we also tried our level best to see that, my lord, if she ready and willing to, my lord, take some lump sum amount, my lord, let her have a good life.
They have never approached, my lord. My lord, the income tax return 17 pages, the form is.
But since, my lord,
Yes.
he was,
If you are ready, you
yeah.
are ready for a settlement.
So some should not be exorbitant, my lord. Only thing is, my lord,
All you have to come out with the proposal.
please, my lord.
Somebody has to come because you have come, you have to tell her what is the amount, then she'll come back saying whether
Much
her client is
obliged.
ready or
Yeah, my
not.
lord, there's no chance of reunion, my lord, because 7 years already
That
lapsed,
I
my lord.
never said. I have only filed for divorce.
Either it may be, either it may be referred to, my lord, it may be referred to mediation, or you come before this
So,
court,
my lord, it's a
whatever the
short
court
date.
says, my lord.
Here only it may be given, my lord. If my learned friend can meet me, we can meet each other and close it if it is coming.
Appearing for the, senior counsel appearing for the petitioner submitter, there are no chances of reunion. And if the petitioner, if the wife comes up with a proposal, the same will be put to his client. And counsel appearing to the wife submitter, such a proposal was never raised with the husband. If they come up with a proposal, she will put forth the same before the client. The husband shall come forward with the proposal, and the counsel for the appearing for the wife shall get instructions in that regard.
Lord, 1 week is enough, my lord. 16th. It's an old case.
It's a matter on.
A date may be given, my lord, because
16th, my lord.
is
18th.
18th. Much obliged.
18th,
18th.
Yes.
same. 2:30.
Huh?
The afternoon session, I'm learning.
No, generally it will come.
Grateful.
Much obliged.
Yes. What are the passovers in this first list?
Passover in first list, serial number 22. Passover, list number 1, Passover, serial number 22.
Petition this case.
Yes.
Plus, he was directed to pay the maintenance that was ordered by this court on the last date of hearing.
I have paid, my lord.
Now, yes, she has.
Mr. So-and-so, learned counsel, the petitioner submits the interim order is complied and the entire amount is deposited. No representation on respondent side. List this matter also.
Plus, I'm for the respondent.
I'm looking at the earlier.
Or
Yes, please argue.
The husband is the petitioner, assailing the correctness of the order on IA number IA filed in proceedings.
Where is the order?
Lord, annexure A, my lords, page number 13. The relevant page, my lords, page number 17, my lords, para number 11. Para number 11.
How much is granted? 10,000.
Lord, 15,000 is granted, my lords, by a way of interim order, my lord. The Honorable Court was pleased to
5,000
direct me
towards
to.
educational expenses.
Yes, Lord, 10,000 is directed to be paid, my lords, by the Honorable Court as interim order, Lord, which I have been paying. Lord, as a matter of fact, Lord, she was a BSc graduate in fashion design and working, Lord, for a sum of rupees 30,000 she was earning earlier. Lord, only the reason for leaving the matrimonial home is that, Lord, my mother, Lord, is aged. And
will not go into
yes,
all that.
Of course, Lord.
Please tell about the financial capacity of the husband.
Lord,
That's it.
she is working, Lord, whereas, Lord, I am
What
also
is
working.
she? What is
Lord,
her earning?
Lord, she was
Yes.
working, Lord, in a option basket option at
What is her
Jayanagar, Lord,
income?
as a fashion
She's
designer.
not working at present.
Why?
But she could not get the job. In fact, she lost it long back. It's not that she's a fashion designer. She comes from a very economically backward this thing. In fact, the reason that they are not able to stay also is because the petitioner husband links her with her father itself. Very abusive, my lords. Highly abusive.
Let's not go into that.
No, that is the only, otherwise I could
That
have
is incorrect,
advised
Lord.
her
That is
to.
incorrect. That is incorrect, Lord. Lord,
The
I filed a
respondent
petition
is
for
against me.
conjugal rights.
He is earning
Lord,
about.
on the other hand, she filed a counterclaim, Lords, for divorce. And on the other hand, one more petition is filed seeking maintenance.
So your income is 50,000.
Yes, my lords.
So as far as the wife's income is concerned, there is nothing on record.
Lord, in the sense, my lord, she was a BSc graduate, my lord, in fashion design. She was working. My lord, as of now, my lord, I don't know whether she is working or not. My lord, she is an educated lady. My lord, therefore, my lord, it is bound and duty to get the job, my lords.
Yes.
My lord, further, my lords, I am not able, my lord, may to meet my lord, son. My lords. Therefore, my lords,
Let's not go into that now. It's a criminal miscellaneous. If you want to meet your son, there is a court where it is
kindly
available
see
where
the
you will
intention
go.
of the party. Kindly see, my lords. A petition
not
is
complicate
filed,
this,
my lords,
Mr.
for
Counsel.
conjugal rights. As a counterblast, my lords, this petition is filed. Not though, my lord, she filed an lord, the counterclaim in my petition for divorce.
Please
The
come.
reason behind, my lords, the filing of petition is, my lord,
Agreed with orders passed.
Not even educational expenses
number
is
two.
paid, my lords.
In criminal miscellaneous number 50 of 2021 date 13th by 2024, whereby the court had granted 10,000 per month towards her, towards the maintenance and 5,000 towards the educational expenses of the child. The husband is before this court. The wife had filed the IA number 2, seeking maintenance of an amount of rupees 20,000 per month to each of the petitioners, to herself and to the son. It is her case that the husband is working as head constable and earning sufficient income. In spite of the same, he is not maintaining the family. It is a case of the husband that wife is working. Wife is a BSc graduate in fashion designing and drawing salary of 30,000. Court had granted maintenance of 10,000 and 5,000 educational expenses. And while granting the same, the court has observed that the wife in her affidavit of assets and liabilities has not shown her educational qualification. She has shown that she is residing in her parents' house. In the affidavit is also, she has shown the salary of the husband as rupees 60,000 per month. The husband in his affidavit of assets and liabilities has shown his qualification as BA and his general monthly expenses are shown as 50,000. He has also shown his gross salary at rupees 51,259 and take home salary at rupees 25,420. He has shown that he is paying EMI of rupees 10,500. And also placed his place. The court had considered the fact that the child is now aged below 10 years and the amount of 20,000 that is claimed by the wife is on the higher side. And it is a duty of the husband to take care of his wife and the child, and accordingly 10,000 towards maintenance and 5,000 towards the educational expenses of the child is awarded. What are the educational expenses of the child?
Let's educational expenses is around 2 lakh.
Where from she is getting all that?
Millards?
Where from she is getting all that?
I can produce that including transport.
No, where from he is paying? She is paying when she is not.
Father is helping her. Father and mother run errands and help her. And now she is trying to do odd jobs as in cooking and other things.
What did you write? Then counsel appearing for the petitioner. Husband submits that the court had granted when his take home salary is 25,420. Quoted or granted 15,000 towards the maintenance, which is on the higher side. It is submitted that the court had failed to consider the fact that the wife is educated and she is capable of earning, and in fact she is earning. She has suppressed all these facts. It is submitted that when once he has filed a petition for restitution,
Yes, ma'am. Yes.
restitution of conjugal rights,
In
the
which,
wife
my lord,
has come
she
up with-
filed,
Huh?
she filed a counterclaim, my lords, for divorce.
She has filed a counterclaim for divorce and also filed this petition seeking maintenance. It is submitted that the wife who is capable of earning is not entitled for maintenance. Next para. Then counsel appearing for the respondent by submits that wife, though she did her BCom, BSc, what is this?
Fashion
BS
design, my lords, BSc
Fa-
fashion design.
BSc fashion designing.
It's not.
She could not secure a job.
Training
And
course.
in fact, what is this BSc fashion technology?
But
Isn't
she is
there?
not fashion designing. She has done a certificate course in fashion. I have ascertained that. They have put it like that. If she was,
No.
then she could have earned much more.
Submitted that she did her BSc and a certification course in fashion technology. She is not able to get a job, and in fact she is even trying for the hard jobs only with the help and assistance from the parents. She is able to maintain the child. Then counsel submits that it's a duty of the father to take care of the child. As a husband, it's his duty to take care of the wife. And the court had rightly granted the maintenance, and there are no reasons to interfere. Next para, having heard so and so, so and so. Admittedly, the income of the petitioner husband is 51,259. Some of he has shown that he's paying EMI 10,500 and other deductions. His take-home salary is 25,420. Considering the fact that the wife is not working and the wife and the child has to live, and she also has to take care of the educational expenses of the child. The court had granted the maintenance at 10,000 and 5,000 for educational expenses. When the wife is capable of earning, she is not earning, and considering and in spite of the best efforts, but she is not able to get the job on the ground that she is educated. The courts will not keep quiet and not grant maintenance to the wife. The independency of these proceedings is the duty of the husband to take care of the needs of the wife. And the amount already that is granted is not an exorbitant amount. Court had granted only 25% of the amount of his salary towards the maintenance of the daughter and the child, wife and the child. In the view of the matter, this court do not find any reasons to interfere. Accordingly, dismissed.
Serial number
Great.
25. 25, Manjunath V. Rayappa for petitioner. Anita N.
I for the respondent in this case.
Yesterday,
20? 5. Yes.
yesterday I was contacted him. And my client is told that my lord, entire amount cleared deposit in the trial court. What is the maintenance amount? So at that extent, my lord, I asked for certified copies, my lord.
Kindly see the order sheet, my lord, dated 7/8/2024 in this
Finally-
conditional order date.
Switch on the mic. I'm not able to hear you.
Order dated 7/8/2024, my lord. There is a conditional order date, my lord.
7/8/2020.
2024 in High Court order date, my lord.
Mm.
In this, my lord, if either a sum of 10,000 rupees per month by 5th of every succeeding month, or sum of 10,000 rupees towards arise as ordered by this court is not deposited within the above stipulated time, the stay granted by this court stands vacant automatically without further reference to the court. And I filed the memo for calculation also, my lord.
When did you file?
It's in 24/1/2025, my lord.
Have you served him a copy?
Yes, my lord. In this, my lord, page number 2, my lord. After the High Court order, my lord, they given only 30,000 rupees in 17/12, 18/1, 28/3, 25/4, my lord. They are not complete the order also, my lord.
Yes, we'll vacate the interim order. Let.
And I have the.
In the interest of justice, my lord,
What
can we have
interest
it
of
next
justice?
week, my lord, next week?
Interest of justice is
Next week,
granting
next
an
week,
interim
my
order.
lord. Because
And that also you don't comply.
Client is not available for 1 week through phone, my lord. That is the reason. In the interest of petitioners.
This order is passed on 7/8/2024,
Agree, my
exactly
lord,
1 year back.
I agree, my lord. I agree, my lord. 1 week finally, my lord.
No 1 week. This is matter on Thursday. By the time, if the interim order is not complied with, this court will not even hear the arguments of the learned counsel of the petitioner and straight away will dismiss the writ petition on that ground, having obtained an interim order, enjoying the same for 1 week, has failed to comply with the same. Yes. Next.
List number 2. Authorized for dismissal, cell number 1. Spurti Hegde.
Precedent, Fred, I am not in Monday.
Monday, anyway, I'm going to dismiss it. Your client is not paid. Take it till Monday, but no accommodation on Monday. Whether you are there, not there, I will dismiss the writ petition.
Monday, I will.
Monday, it's the matter on Monday. Yes, Monday.
Kindly see the order sheet, my lord. In every date, they are taking the time, my lord.
This Monday, it will not be adjourned. It should be mentioned in the cause list that this is a case where no further adjournments will be granted. Yes. Yes.
I appear for claimant, my lord.
My lord, I appear on behalf of first respondent counsel in the first matter and appellant counsel in the second matter. May it please be taken up on Tuesday or Wednesday, my lord.
There is no representation on behalf of the appellant in MFA 8660 of 2020. Why you were not? Why you want time now?
My lord, I am not prepared. I am not R. Gunashekhar. I have promised to appear on his behalf. I'll get the file and read it. If my
So
lord.
what would be there such big issues that you require a preparation for that?
I need to at least read, my lord. I can't
You
stand.
should have done
and-
it from morning. You've been waiting from morning.
Yes, but without.
Because every time matters can't be listed like that. One invitation, one dismissal, one adjournment. This is matter. Delete
lord.
from the caption for dismissal. List in the month of December.
Cell number 2. A. Krishna Swami for appellant.
Respondent,
K. Kumar.
respondent claimant, my lord.
Why is it adjourned yesterday?
Yesterday, I had requested time to produce the full bench decision of Kerala High Court. My lord, may I pass on the wherein they hold that permit and fitness certificate are fundamental breach. My lord,
Where is the paragraph?
my lord, end of para 2 in page 2. Contest the matter when last 4 lines, my lord. There was no valid permit or fitness certificate. Turned out to be a question
Paragraph
of
number 2.
para 2, last 4 lines, which was required to be determined by a larger bench. It is based on the said reference that the above matters came to be listed before this bench for considering the declaration of law made by the full bench of this court in Augustine's case cited. My lord, may I request para 6 end. Driver was not having valid
Paragraph number
Driving,
6.
para 6, last 4 lines.
Hmm.
Valid driving license, the vehicle was not covered by a valid policy. The vehicle was not having valid permit, and further, there was no fitness certificate as well. After fixing the total compensation payable at so and so, so and so. My lord, may I request my lord's kind consideration to para 17 and 21. Para 17. My lord, 6 lines from the bottom.
Hmm.
Registered vehicle for the purpose of section 39 of the act, which stipulates that nobody shall drive or cause a motor vehicle to be driven without valid registration in public place or such other place as the case may be. These requirements are quite fundamental in nature, unlike a case where a transport vehicle carrying more passengers. My lord, now I take my lord's kind attention to para 21, where law is declared. They hold we can directly last 2 lines in para 21 would be sufficient. Said,
No,
and
let's
the
read
latest
it.
ruling in
Like with
Amrit
all
Pal's,
this- No, 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 we'll read it. It's all piecemeal. Court will not be able to understand.
the question whether absence of valid permit to a transport vehicle at the time of accident is a fundamental breach or a technical breach had come up for consideration again before the apex court recently in Amrit Pal Singh's case. The factual matrix in the said case is that the rider of the motorcycle was knocked down to death by the offending truck on 19/2/2013, which led to the claim petition preferred by the legal heirs. The claim was resisted by the insurer, mainly contending that there was violation of policy condition insofar as the offending truck was not having a valid permit and the driver was not having a valid driving license. Based on the materials and record and placing reliance on the verdict passed by the apex court in Challa Upendra Rao's case, the tribunal, after fixing the quantum of compensation, directed the insurer to satisfy the same, with liberty to have it recovered from the insured. The said finding and reasoning came to be affirmed by the High Court, in turn leading to the proceedings before apex court. After exhaustive discussion on the relevant provisions of law, including section 228, 231, 247, 66, 149, and 166 of MV Act 1988, and the various judgments rendered by the apex court at the different points of time, including in National Insurance Company versus Swan Singh and Challa Upendra Rao's case, the apex court held that the offending truck was not having a valid permit on the date of accident, which was not a technical breach to attract the dictum in Swan Singh's case, cited supra, where also right of recovery was held as conferred on the insurer. Once the breach was established by the insurer, it was also observed that it was not a case where any of the exceptions under subsection 3 of section 66 was attracted, and further that the existence of a permit of any nature was matter of documentary evidence. The bench held that the exceptions carved out under subsection 6 under section 66(3) of the act are to be pleaded and proved by the insured owner, and this burden cannot be shifted to the shoulders of the insurer. It has accordingly been declared that the use of a transport vehicle in a public place without permit is a fundamental statutory infraction, and the principles laid down in Swan Singh's case cited and Lakshmi Chand versus Reliance General
But
Insurance.
I'm not able to understand here. It says finally, suddenly in this order, out of the blue, this fitness has come. All the while they were dealing with the permit. Suddenly in this above paragraph 22, for the first time they used the word fitness.
No, my lord.
Then they said, accordingly, that the law laid down in Tara's case is restored. Where is Tara's case referred?
Para?
Tara's case, 21.
Tara's case.
Where is it discussed in the judgment?
My lord, this is may request larger bench. fact, Augustine case has to be looked into. 3 judges bench decision.
No. It says the law laid down in Tara's case is affirmed, and the dictum in Tara's case is restored, and the contrary view expressed in
Well,
Setunath's case stands declared as incorrect.
Well, para 15 may be read. Para 15. Para 15. As mentioned above, fitness of a vehicle to be used as a transport vehicle is of paramount importance. The necessity to have fitness certificate is prescribed under section 56 of the Act. Subsection 1 of section 56 clearly stipulates that a transport vehicle subject to the provisions of section 59 power to fix the age limit for motor vehicle, and section 60 registration of the vehicle belonging to the central government shall not be deemed to be validly registered for the purpose of section 39 unless it carries a certificate of fitness as prescribed by virtue of section 84A. As mentioned already, it is a mandatory requirement of every permit that the vehicle to which the permit relates shall carry valid certificate of fitness issued under section 56 at all time, absence of which will automatically lead to situation that the vehicle will not be deemed as having a permit if it is not having a fitness certificate on a given date. Using a motor vehicle in an unsafe condition in any public place itself is an offence under section 190 of the Act. Separate penalty is prescribed under section 192 for driving or using the motor vehicle in contravention of section 39 of the Act, that is without registration, which at the first instance.
Yes.
So
And what is the other ground?
This is the fitness certificate and permit were not there. I have led
What is
evidence.
the other ground?
Apart from that, I do not even press for the driving license. He had no driving license. No evidence is available from my side. My lord, I had indicated to my lord that there are 2 decisions of the apex court with regard to these one, where a certificate of registration, if it comes without the
Registration?
permit, 2 decisions of the apex court. My lord, yesterday I had made a mention that they discussed it under Consumer Protection Act. One is Narendra Singh's case of 2014, and another one is 3 judges bench in United India versus Sushil Kumar Godara. Both are available at my lords. Narendra Singh's case is followed in the subsequently. Narendra Singh's case may be looked. That was rendered by 2 judges.
You're on what ground for enhancement?
Ultimately, if I succeed, I will get an order of pain recovery from my.
Yes.
Malada. Please claimant.
Malada. In the respect of DL concern, Malada, the driver of the offending vehicle having the.
You are not the owner of the vehicle.
Valid DL, Malada.
That we will see. Not he is not having a fitness certificate. Is the evidence.
Please, Malada. And
please come to the order. Where is the table?
Malada, please. Malada, in page 17 of the judgment, Malada, para 32 of the judgment.
What is the age?
19-year-old as on the date of accident. 19-year-old.
19 years.
19 years.
What is he doing?
Malada. Was occupation by vegetable vendor and coconut business.
How much is earning?
20,000 per month.
Which year is the accident?
Accident on 19/4/2017. 19/4/2017.
Oh, how much the court had taken?
7,000 per month was taken. The claimants are the parents of deceased man.
50 has to 50% has to be affected. Who are the claimants?
Hello?
Parents.
Parents, man. Claimants are the parents.
Multiplier is 18.
18. 18.
It comes to 18 lakh 2,600.
Rate of interest, rate of interest I have disputed. It
What was given by the tribunal?
9% is granted, throughout 6% may can.
Yes, please come. Agreed with award passed in embassy number 1681 of 2017, dated 29th August 2019. The claimants are before this court seeking both the insurance company as well as the claimants are before this court. Insurance company's appeal is MFA number 501 of 2021, and the claimant's appeal is MFA number 2222 of 2021. Land counsel appearing for the insurance company submits that the tribunal has fixed a liability on the insurance company. It is the case of the insurance company that there is no valid permit, there is no driving license, and also the vehicle was not having the fitness certificate. In support of their case, they have examined the inspector, vehicle
And office,
officer from the RTO.
RTO office and also insurance company office.
RTO, they've examined the RTO officer, and in the evidence, it has come that it is elicited that the fitness certificate is not there to the vehicle, and the document is also marked before the court. But the court had failed to consider all these aspects and fasten the liability on the insurance company. It is submitted that the rate of interest the court had taken 9% as an interest. It should have been 6%. Next para. Land counsel appearing for the claimant submits that when the accident had taken place in the year 2017, court had taken the income at
7,000.
7,000.
7.
Court had taken the income at 7,000. Future prospects are granted.
That was granted.
7,000, and granted the compensation of an amount of rupees
11 lakhs.
amount of rupees 11,68,400, which is not a just and reasonable compensation, and it needs to be enhanced. Next, having heard the counsels on either side, there is a material on record. The first contention of the insurance company with regard to the driving license, permit, and the fitness certificate. As far as the first two issues are concerned, that is the driving license and the permit, no satisfactory evidence is adduced before the court. Then the third is with regard to the fitness certificate, that there is evidence on record to show that there is no fitness certificate to the vehicle as on the date of the accident. When once there is no fitness certificate, it amounts to fundamental breach of the contract, of a breach of the policy. The counsel appearing for the insurance company had relied on the judgment of the full bench judgment of the Kerala High Court in Parith Pillai versus Oriental Insurance Company Limited, reported in 2019 AR Kerala 9. He relied on paragraphs number 15, 17, 21. Extract those paragraphs. You also relied on the judgment of the Apex Court in United India Insurance Company Limited versus Sushil Kumar Botra, reported in 2021, 14 SCC 519. Which paragraph? Paragraph number 14. Then he relied on the judgment in Narinder Singh versus New India Assurance Company Limited and others, reported in 2014, 9 SCC 324. Eleven, 12, relying on these judgment submits that not having a fitness certificate goes to the root of the matter and the insurance company is not liable to pay the compensation. It is the contention or the or the this court has perused the judgments and also the evidence that is available on record. As far as the permit is concerned, the vehicle, as far as the fitness certificate is concerned, there is no fitness certificate to the vehicle in the light of the evidence adduced by the insurance company. In the above referred judgments, the Honorable Apex Court as well as the Kerala full bench of the Kerala High Court has held that not having a fitness certificate is a fundamental breach of the conditions of the policy. In those circumstances, the principle of pay and recover will apply, and the insurance company is liable to pay the compensation and recover the same from the owner of the vehicle. Then coming to the compensation, the tribunal has awarded the compensation as per the table given below. At page 32 it is there. This accident had taken place in the year 2000 and 2017. As per the table, the income has to be taken at 11,000. Future prospects at 40% comes to 4,400. That is 15,400. There are as he is a bachelor, 50% has to be deducted towards his personal expenses. Then his contribution to the family would be 7,725 into 12 into 18 is 16,68,600. For the under the head of loss of consortium, 44 into 2, 88,000. Funeral expenses 36,000. And in the light of the law laid down in Mekala versus so and so 10,000. Altogether, the claimant is entitled for an amount of rupees 18,02,600. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 11,68,400 to 18,02,600. The entire amount shall carry 6% interest. The appeal of the insurance company is partly allowed by applying the principle of pay and recover. The amount in deposit shall be forthwith transferred.
Number 3, J. Kumar T. Sunil L.
Take this.
The needful done, we have paid morning minus. For respondent number 1 and 2.
Why you were not present on the last occasion? We are not on the requisites, sir. You were not there on the last occasion. The matter is listed for dismissal.
Yes, minus. I was held up in another case minus. That's why I could not.
You are not evincing any interest in pursuing the matter right from 2021. National Insurance Company. You appear, Mr. Krishnaswamy. National Insurance Company. Mr. Krishnaswamy is directed to take notice on behalf of the insurance company and the land counsel for the appellant shall serve the copy of the memo, copy of the appeal memo on the counsel for the insurance company. Liability is on whom?
The petition was dismissed.
Huh?
The petition was dismissed.
Notice to the first respondent. It is submitted that needful is done. This matter immediately after service of notice on the first respondent. Call for the TCR. Yes,
Seal
4.
number 4, hearing on interlocutory application 4.
My lords, I filed an application for withdrawal of the.
Where is the counsel
award.
for the petitioner, appellants? There is no representation on behalf of the appellant. Counsel for the respondent is present, and IA is filed for withdrawal of the amount. As there is no representation on behalf of the petitioner, the IA number 1 of 23 is allowed, and the petition is permitted to, the respondent is permitted to withdraw the amount. Next, come to 5.
Seal number 5,
Oblige, Your
B.A. Ramakrishna. B.A. Ramakrishna for appellant Ramesh H.E.
Appeal. Two applications are made. One is for impleading the insured of the vehicle, one Ramesh, and also to permission and order of 41 Rule 27 to produce the Aadhaar card of the deceased. Because the MSET has taken it as 59 years, but actual age was 63 years. So that those documents,
You are appearing for the insurance company.
insurance company.
Listen, when do you want?
Next week, 2 IS may be allowed, and then
Whom you want to implead by IA number 2?
the Ramesh,
Who is the?
he is the insured of the vehicle. Earlier, before the MACT, they have impleaded one Suresh, who has no
Going to be impleaded as a respondent number?
6 months.
So far, notice is not ordered.
No, 6 was Suresh. So now this person has to be impleaded as 7.
So let's issue notice to him.
That's
On IA number 2, notice to the respondents. For additional documents, we have to, yes. This is matter of service for notice.
Seal number 6, F.S. Dabali for appellant
Yes.
A.P. Bhuvan.
Respondent. Whole respondent, I have filed an application to bring alerts of the deceased respondent. Notice may be issued.
IA number 1 of, on all the IAs, notice
Yes,
to the respondent.
Seal
Next,
number
7.
7, A.N.
IA
Krishna
number 1
Swamy.
of 23 is filed to condone the delay of 15 days.
Appearing for the
Delay-
respondents.
Delay condone.
This
Ready?
matter posted along with MAPN number 4167 of
You
23.
filed the appeal.
Climate
List
spell.
along with write on a paper and give to the court officer. List along with so and so on 19th of September. 20th is a working day. 20th September.
Earlier, 16th or 17th.
16th. Yes, next. 7.
Seal number 8. Seal number 8,
IA number 1 of 23 is filed to condone the delay of 28 days. The reason stated condone. Ready?
No.
It's connected with another matter.
along with
Take that. Along with that on 20th. Yes, 9.
Seal number 9, for admission matter, seal number 9.
Serial number 9. In 2 cases, I have to make deposit. My lord, 2 days time may can be granted.
What you have to do?
My lord, I have to make statutory deposit in 2 cases. My lord, today they have drawn DD.
No, why should we grant you time in 2017?
My lord, 2025 case. My lord, 3881 of 2025 and 3783
Connected matters are there.
Connected case. My lord. I have to deposit my share. Today DD is
I think
drawn.
already last time I have passed an order.
Passed order. Today DD is drawn. My lord, they have not yet handed over. Within 2 days, I will deposit.
When is the order passed?
Along with interest, order is passed. To deposit along with interest, I have instructed to
Unnecessarily, we have listing the matters. You should have done it by this time.
understand, my lord. They have to, my lord.
That's
there
that
will be
is the
huge
duty
amount, my lord.
They have to do it, whatever is the amount. When is the order passed?
Today they are trying the DD. We will pass it.
And what is the time?
Now 4 weeks time was granted on 5/8.
Finally, this court on 5/8/2025 has granted a 4 weeks time to deposit the amount. Then counsel submits that he requires 2 days time. Lists this matter on 19th.
On submission.
By the time, if it is not, then I'll dismiss your appeal.
Within 2 days, we will deposit.
By the time, if the amount is not deposited, appeal shall be dismissed on that ground. Yes?
9.1, MFA number 3783. Note 2, the steps not taken in respect of respondent number 3. Respondent number 3 died, leaving behind respondent number 1 and 2.
1 minute, 9.1. Where is the note?
9.3.
9.1, 9.1.
Yes.
Note 2, steps not taken by counsel for the appellant for respondent, this is respondent number 3.
The respondent number 1 and 2 may kindly be treated
Where
as
is he getting that note?
9.1.
Cause list is.
Cause list.
I'm looking at the cause list.
9.1.
9.1 says,
3783.
as per general order, nothing.
Note 2, note 2.
That is 9.3. 3783.
3783.
That is
That is 9.3.
Please, steps not taken is R3 died, leaving behind respondent number 1 and 2. They are already on record. That effect they have to amend the cause statement.
I will carry out amendment order may continue fast.
In 9.3,
Yes.
it is
Respondent
submitted
number 1
that
and 2 may continue.
already the LRs of R3 are on record.
As respondent number 1 and 2 are the LRs of respondent.
R3 are already on record. To that effect, a memo is already filed.
Not filed. They have to file.
I will file my that order may continue fast.
You appear for whom?
Yes. Respondent number 1 and 2, madam. I appear for respondent number 1 and 2. They have to file a memo treating them.
You don't have to tell him that they are the LRs.
Last time I informed them.
No, if you inform, he will file the amendment memo.
Please.
The needful shall be done within a week, by next date of hearing. Yes.
Cell number 10. 10 urgent. Cell number 11. Nagaraj Hegde.
Yes.
Cell number 11. Nagaraj Hegde.
Who appears to the respondent?
Respondent.
Where is Mr. Raju?
He took time to produce some
PB
statement
Raju.
on the point of not the premium is collected for rupees 8,000 as per the notification.
So we'll have it on that Saturday, 20th.
27th.
Huh?
20th.
But it shows in September 20th.
28th is not.
Saturday is not shown in green. It's a working day. There is a star also.
27th is not only for civil court.
No. 20th. Oh, it's 27th.
27, madam. 27 is for only civil court, not the high court.
No, 20th? No working day. List on wherever I said 20th, make it on 23rd.
23rd.
Yes, next.
27.
23rd.
23rd.
Yes, next.
Cell number 12.
Respondent Miller, 12.1 R1 dispensation memo file. 12.1 ನಲ್ಲಿ R1 may be dispensed.
12.1 R1. Memo for
Ravi
dispensation.
Sampriti may be directed to take notice. In crop appeal I filed.
Seeking dispensation of notice to
R1 Miller.
respondent number
1.
You wrote something like 21.
Sorry. 1 Millet.
No, respondent number 1.
Yes, Millet.
Is the owner of the vehicle.
Owner of the vehicle.
To dispense with notice to respondent number 1.
Ravi Sampriti is filed appeal.
Is taken on record. Notice to respondent number 1 is dispensed with the risk of appellant. Mr. Ravi A. Sampriti is directed to take notice on behalf of the insurance company, as he has already filed appeal on behalf of the insurance company, and transfer the appellant shall serve the copy of the memo on the council. Admit post for final hearing. Call for the TCR.
Please,
Yes.
Delay of 445 days. Delay of 445 days.
Same. IA number 1 of 24 is filed to condone the delay of 445 days in filing. Condone on condition. Yes, next.
Yes, sir. Cell number 13 urgent. Cell number 14.
For appellant, my lord.
Yes.
My lord, I didn't have the file, but the matter of the case is that in the trial court has erred in taking the age of the claimant as 58 years old, my lord. The other card shows he was aged 68 years, but the tribunal had taken consider the age of 58 as per the FIR record. But
No, is this a case of a death?
yes, my lord. That,
And then what the postmortem says? Look at it, what is the, have the record?
No.
Record is not there.
Not this. Record is not the
So
serious.
admit post of final hearing, call for the TCR. Yes.
Cell number 15. MV Maheshwarappa.
I appear for appellant and also company filed. I am also appellant in the.
Tomorrow is morning, he was asking for time.
Last the
Huh?
final hearing, that is record received the injuries case quantum that is deposited.
Yes.
Shall I commence, Mala?
Yes, your appeal.
Lord,
What ground your question?
the involvement of the vehicle in the accident and also quantum of compensation awarded by the president.
How you are denying the involvement of the vehicle?
Lord, the accident is Mallard on 13/9/1918.
13/9/2018.
18. The alleged complaint was given on 19/9/2018. That is after 6 days from the date of accident.
Yes.
Mallard, actually, Mallard, he, according to the claimant, Mallard, he was going along with one Anil in a motorcycle.
That's the only ground or any other?
No, even quantum of compensation, because
that we will go.
Yes,
With
yes.
regard to the involvement of a vehicle, delay in giving the FIR.
delay in the giving the
Complaint.
FIR.
So-
And Mallard, there is no MLC or in medical certificate show
Let
that
us
he has
see,
involved.
let us see the exhibits. What are the exhibits?
Please, they have produced number of documents, Mallard. Mallard, see, Mallard, exhibit P6 is the own certificate. There is no mention
Exhibit
that.
P6, record is there?
Yes.
Take exhibit P6.
There is no mention that he sustained injury by involvement of this
Exhibit
particular
P8
Tata
and
Ace.
9. Yes. P14.
Is a discharge summary.
15.
There also there is no mention. And Mallard,
P25 MLC.
Exhibit 25.
Yes.
kindly see, Mallard.
First give the MLC.
P20.
P25.
P25.
P25 is Christmas hospital, sir.
Give that. P25. P25 is an authorization letter for attending the court proceedings, not a MLC.
That is as per the P25.
Yes, yes, it is there. Next page. Sachin, so and so, date Dinamsa 13/9/2018 at 3:10 p.m.
Oh.
RTA today at around 2:30 p.m. near Jalamangala. The patient was driving on a two-wheeler and was hit by auto.
Well, if this is true, then matter why there is a difficulty for any one of these persons. There are almost like 8 persons were there at the time of accident. They are in the hospital also. Father, brother, pillion rider.
This we will consider. Next,
Please, ma'am.
come to the quantum.
my lord, there are almost like 8 persons were there at the time of accident. And my lord, none of them have given the complaint. My lord,
Please come
even the
to the-
hospital authority also, my lord, when they have registered the MLC, what is their duty? They should have intimated to the police so that police will come and take the statement and file the complaint.
What
There
are
was
the
no
injuries?
reason.
Pain and suffering, how much amount?
My lord, pain and suffering.
Pain and
my lord,
1 lakh.
1
What
lakh
are the
is awarded.
injuries? What are the
Kindly see
injuries?
exhibit P5.
The injuries, your lordship, the
Kindly
page
see
number
exhibit
25.
P6, my lord.
Page number
P6,
20.
my lord.
Let him argue on the
26, your lordship.
20.
26, ink page number, para number 16. The petitioner, to prove that nature of his injuries, he examined Dr. Krishna Prasad, consultant orthopedic surgeon, Asmat Hospital, Bangalore, as PW2 through his case sheet, 3 X-rays and 2 medicals out of patient record. That is, the petitioner has sustained injuries type of 3 open supercandular fracture of right femur with the 10 cm bone loss, 5th metatarsal fracture of right foot, 3rd metatarsal fracture right foot.
Nothing to increase in the pain and suffering. 1 lakh is a reasonable compensation. Then coming to, how many days was in hospital?
2 months.
No, he is not in
He
2
is
months.
as per the evidence. That is.
Evidence allowed. Go by the document. Yes. My lord, discharge summary, my lord.
First,
kindly see at my lord exhibit P8. This is from 21/11/18 to 28/11/18. There, my lord, it's only 7 days. Then another discharge summary exhibit P9, my lord. 13/9 to 19/9. Almost 16 days. 16 days.
Oh, that is
Exhibit
continue
P8 and
following the
P9.
treatment, your lordship. Continuing the following treatment.
No, we are talking about the hospitalization.
Hospitalization 1 month. First, but is admitted in
When we are
admitted in 13/9/2018 and discharged in 19/9/2000. Then they admitted 19/11, your lordship, they, as per the evidence.
So food, nourishment and loss of amenities, court had granted 20,000. So for all conveyance, food, nourishment and everything, all together we'll grant 30,000.
Here is amputation of right, second and third toys.
Next, medical bills.
My lord, in addition to it, my lord, 20,000 is awarded towards
That's why
conveyance charge.
we are making it one amount. 4,92,496. Then coming to loss
My
of
lord,
income.
regarding medical expenses, my lord.
Huh?
Medical expenses, my lord, tribunal has not at all considered anything. Kindly see, my lord, they are produced. It appears that
4,92,000.
Duplicate bills, not the original bills.
Please
And
don't.
it is not supported by prescriptions.
Let's take your grounds in the appeal.
Please, my lord.
Where did you say so?
My lord, regarding medical expenses, my lord.
History 6 medical bills, your lordship. Then addition, exhibit P12. Totally 4,92,496. Tribunal is only granted 4,90,000.
Ground number 14.
No, only 12 grounds are there.
Ground number 14.
Get his appeal. His appeal.
Ilva alli miss agidya. How? My lord, it should be there. It should be there. I don't know. Nimma pila. Yes. Ground number 14. Sir, nande miss agidya anta.
This exercise we can't do about the medical bills now.
Tribunal should have done it. That's what my humble.
But you should have taken the ground there, not now. Yes. Loss of income during the later period. Which year is the accident?
My lord, my main
2018 accident.
I'll make one submission. My main ground is regarding my lord, future income awarded by the tribunal.
No, let's go to that. Loss of income during the later period. Which year is the
That
accident?
is also, my lord, 50,000 is awarded.
Which year is the accident, Mr. Count?
2019.
2019 is 14,000.
PW2 doctor stated that another 2 lakhs for operating, that is.
Both of you are not like what the court is asking. There, both of you are not sticking.
Please.
Now we are talking. What is the income I'm asking? Then you both of you will
Tribunal
go to
has
the next
taken
step.
12,500 per month.
14,000. 2019.
2018, my lord, 12,500.
Just now you said
I'm sorry.
2019 is the accident.
2018. 2018. 12,500 is taken. But my lord, he is continuing in service and getting regular income.
No,
He is
your
working.
lordship, that is entire they resign from their job.
There is
Stated
no
that
proof.
in the
There is
evidence.
no evidence. My
What
lord,
is the
when he
work
was,
he is doing?
my lord, one submission. He is working in BHL. It is a central government organization. He cannot be removed from the service. If he is removed from the service, definitely there will be a
Yes, what is the
authenticated
evidence in
document.
that regard?
No evidence, your lordship, removed from the,
Simply that's all he
he
says.
is only for,
There should be evidence
Evidence,
removed from
evidence.
service means, please wait, Mr. Vijay Kumar, let him ask him.
Please, my lord, I'm sorry. I'm sorry.
What is the document to show that you are removed from service?
no documents produced.
Why will they produce? You should produce.
It's just your
About
lordship.
whether you are in service or not, how will they produce?
That is stated in the lordship, the, due to this fracture and injuries, removed from the service.
If you are removed from service, BHL is not some,
Not permanent employee, your lordship, that is only outsourcers, that is taking into consideration, that is. He has stated, your lordship, the,
where is it discussed?
that is in para number.
What you are earning while you are working, what is your salary?
As per the 15,000, the evidence.
Let us see that you are
Yes.
not a permanent employee.
In para 2, page number 3 of the judgment. Immediately after the accident, petitioner was shifted to Narayana Hospital, so and so. After first aid treatment, he was shifted to Hasmat Hospital, Bangalore, so and so. Then next page, my lord, petitioner was very hale and healthy, and he was working at BHEL, Bharat Heavy Electricals Limited, at Yashwantpura, Bangalore, as an operator and technician. He was getting salary of 15,000 per month.
Per month.
That is their own contention, their own. How he can be removed from the service?
Yes, what do you say?
He removed, now he is not working due to this.
That the document is required. How will the court consider that?
Now, your lordship, they have stated in the evidence.
If you want to file an application under order 41 rule 27 and make, place the
ready.
document before the
Yes,
court,
your
we will
lordship,
consider.
date may be given.
The land counsel appearing for the insurance company submits that is working in the claimant is working in BHL and earning is working in BHL and there is no material on record to show that he is removed from service in when there is no income court ought not to have granted the maintenance, the compensation of the head of loss of future income. It is submitted that the court had failed to consider this land counsel for the respondent. Land counsel for the claimant also does not dispute the fact that no document is placed before the court considering all these and it is submitted that he will come up with the necessary document by way of an appropriate application. List this matter in the month of October due someday. Yes, next.
16. Cell number 16.
No representation on behalf of both the parties. List this matter in the month of December. Next 17.
Cell number 17.
For appellant, quantum plea.
Where is the counsel? Heard the learned counsel for the insurance company. No representation for the respondent. List this matter as part heard on 19th. Even if on the day there is no representation, court will pass orders. Yes.
Final hearing. Cell number 18.
For the respondent in this matter.
Yes.
So petitioners, week of time may be granted, madam.
Why?
The senior is held up in.
Lordship, in the last occasion, I have filed a memo for sending.
Why RPFC is
That
tagged to
is
MFA?
wrongly it was connected, my lord.
Huh?
My matter is connected to 18.1.
Why MFA is connected to RPFC?
In the last occasion, I have filed a memo and seeking for the.
Dealing this RPFC.
Yes.
My lord,
This-
in submission, my lord. In the last occasion, I have filed a memo regarding to send back the trial court's records to enable the
In
respondent.
this matter, in 18.
Please, my lord. But in the
All of this, the registry is right to send back the TCR to the trial court and once amount is received, that should be sent back to this court. Yes.
Please.
I think 18.1. list this matter, admit, it's already in for final hearing.
Yes, my lord.
Yes, list in the month of November.
Please.
It's next 19.
Till number 19.
And after next week, Malata.
After a week, Manoj. I have not yet filed my wakalat.
In the month of November. It's 20.
Till number 20.
Well, seal number 20, I appear for appellant in 20.1, my lord.
Yes. Insurance
Well,
companies.
it's
Insurance companies on what ground?
The policy was cancelled because of dishonor of check. Notice was also issued. The trial court.
Whether it is, whether the said note, have you filed the acknowledgement?
Yes, subsequent.
When is the notice?
The insured obtains another policy, that is also produced.
No. Notice is issued.
Sure, that is why it said, he comes, takes a policy, another policy from the very appellant itself. That policy is also produced to show that he had the knowledge about the dishonor. The tribunal says that.
No, when he has taken another policy, why is he relying on the old policy?
I don't know. That probably the effect of the policy, date of issue. He has obtained it subsequent.
Have the dates clear.
Yes,
please tell the dates.
Yes, ma'am.
No record?
No.
It must have been, it's in final hearing. Yes. Date of accident?
18/7.
18/7
is the date of accident. Policy was cancelled.
18/7/20?
2018.
2018.
Yes.
When was the check issued?
The policy was cancelled on 23/4/2018.
Policy cancelled on?
23/4/2018.
Now, when was, as that policy is effective from which date to which date?
I produced it. It is obtained on it after the accident. This next policy is, he comes to the, after the accident.
I'm talking about the first cancelled one.
Policy was valid from, the validity was from.
You didn't vote out. That's what I said. October also no date. Everything no dates. October. Don't do it. Give the TCR.
My lord, may I submit, my lord?
Yes.
My lord, the cancellation notice was duly not served upon on the owners, my lord.
Let me look at the papers.
Yes, please, my lord. My lord, internal page 17 of the judgment, my lord.
It was from 31/3/2018 to 33/2019.
Internal page 17, it is mentioned, my lord.
I tendered the evidence of the RW1. It contains the details.
Why it says period of insurance?
Yes,
from 31/3/2018
to 33/2019.
18.
19.
No, it is shown as 18.
I'm sorry, my affidavit is very clear. 19 it shows.
Where do you get the date? This is
My lord, this is the first policy which was cancelled on, my lord, 5/4 we came to,
1 minute, let me check.
and 23/4/2018, my lord, notice was sent to the insurer, cancelling the policy.
1 minute. Check is dated 28/3/2018 is the check.
Yes. It was dishonored on 5/4/2000.
1 minute, let me complete this and then
Please,
I'll
please, my lord, I'm sorry.
28/3/2018. $42,714. It was dishonored on 4/4.
Yes.
2018.
Yes. And the endorsement was given on 5/4. On 23/4, my lord, letter was sent to the.
Your notice is dated
Yes.
23/4/2018.
Yes.
Where is acknowledgement?
My lord, receipt is produced.
Receipt is not, it has to be acknowledgement that it is served.
My lord, that is why, my lord, the General Clauses Act very clearly says, for service, my lord, to be held sufficient, what is required is, my lord, properly addressed, duly stamped and posted. In addition to that, my lord, in this
Supreme
case,
Court says otherwise.
my lord, in
But the
this
Supreme
case,
Court said otherwise.
yes, ma'am. In this case, my lord, I'll come to that. Supreme Court is the decision only. In this case, my lord, subsequently the insured comes and obtains a policy also.
That will go,
My
that
lord,
will go
what is it?
later.
Yes.
So first point that is clear is mute it wherever the sound is coming from. Now, as far as you also agree that there is no acknowledgement. We'll go to the next document.
Yes.
Acknowledgement is not there. Next, where is the next one policy?
My lord, he exhibit on. He is obtained it on 9.
It is from next one is
Yes.
from 27/2018
Yes.
to 19/7/2019.
Yes.
Now, date of accident is 18/7/2018. He has taken it on 27/2018.
Yes. My lord, the Supreme Court says, my lord, it's a contract, my lord. Insurance is a contract. My lord, if without consideration, my lord, in one of the judgments, I shall cite it, my lord, Supreme Court says, it is a contract vide ab initio. And the very, my lord, the moment the consideration is not there, my lord, the policy is issued subject to the realization of the very policy is subject to realization of funds. My lord, what is required, as my lord said, is whether it is brought to the knowledge of the insured or not. Now, my lord, there is sufficient material to indicate. My lord, the insured doesn't come forward and obtain a, my lord.
Oh, even your submission is taken. It shows 27/2014. Accident is much prior to that. As on the date of the accident, whether he is aware of it or not is a question. That's the question.
Yes, that is why I said, my lord, what is required is a properly addressed and posted is, that is the, my lord, you taken also, my lord, there is one judgment which probably I could not bring that because there was a policy obtained subsequently. I thought I would be able to convince. My lord, may kindly call it next
There is a
week.
judgment. I
I'll
have a
produce
judgment.
that. I'll produce that.
I have a judgment of the Supreme Court saying that unless and until that is communicated to the owner, it doesn't amount to
Yes,
cancellation.
that there is no dispute.
In this case, no acknowledgement. Acknowledgement only shows it is received by the owner. That is not there. Now, this document which you are saying, I can understand if it is much prior to the accident, if they have taken the policy, then what arguments you are submitting, that can be considered.
I got it. I only, my lord, may kindly be called next week. I'll make one more attempt I remember, my lord, there is a judgment where
Hello.
General Clauses Act, my lord, referred to.
Madam
I will try to
Sushmita,
raise that on.
there is disturbance from your office, please.
The judgment is there. Ask Akshita to find out. We only passed several orders. The, if the, with regard to the, this premium amount, if the check is false, if the same is not in the knowledge of the owner of the vehicle and no acknowledgement is filed in that regard, then it doesn't amount to the liability of the insurance company is not taken. This one? Oriental Insurance Company Limited versus Indrajit Kaur. Oriental Insurance Company Limited versus Indrajit Kaur. Reported in Laws SC 1997 1242.
There
As
is
per
also,
that, the Supreme
yeah,
Court said
my
you are
lord,
liable.
I'll refer to, I'll examine that also.
Keep this
There is
judgment.
one more judgment also.
This is matter tomorrow for judgment.
My lord, may sometime day after tomorrow.
No, I have already heard. I have spent enough time.
My lord,
Again, I have to
I'm only
recapitulate
seeking
everything.
one more day accommodation.
This is a matter on Thursday.
Please.
Much obliged. Much obliged.
Cell number 21, Shantraj K.
No representation list in the month of January. It's
Cell
22.
number 22,
This so
G. Lakshmi Rao.
no representation for the appellant. Same, this also listed in the month of January. It's
Cell
23.
number 23,
Lord, I appear for respondent number 2, my lord.
Nar.
Also for the
This matter, the same matter as the earlier matter, the premium check was bounced much prior to the accident, and also policy is cancelled much prior. And acknowledgement also I provided. Exhibit R1, R2, R34.
Why? Huh? This is matter for judgment on Thursday along with the other matter.
Yes.
Make some research.
For
My lord,
judgment.
if there is any room for settlement, the parties may be relegated to mediation center, my lord.
This is the owner.
Yeah,
This
they
is the
are.
owner of the vehicle. Owner of the vehicle. He also proposed me pay some amount, not the exact amount, award amount. I will also
Lord,
verify.
Both the parties appear before the mediation center.
Yeah, but
On,
Please, my lord.
before the Bangalore Mediation Center on 23rd September. That is the one.
In High Court they are doing.
High Court Mediation Center
Particular date may be given.
on
23-9.
22nd September.
Obliged, my lord.
Yes, next.
List number 3,
Yes,
Cell number
may I seek
1.
one indulgence, minutes? May I seek minutes one indulgence? It's list number 2, serial number 4. It's I appear for the appellant. But your lordships have ordered for release of the amount, minutes. I have challenged the liability, minutes, in that appeal.
True, then when we.
I'm
when
sorry,
there is
minutes.
no
I was on the legs, minutes. I'm sorry, minutes. I could not be present.
I've recorded that also because no representation. I've ordered.
Minutes. I'm sorry, minutes. I was there, minutes, in the other court.
List is 4 and that order list is on Thursday.
Number 4.
Yes, next.
List number 3, Cell number 1.
I am for the petitioner, my lordship.
For the respondent, ma'am.
Yes, why is it adjourned?
Yes, because that maintenance is already awarded in OS. So to clarify, for clarification, that day this court has adjourned the matter, my lordship. It's already awarded in OS in RFN.
How much is awarded?
15,000 for the wife and 10,000 for the daughter.
Half of the share of property has been also awarded by the trial court.
Then how many times you require maintenance?
No, much. What happened is in OS suit 21 of 2019, they awarded the maintenance parts, and the husband has appealed, and before this Honorable Court, the stay has been granted, my lordship. And noting that there is an maintenance passed in OS, this 125 proceedings has been dismissed, my lordship. That's why, and OS.
That's right. How many times you require? In how many proceedings you want maintenance? 25,000 maintenance is not sufficient.
That was not attained finality, my lordship. That's why I preferred an RPFC.
My lord,
when you're receiving already the amount, the court was right. It has attained penalty.
Now, at the time of the preferring
That's why
RPFC.
we'll record this. We will record this. Please come. The present RPFC is filed, agreed with orders passed in criminal miscellaneous number 11 of 2019, dated 1st March 2023, whereby the court had granted maintenance, had dismissed the application, dismissed the petition filed by the wife and the child seeking maintenance. The court has observed that already the maintenance rupees 20,000 per month is awarded. 1/4 shared in the, you are saying 25. Court says 20.
No, it's now RPA has been filed by
20,000 per month is awarded, and 1/4 share in the said property has been allotted to the son.
Half of the share of the
husband.
The number 2 is who?
Daughter, ma'am.
So is allotted to the daughter.
Daughter.
Hence, they are not entitled for maintenance. Agreed thereby, the petitioner, the agreed thereby, the wife is before this court. Then counsel appearing for the wife submits that as the order passed in OS number is appealed by filing MFA number RFA number 1003 of 2022. The petitioner has filed has initiated the 125 proceedings. Then counsel appearing for the respondent had placed before this court the order that is passed in RFA number 1003 of 2022, dated 5th June 2024, whereby the court has affirmed the judgment and decree passed in OS number 21 of 2019. And where do you get this 25,000?
My lord?
25,000.
Not 25.
20 only.
20
Is affirmed in the light of the fact that already the court has granted 20,000 as maintenance, and the wife and the children, wife and the daughter is getting, and also the property share in the property is awarded. She is not entitled for maintenance in this 125 CRPC proceedings. This court finds that this court is of the view that the court had rightly considered and passed orders, and hence nothing survives for consideration in the as rightly ordered, and this court finds no reasons to interfere with the well-considered order. Dismissed.
Much obliged.
Sale number 2.
Yes.
Mr. Hanmantayappa K.
I'm for the respondent in this case, too much.
Appeared for the, sorry, my lord, last.
Yes. Please argue.
I could not be present. I was held up. My lord, this petition is filed by husband, my lord. Husband's petition challenging the.
They're not able to see.
Challenging the order of maintenance granted by the family court Chikbalapur. My lord, the.
How much is awarded?
4,000.
2,000 and
2,000 is for the fine.
2,000 cost.
Yes, ma'am.
Then what is your income?
My lord, I could not able to contest the petition. My lord, just in 19 days time, the family court has disposed of the petition. My lord, I will read to your lordship kindly.
No, even if you contest, there cannot be a lesser amount than 4,000.
No, first, my lord, in 2016, she had filed a petition before another court seeking maintenance under section 125 for herself under a minor child. When I raised an objection that the child was not petitioner's child, she abandoned, and in the year 2018, that petition was dismissed.
And after 5 years, my lord, she files another petition before the family court in Chikballapur without disclosing the factum of previous dismissal of the case. And this time she files a case only in her name without mentioning the child and as such. Kindly only grant for 2 minutes, my lord.
No, assuming that that is what is done, is she not entitled for maintenance?
She is entitled, madam. No, my respectful submission to your lordship, please. My lord, it is an order passed without hearing the petitioner. Here an opportunity may kindly be given.
That's not,
I may be put on terms, madam.
No, not terms. What I'm saying is 4,000 is a maintenance, interim maintenance. It's a RPSC. It's 4,000 is a maintenance that is granted. Could it be a lesser amount than that? For that you can tell this court what is your income.
Lord, only one revenue record RTC has been produced by her, which stands in the name of the petitioner.
What do you do?
Agriculture.
Huh? Agriculture. What is your income?
Lord, I could not produce any source of income before the family court because without giving an opportunity to face me ex parte
No,
on
let's
day-to-day
not,
basis,
let us
an order
not,
has been
let
passed.
us not remand this matter where only 4,000 is maintenance is granted.
My lord, true,
Please
my lord.
file whatever you want to file before this court. We will decide. Please come.
My lords,
The
one humble
petitioner
submission is
shall-
my lords.
Huh?
One humble submission in this case, my lords. As the petitioner has filed, he has married for the second marriage, my lords, where he has got 2 children in that case also. In that, the trial court has already taken into the considerations of that aspect, and it has been allotted, my lords. And the 4,000 is a nominal amount, my lords.
That's what his contention is, that he is not given an opportunity.
Please, my lords.
The land counsel, the petitioner submits that no opportunity is given by the court to file the necessary documents. This court has perused the order. The maintenance amount that is awarded is 4,000. Hence, this court is not inclined to remand the matter. Whatever are the documents in support of his statement of assets and liabilities the petitioner is relying shall be placed before this court. List this matter in the month of October. Yes.
My lord, this arrest warrant has been issued. Kindly stay further proceedings in the execution.
4,000 will not.
No, at least you let me kindly make it 2,000. I will till the next date of hearing.
Yes, next three.
For the respondent in this case, my lord.
Hearing on interlocutor application 3.
But I have filed an application to modify the order dated 23/7/2025, whereby this court had ordered.
You are for the petitioner or respondent?
Respondent in this case, my lord.
What is modification of the order?
My lord, my modification of the order is regarding I had made an application to withdraw the amount deposited, but the withdrawal was permitted to be made in favor of the respondent number 1. However, I am seeking modification in this. Yes, please.
IA number 2 of 25 is filed seeking modification of the order dated 13/10/2023. Then council submits that.
23/7/2025. Modification of the order dated 23/7/2025. They have also filed another application which is different. The petitioner has filed another application which is different.
Filed by respondent. Latest one. Dated
8/8/2025, my lord. I have filed the application on 8/8/2025. Sorry, 8/9/2025. Sorry, my lord. 8/9.
Yes.
Lord, may I? I'm appealing for the petition, my lords. I have yesterday only I have filed the NOC Wakalat in this case, my lords.
It's okay.
No.
Already there is an order
please,
passed
please,
by the
please.
court.
No.
Now we are only modifying whether it is respondent number 1 or 2. That's it.
No, please, man, I am not bothered. But in this case, I have also filed an application to modification, seeking the modification dated order dated 13/10/23, my lords. That was a.
We will not modify an order dated 13/10/23 now. We will decide the RPFC, let him withdraw the amount.
Please, my lords.
What is your IA? IA number?
My lord, IA number 1 of 2025.
Registry is directed to put up IA number 1 of 2000. IA 1 of 25 is withdrawal of the amount.
My lord, I have filed it yesterday.
Give that.
Withdrawal of amount is IA 1 of 2024, my lord.
All everything in one. IA number 1, modify IA number
24,
1
my lord.
withdrawal.
Of
How can it
24
be?
is withdrawal.
How can you seek two application, two reliefs in one application?
No, my
IA
lord,
number
IA 1
1
of 2024 is
to modify the order dated 23/7/2025 permitting the respondent number 1 to withdraw the deposited amount. It is stated that on 23/7/2025 this court passed an order allowing the respondent to withdraw the deposited amount. Allowed the respondent number 1 to deposit the amount. Who is respondent number 1? Who is respondent number 2?
respondent number 1 is the daughter, my lord. Respondent number 2 is the mother, my lord.
It is submitted that respondent number 2 is the mother and respondent number 1 is the daughter. Concerning the submission, the order dated 23/7/2025 is modified and the respondent mother is permitted to withdraw the amount. Yes, this is this matter in the month of December.
Case number 4.
Obliged.
Lords, my name may be shown in the first item. Lords.
What is your name?
Ranjit Chiprion, my lords.
When did you file wakalat?
Yesterday only, my lords.
So and so submits that they have filed wakalat. Registry is directed to show the name of the counsel. Yes, next.
Case number 4. Nandish Gowda.
Lord, the present petition filed for seeking modification of the order dated 10/12/2024 passed by the Family Court Shivamogga, my lord.
That's not called modification. You are questioning that order.
Please, my lord. Proceedings initiated under 125 of CRPC, my lord.
Where is impugned order?
In page number 20, my lord. Page number 35.
Court has granted 15,000 per
Please, my
month.
lord, for the petitioner number 2.
That's a daughter, son.
Lord. We have filed the application for seeking for both the petitioner number 1 and 2, my lord.
You want enhancement?
My
You
lord,
are for
it is,
whom? You are
petition
for the
number-
wife. Yes, notice to the respondent.
Please.
Yes, 5.
And also there is a delay of 72 days, my lord.
That now we can't condone after the parties.
Case number
come.
5.
Yes.
Case number 5. K. Srinivas.
Okay, for the appellant.
For
Petitioner
petitioner.
on behalf of Kelch Nosmalat. I have 2 days time, let's.
This is matter in the month of December. Yes, 6.
Case number 6.
No further adjournments will be
appeal for
granted on the next date of hearing.
I appear.
No, not for you. In the next matter, 6.
Lord, the wife has not been ordered even a single pay maintenance. Either there is no permanent alimony nor any maintenance has been ordered. Since because she has
So it is
sought,
only being adjourned at your request.
pardon, Lord?
It is only being adjourned at your request repeatedly.
Yes, no.
Yes, let's see.
In the year 2004, they got married. I am for the wife, my lord.
Mm.
Wife has presented this petition,
Mm.
challenging the order of
Come to the order. Page number.
order passed on application filed by her under section 125 CRPC. In page 44, Your Honor may kindly see, since because in a connected divorce proceeding initiated by her husband, she has demanded money, that is being taken as that woman is greedy and therefore no maintenance is awarded. That is the order. At page 44,
Respondent is the husband.
Respondent is there.
He has not let in evidence and has not produced any documents.
Yeah.
Please read from paragraph number 28.
Paragraph?
28.
Petitioner has stated that her general monthly expenses is around 20,000. It is stated that her qualification is graduation. Presently, she is taking tuition at home and getting 6 to 10,000 per month. And further, it is stated respondent has studied MSc.
Why a criminal miscellaneous 2013? When is the order passed?
2021, my lord.
Why it is pending for so many years?
I don't know, my lord. My colleague has filed this case.
They are living
Since,
separately from 2004.
Yes, my lord.
And how is she leading her life from 2004 till now?
And there was an interim order granted in the earlier, this one interim application. Even that interim application he has not obeyed, my lord. And finally, the order has come. He sought on two grounds, my lord. One ground is nullity of marriage. The other ground is cruelty. The nullity, the plea of nullity has been rejected by the court, and only cruelty appears to have been established. This court should have shown some wisdom in considering this petition, my lord. Almost petitioner as well as her sister's money was taken by him crookedly, and he has opened RD account joint name, and he has transferred his money, later taken his money back to purchase of a house property at Bengaluru. And he says before the court that there is transaction of 20 lakhs in her account, therefore she is satisfied with the income.
It is admitted that the sum of rupees 21 lakh 65,045 was deposited to her account from the account of her husband on different dates.
My lord, it is an accounts jugglery he has made. At the time of marriage, my lord, he took 5 lakhs from the petitioner's family and deposited as a joint account. Later withdrew the joint account, and then he put it into the site purchase advance with the BDA from that account. And later he sells the house of his mother at Mysuru, then transfers the said amount to this lady's account, then withdraws again. See, this account jugglery has been believed by the court.
In the pending MC, you have not filed any petition.
No, I did not. She has filed a dowry application, a dowry case also.
Not dowry case. In the pending MC, 24 application is
Pending
not filed.
MC, my colleague has not filed any other permanent alimony application or pendant late application. He has not filed. Hoping that the order will be granted in this petition, he has not moved. Nothing has been given. In fact, he has taken more than 10 lakhs since, because at the time of marriage, in demand of dowry, my lord, their parents sold a house and gave 5 lakhs to her. I have got a statement of account, my lord, how he has withdrawn from 2004 to 2007. This was produced before the court.
Yes, this is matter as part heard on 18th September.
Cell number 7. Tumgi for petitioner.
In this matter, I have filed, my lord, the assets and liability as per the direction of this honorable court. In fact, my lord,
We'll see some other day. This is a matter on 23rd.
Cell number 8,
My lord,
Rajesh Gowda.
the wife has filed to prove
BN
she is
Suresh.
living with the pen till 2019 and also filed to prove that, my lord, the husband has been neglected him.
This is on 24th of October.
And she deserted.
What it is awarded is only 3,000 rupees. My lord.
But she is not willing to come. My lord. And the device has been granted.
It was subjected to
24
harassment.
24th.
Intermodal may be extended.
Intermodal granted is extended. 9.
Cell
Till
number
further
9,
address.
Jayana.
Further address. Intermodal.
Huh?
Till further address.
No, 24th I'll dispose of. Yes, next.
Cell number 9,
1,000 what it is granted. My lord. And
Nine.
that also they are bargaining.
Serial number 9, I have submitted a DD of rupees 45,000. I'm filing memo also, as well as calculation.
Take that.
Request time for further payment, please. Kindly posted on
Given
next
the
2
DD,
months.
45,000.
then counsel for the respondent submits that an amount of rupees 45,000.
Please.
For an amount of rupees 45,000, a DD is
In favor
handed
of
over.
wife.
Handed over to the counsel for the wife.
Please. Today it's
To you only they have handed over.
Please, ma'am.
DD is handed over to the counsel for the.
Did it done in favor of
That's
petitioner?
not, that's not, so much of details are not required.
Please.
To the counsel appearing for the wife. And he has also filed the memo of calculation. The same is taken on record. This matter in the month of November.
My lord, because balance is there. They
He
will
will pay
pay.
it,
Another 2 weeks they will pay.
not 2 weeks, maybe, because he is only
Yes,
an
next
employee in
matter.
postal
Or-
department.
10.
In the month of November, it may kindly
10.
posted.
It will come. Yes, next
number
10.
10,
I'm
Cell number
appearing for the
10,
petitioner in this case, my lords.
Yes.
The
My lord,
present case is filed.
Yes.
The present case is filed by the petitioner seeking stay on the orders passed by the family court in the criminal miscellaneous. number
Please come to the
247.
order. What is the order?
The order
Maintenance
is
of
was ordered them in page
6
number
plus 3,
30, my lord.
6 plus 3, 9,000 is granted.
Yes, my lords, they have granted the same maintenance from the date of petition, my lords. The petitioner's salary is only of rupees 28,000. From the date of petition, it will come around 2,25,000. The petitioner also has a huge amount of loan taken for.
At best, we can grant you time for paying the arrears, sir. But this
My lords,
amount.
stay may be granted on the arrears, my lords, from the date of
No, no,
petition.
no, no. Stay may be granted, stay will be granted on the condition that you will pay it in 10 weeks.
In 10 weeks, my lords. Please, my lords.
Then counsel for the petitioner submits that the court has granted maintenance of 6,000 from the date of petition until she remarries. It is submitted that paying the arrears is very difficult for the petitioner. Considering the same, there shall be stay of all further proceedings as far as payment of arrears are concerned, on the condition that the arrears at 6,000 will be paid paid within 10 weeks from the date of receipt of the copy of the order. Notice to the respondents.
cell number 11, final hearing,
Petitioner, my lords. My lords, in this case, as per your lordship's instruction, I had filed the affidavit in the previous date of hearing, my lord. Your lordship had in fact instructed me to file an affidavit to the extent that what was his previous job, what was his salary drawn. I have filed to that extent.
Will take it.
My lords, may I request the matter be taken in the list 1, my lord, because stay has not been granted and the trial court is.
This matter, the other day, what to do is RPFC in tomorrow's list, in the first list will take up. RPFC first list, WP second list, MFA third list from tomorrow. Yes. Huh? Please use the mic. I don't even hear. Even this much.
As per the order of the trial court, my lord, the kindly see, my lord, the order, my lord, 1 lakh rupees.
I'm hearing the matter. No, I'm not hearing.
No, my lord, what happened? Say, second instrument fees has been, my lord, examination is there.
We will see. Yes, yes.
The matter may posted for admission, my lord. This is not yet admitted, my lord.
Delete from final hearing. List this matter. Delete from final hearing. List this matter for admission. Automatically it will come in the top.
Please.
Yes. Any signatures?
so, cell number 25-9.
Court of sir. Court of sir.
Sir, ಹೇಳಿ sir.
Madam, last ಇದು serial number 11 date ಕೊಟ್ರ madam list 3 ಇದು ಈಗ.
Third list, sir.
Third list 11 ಈಗ last case call ಆಯ್ತಲ್ಲ madam.
25/9, sir.
25. Okay madam, thank you.
Non-compliance ಇದ್ರೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕಂಪ್ಲೈಯಬಲ್ ಇದ್ರೆ ಲಿಸ್ಟ್ ಮಾಡಂಗಿಲ್ಲ ಅಂತ ಡೈರೆಕ್ಷನ್ ಇದೆಯಲ್ವಾ ಯಾಕೆ ನನಗೆ ತೋರಿಸ್ತೀರಾ ಇದ್ರೆ when standard direction is there from the court itself, why are you asking me? Advocates ಎಲ್ಲ ಹೇಳ್ದಂಗೆಲ್ಲ ನಾವು ಫಾಲೋ ಮಾಡಕ್ಕಾಗಲ್ಲ. ವಾಟ್ ಅವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಈಸ್ ಡೈರೆಕ್ಟೆಡ್ ದಟ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಶುಡ್ ಬಿ ಫಾಲೋಡ್ ಅಷ್ಟೇ. ಸರಿ ತಗೊಂಡ್ ಬನ್ನಿ ನೋಡ್ತೀನಿ ಅದ್ರ ಕಂಪೇರಬಲ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದ್ರೆ ಲಿಸ್ಟ್ ಮಾಡಂಗಿಲ್ಲ.